Good morning. Today is Wednesday, May 4th. This is the time and place for the regularly scheduled Nevada Gaming Control Board meeting for the month of May. Madam Secretary, has our agenda been posted in accordance with the open meeting law?
Yes, it has.
Today, we'll be covering all items noticed on our agenda. Madam Secretary, let's proceed with public comment, please.
This item is placed on the agenda to give the public an opportunity to comment on gaming-related matters.
Anyone wishing to make a public comment, please step forward and state your name for the record and make your comment. We'll hold comments to 3 minutes apiece, please.
Good morning. Yo, Leticia Luis, trabajé en el Boulder Station durante 26 años. Siempre fui responsable en mi trabajo.
I, Leticia Luis, worked at Boulder Station for 26 years. I was always responsible in my work.
Trabajé como cocinera durante ese tiempo. Vi todas las injusticias en el trabajo.
I worked as a cook, and during that time saw all the injustices work.
Decidí ponerme el botón como representante del sindicato. Después de eso, hubo un cambio muy grande en el que siempre me presionaban más porque no quieren que entre el sindicato de trabajadores.
I decided to put on the button as a representative of the union. After that, there was a very big change in which there was always more pressure on me because they do not want the unions to enter.
Ahora con la pandemia no nos devolvieron el trabajo. Le dieron el trabajo con menos antigüedad a personas y también contrataron a gente nueva.
Now with the pandemic, they didn't give us our jobs back. They gave jobs to people with less seniority, and they also hire new people.
Yo también soy ser humano. Necesito que me devuelvan al trabajo y seguiré luchando hasta que cumplan.
I'm also a human being. I need them to return me to work, and I will continue fighting until they comply.
Me siento deprimida, estresada, tengo gastos, no vivo del gobierno, tampoco tengo quien me ayude, porque por eso quiero justicia. Tengo que seguir luchando para recuperar mi trabajo.
I feel depressed, stressed. I have expenses. I don't live off the government. I don't have anyone to help me either. That's why I want justice. I have to continue fighting to get my job back.
Thank you.
Thank you. Okay, is there anyone else who'd like to make a public comment? Please come forward and state your name for the record.
My name is Rodrigo Solano Quiroz. I work in for Station Casino 28 years. Then me lay off due to the COVID-19. Station Casino has called me back to work, and I have struggled because I have expenses, rent, and my wife sick. I went to union and the Boulder Station. We vote for union. Please help us. And thank you. Thanks. Thank you for listening.
Just for clarification, sir, you said you have been called back or you have not? You have not been called back?
Call it. I had 20 years and the guys take new people, like ladies say. And I waiting, and I looking for job. I got failure, side, and no call. Yeah, this triangle, and I'm distressed, too much stress, because my wife we have a bad situation, and this is very sick,
Sorry to hear about that. Thank you for your comments.
Thank you so
sir.
much. Okay, appreciate it.
Please, if you have a comment, please step forward and state your name for the record.
Good morning. My name is Ken Liu. I'm here representing the Culinary Union. I'm here to provide the board with an update on one of the cases against station casinos pending before the National Labor Relations Board. On April 12th, NLRB Administrative Law Judge Jeffrey D. Witkin issued a 138-page decision with proposed findings of facts and conclusions of law against station casinos. Judge Witkin's proposed remedy recommends that the NLRB order Red Rock Casino to recognize the Colony Bartenders Union and bargain in good faith. An important part of Judge Witkin's role in the case was to assess the credibility of witnesses who testified at trial, including several station casinos executives. The judge found some of these executives to be not credible or reliable, even though they were testifying under oath. the ability of a gaming license holder's executives to tell the truth certainly bears upon its suitability for licensing. Here are some quotes from the judge's decision. Footnote 11. However, as noted above, Chief Operating Officer Robert Finch was not a credible or reliable witness generally. Footnote 22. Again, I discredit this testimony, both because it is contrary to the record as a whole and because Finch's poor credibility generally. Footnote 24. I discredit Fortino's and Nelson's testimony to the extent it indicates otherwise. Fortino here refers to the company's Senior Vice President of Human Resources, Phil Fortino, and Nelson refers to Red Rock's General Manager, Scott Nelson. Footnote 25. Thus, I give no weight to either Finch or Fortino's testimony. Footnote 26. To the extent Nelson's other testimony conflicts with the above findings, it is discredited as contrary to the weight of the evidence. Footnote 108. Although Fortino testified that he was not aware of such news report, I discredit the testimony. Footnote 115. 04. Fortino, Finch, Welch, and Cudi also specifically refused to admit that there was any discussion at the meeting regarding the underlined and bolded red points in the health insurance and retirement proposals about incentivizing employees not to vote for the union and taking away union power. Further, none of the four appear to be credible or reliable witnesses on the subject generally. Here, Welch refers to Chief Legal Officer Jeffrey Welch, and Cudi is Chief Financial Officer Stephen Cudi. Footnote 126. However, I discredit this testimony. As noted above, Fortino and Finch were particularly poor witnesses. On page 63, quote, however, there are substantial reasons to question Welch's and Cudi's testimony regarding the overall increase in turnover from 2018 to 2019. As noted above in footnotes 11 and 115, both provided highly questionable, discredited testimony about other significant matters. Although station casinos will ask the NLRB to review the judge's decision, the agents will overturn his credibility findings only if the clear preponderance of evidence shows he was wrong. That is because he was the one who heard from these witnesses firsthand and is in the best position to assess their demeanor under oath. We wanted to provide you with this update today because we believe the reputation of the Nevada gaming industry is at stake here, as it is reflected poorly by the history of illegal behavior of station casinos. Thank you.
Thank you. Is there anyone else who would like to make a comment here in Las Vegas? So please step forward. Okay, seeing no one, Carson. Is there anyone in Carson City? I see no one. All right, Madam Secretary, that will close our public comment section. Let's go to the next item on our agenda, the approval of the prior month's disposition.
Pursuant to NRS 241.035, this item is the consideration of the approval of the Nevada Gaming Control Board disposition for April 2022.
Okay, we've each had an opportunity to review the disposition. Would either of my colleagues like to make a motion?
I'll make that motion, Chair.
Thank you.
I move for approval of Control Board disposition for April 2022.
Okay, Madam Secretary.
Member Katsaros.
Aye.
Member Watkins.
Aye.
Chair Gibson.
Aye. Thank you. All right, Madam Secretary, I believe that brings us to our non-restricted agenda. Let's start with item number 1, please.
Non-restricted number 1 are the applications of Excel Entertainment, Inc. for registration as a publicly traded corporation and for a finding of suitability as sole member and manager of Excel Entertainment LLC. You also have the applications of Excel Entertainment LLC for registration as an intermediary company and for an acquisition of control and for a finding of suitability as sole shareholder of Century Gaming, Inc. Next are the applications of Century Gaming, Inc. for a transfer of interest and the applications of Andrew Harry Rubenstein, Michael Joseph Marino, and Carl Ivor Peterson for a finding of suitability and or licensure as officers and or directors as noted on the agenda. Lastly, you have the request to withdraw the application of Kathleen Phillips, also as noted on the agenda.
Okay, thank you very much. All right, let's begin. Mr. Gimignani, would you like to step forward? State your name for the record, please.
Thank you, Madam Secretary, Member Watkins, Member Katsaros, Chair Gibson. For the record, I'm Greg Gimignani of the law firm of Dickens Wright on behalf of Excel Entertainment. With us today, I have Andy Rubenstein, President, CEO, and Director of Excel, Derek Harmer, General Counsel and Chief Compliance Officer of Excel, Matthew Ellis, Chief Financial Officer, Michael Marino, Chief Commercial Officers and CIO, and Carl Peterson, Chairman of the Board. Before moving forward, I'd like to take the opportunity to thank all of the Gaming Control Board personnel that worked on this matter, including Luke Rippey, Candace Nishizawa, Aubrey Wilson, Eric Kaufman, and Tina Logan. And this matter, was for this matter. I also need to thank Jeff Silver, who did most of the heavy lifting as outside counsel before his retirement earlier this year. We do have a presentation regarding the background of Excel and the transaction before you. And we have previously provided copies to the secretary. And we ask that this submission materials be treated as confidential. And with that, I'll ask Mr. Rubenstein to approach dais and to begin the presentation.
Okay, that's the way we'll proceed then. Please step forward, Mr. Rubenstein. And take us through your affirmative presentation, please.
Yes, good morning, Madam Secretary, members of the board. For the record, I am Andy Rubenstein, President and CEO of Excel Entertainment. Before moving forward, I would also like to thank all of the gaming board control agents that worked on our file. They were professional, persistent, most of all, very patient with us. I also would be remiss if I didn't also thank Jeffrey Silver for guiding us through this process up until his retirement. We are both proud and excited today to be before you to seeking licensure in Nevada. We could not be more thrilled with the opportunity to partner with the Century and the United Coin team, and we'll continue on to the presentation. As you look at the Excel at a glance slide number 3, we are the leading distributor gaming operator. As a public company in the United States, we're headquartered in Burr Ridge, Illinois. We install, maintain, operate video gaming terminals, ATMs, other amusement devices in authorized non-casino locations, such as restaurants, bars, taverns, convenience stores, liquor stores, truck stops, and grocery stores. We operate over 13,500 machines in over 2,500 locations in the state of Illinois. We have over 1,000 employees in the 3 states that we operate in. We are a very strong financial institution with a strong balance sheet, with low leverage. As of the end of 2021, we were at 1.0 net leverage. We hold licenses in Illinois, Pennsylvania, Georgia, South Dakota, and West Virginia. We are approved for licensure in Montana, subject to post-closing disclosures, and we are pending licensure in the state of Louisiana. Moving on, as you can see on slide 4, we've had consistent growth outside of obviously the pandemic year, or 2020, and we continue that growth as we move into 22. A company that is growing both employment and our revenue and the small businesses that we partner with. As you move forward to the executive management team, today you have myself, Derek Harmer, our general counsel, Matt Ellis, who is our chief financial officer, Michael Marino, who is both the CIO and chief commercial officer, and unable to be with us today, Mark Phelan, who is the chief revenue officer of the company. Our board of directors on slide, next slide, slide 6, is a diverse board of directors with diverse experience from both gaming and public company experience. As you can see, the list of different individuals, many of them have our public company board experience and have been involved in gaming for numerous years. Just to note, my brother was a founder of the company with me, and as well as Buzz Rodenberg was a founding board member. As the core of what our business is compliance. We have a commitment to compliance with every individual who works for Excel. Uh, as we start training on compliance from day one. We see ourselves as not just partners with the establishments that we place our equipment in, but partners with the regulatory authorities that we work with to maintain an industry that is trusted by not only the players, the establishments, but the public. We've had a compliance plan since we started gaming. We have required our employees up until recently to go above and beyond any licensure that was required by the state. And we have a audit committee, governance committee, compensation committees to continue to provide oversight. The raise your hand, see something, say something culture has been core to our operations from the beginning. We provide workplace and sexual harassment training for all individuals on an annual basis. And we do detailed background checks for any individual that is licensed. We have a whistleblower hotline. And in addition to that, we have 4 in-house attorneys that focus not just on legal, but compliance work.
If you would, sir, just to back up, you said you do extensive diligence on each individual who's licensed.
Yeah, so as they come in, we do a background check, like we run them through the
I
company.
understand what that means. I'm just asking you, it's only licensed.
Right, so the amusement division of our company does not handle any gaming equipment. They don't have any involvement with gaming, so they're not licensed individuals. If you look at slide number 8, our historical company timeline, we started the company nearly 13 years ago, and you can see as we've shown a continual ability to integrate and bring other companies into the Excel family. Many of our leaders today are from these companies that have joined Excel. And in the spring of 2019, we had the opportunity to investigate a public company opportunity with the TPG SPAC. And in November of 19, Excel became a public company. So looking at slide 9, we came into contact with Century and probably long before we really kind of had conversations with them about kind of joining the Excel family. But formally in 2020, we had real conversations, and we saw this as an exciting opportunity for both companies. And they provide a lot of proprietary technology, manufacturing platform that Excel doesn't have. They have a great management team. They run a very lean and streamlined operation. And this was an opportunity to really mix the best practices of both companies. And as we go forward, we believe that the combination of Excel's experience in Illinois and other states with the Century, Grand Vision, United Coin experiences will make for a great combination. Looking at slide 10, you can see Century has their 3 different divisions of the operation in Montana, the one here in Nevada, and the manufacturing. We're excited to embrace all of them. As you're probably well familiar, here in Nevada, the Grand Vision United Coin business has been very successful. It has had a long history here, and we're looking forward to bringing some of our expertise with their skills in working with equipment, working with systems, and the local Nevada customers. I'm going to invite Matt Ellis, our Chief Financial Officer, to kind of walk you through the transaction and our balance sheet.
Please. Okay. Please state your name for the record, Mr. Wood.
Good morning, Madam Secretary, Mr. Chairman, members of the board. For the record, my name is Matthew Ellis, Chief Financial Officer of Excel Entertainment. On slide 12, we've laid out the anticipated purchase price of Century. That's composed of $5 million of Excel shares in Excel common stock. In addition, we anticipate making a cash payment of $160 million. 150 of that is the negotiated purchase price. 10 million of that is based on the current trends in net working capital. Century's actual net working capital should be approximately $10 million higher than what was negotiated. To fund the cash purchase, we anticipate drawing $100 million from our delayed draw term loan, of which we have $400 million available, and $60 million from our revolving credit facility, for which we have $150 million available. As noted on the slide, the senior management of Century will continue to operate the business. Steve Arnsten, CEO, Heidi Schmeltz, CFO, Merle Frank, Managing Director at Grand Vision Gaming, Tim Cogswell, VP and General Manager, as well as Debbie Cornine, Director of Regulatory Compliance. Moving on to the next page, you can see Excel Entertainment's balance sheet as of December 31st, 2020 and December 31st, 2021. You can see the company's in a pretty strong financial position. And as I noted earlier, we do have the ample capacity. And as Mr. Rubenstein noted, we have low leverage to add Century to the Excel family. The next slide shows a snapshot of our org chart, which shows the anticipated purchase. Excel Entertainment Inc. at the top is the publicly traded company. Excel Entertainment LLC is a wholly owned subsidiary. Our credit facility is between that, and Excel Entertainment LLC will be purchasing 100% of the equity interest in Century Gaming Inc., and as well as the two wholly owned subsidiaries, United Coin Machine Company and Grand Vision Gaming LLC. Thank you.
Thanks.
Thank you.
So kind of concluding the conversation and the presentation, the combination of the two companies is a win for both of us. It's a natural extension of both of our businesses. Two companies have very similar cultures and values. We've spent a couple of years kind of vetting each other out and have had multiple visits back and forth between markets. Both companies value the relationships that we have with our customers, and the leadership teams are looking forward to growing together. Their technology, Excel's business strategies, and our strong balance sheet and access to capital will allow for the combination to continue to grow. So thank you for allowing me to present today. Any questions that I can answer, I'm here to be helpful.
Okay, thank you very much. Mr. Gimignani, is there anything further you'd like to present as part of your affirmative presentation?
No, what we've done is we've actually brought the experts in each area of the company here with us today to answer any questions or concerns that you may have. I know this was an extensive investigation.
It was.
This is a relatively new but very complex company that's grown rapidly and has reacted and adjusted as it's grown, and will do so again. As you note in the presentation, that the current makeup of the compliance committee will change upon approval from Nevada to add an independent compliance committee member to comply with Nevada's requirements for a compliance committee. But we thought it best to address the concerns you have in the interest of
I
time.
appreciate it. Thank you very much. It was a good affirmative presentation. Thank you for that, Mr. Rubenstein. Okay, I anticipate my colleagues and I will have a number of questions. We do extensive background checks, as you know, probably very different than what you've experienced thus far. So let's jump into it. I'll open it to my colleagues, and let's start the question.
All right, Mr. Rubenstein, there is an interesting story I hear about how Excel ended up going public. Would you like to share it?
Sure, be happy to share it. So my father is an an M&A attorney, he's now retired, and has taken many companies public. And I kind of vowed that we would always be a private company. There was really no interest ever to become public. And my brother works for a firm called Rain. It's a private equity venture capital firm. And through his wife, my sister-in-law, and a friend of hers, both their daughters attend a school in San Francisco, and both families, the two mothers were discussing spring break activities, and the two mothers thought it would be great to get the families together because they both were going skiing in Colorado. My brother was kind of resistant. He didn't really know the other family. This is our family vacation, but he kind of agreed. And over kind of lunch one day, the two families getting together, my brother and Mr. Peterson started having a conversation about what do you do? What do you do? And Carl was looking for an opportunity for his SPAC to find a company to bring public. And my brother has a portfolio of investments that he has with Rain, and they kind of circulated through them. And then my brother's like, well, what about my brother Andy's company? And Carl's like, well, I have experience with the Caesars board and being involved with Caesars with TPG. Gaming's very interesting. Let's give him a call. And they called me from the ski slopes and at lunchtime, and I thought it was another one of these kind of goose chases, and I was like, yeah, you guys talk about it. If there's real interest, I'll listen, but I really don't have any interest in taking the company public. And they called me back the next day, and Carl was very interested. And I said, yeah, okay, why don't you come visit our company, do your homework. In Illinois, all the information is publicly available on revenue and performance of businesses. So they can look up what we do, how the business operates. And sure enough, they said, well, we'll be out there. I'll call you back tomorrow. Can we come next week? And subsequently, Carl and some of his team came out to visit, and they said, we're very interested. And I said, well, make us an offer. I said, there's some of the things that we would like. And one is that we'd be able to maintain the culture that we've had, the same people in management. The company was a lot of friends and family were involved in investment and in helping grow the company. And our company is a series of many, many family businesses that have been combined. We want to keep that culture. And Carl was agreeable, and he proposed a price that I thought was acceptable. And one of the conditions was nobody was required to sell any of their stock. They wanted to, they could sell, but if not, they can continue on as the public company. And sure enough, in the course of about 6 months, we became a public company in November of 2019. Totally accidental, never intended. And it's been a great experience, really has. We wouldn't be here today if we hadn't become a public company.
So we have extensive testimony from you. So in your statement where you say that it's accidental, company went public, that's what you.
Yeah, it was no intention. We weren't looking. It was just the fact that there was a plan for spring break, and everything kind of
Working
happened.
on vacation.
Yeah, and it worked for everyone. So yeah, we're thrilled with what the experience has been for the last couple of years. The SEC is a very good guidance in terms of for financial reporting and understanding of our business in a different way than we had looked at it before. All the regulatory authorities that we've worked with have embraced the public company entity because we are a very unique kind of type of business to be public in, and it works.
And in that transaction, the agreement was that the management structure would remain the same, and that's true for this transaction as well.
Yeah, that'll be the same. And then part of, as we have done kind of mergers or we have business combinations, one of our core philosophies is define management and leadership that embraces similar culture. And you can look at the Excel kind of leadership team, the first 50 people in the company, and most of them are from business combinations because we believe in kind of keeping the people who lead the companies prior and understand what's important. And we're very selective on who we do business with.
Okay, thank you.
In this vein, in the same vein, if we can discuss the Clairvest investment.
Mhm.
When did they originally invest in?
So Clairvest again was something that we weren't really looking for. And Clairvest did not invest any dollars into the company. So what happened was we happened to be at a conference, met an individual from Clairvest, and he expressed interest in kind of purchasing an ownership interest into Excel. No control, just an ownership interest. And at that point, it'd been 5+ years since a lot of our original investors had invested in Excel, and we hadn't returned any capital to them. So what we structured, the way we structured it was it would be a shareholder to shareholder transaction. They would tender kind of the price that they would be willing to pay, and our shareholders individually had the ability to decide to sell all of their shares or zero, whatever they wanted, directly to Clairvest. No money ever came into the company. It all went directly between Clairvest and the shareholders. And I think Clairvest bought around 28% of the outstanding shares at that time.
What rights did Clairvest have according to the shareholder agreement at that point?
I don't have all the details on the rights, but like typical investment rights that would come with that type of investment. I just don't know all of them. And I think we can provide you the detailed documentation of the transaction if you haven't had it already.
Thank you. Good morning.
Yeah.
I wanted to follow up on a few things from your presentation here. You mentioned the states that you're currently licensed in. And you also mentioned that there's only 3 states right now that you're operating in.
Yes.
Is that correct? Okay,
Mhm.
so that's Illinois, that's Georgia. What was the third?
And Pennsylvania.
And Pennsylvania is live now.
If it's not live, it's weeks. I mean,
Okay, fair enough.
we have the equipment that's sitting in our warehouse. There's one location that's going live. It is not a significant operation,
Okay,
but we've been licensed for multiple years. with the state
understood.
of
Our
Pennsylvania.
material said that you were, it was pending, was
Yes.
soon, imminent.
Yeah.
There was another state that you didn't mention in your opening, which was in our materials, and I want to understand if it's accurate or not, Iowa as well.
So Iowa is not a, we are in Iowa. We operate a very small amusement type business. It is not a gaming regulated business. It is amusement business with amusement devices. We do operate there. We are licensed. It's not really the licensing that you guys perceive, but we are licensed and we have the permits to operate in Iowa and about, call it 80 to 100 establishments,
Why did you leave that off the list then?
because it's not gaming.
So is there any other states that's not gaming that you're operating in?
I don't believe, is there any other? No, I don't believe so.
When you say game, because we're talking about
Like
it's
regulated,
all nomenclature in the end, right? You've got nudge machines, you got amusement machines, you got coin operated amusement machines, you've got all these street machines. There's all different terms.
Right.
So you're saying in Iowa, you're differentiating that type of machine versus say the Georgia type of machine.
yeah, because there's a gaming regulatory body in the state of Iowa that you have to be licensed. We are not licensed. We are licensed under, was it the department? Which department?
It's the social and charitable gaming.
Yeah, please.
Yeah, come on. This Derek's the general counsel and chief compliance
And
officer.
for the record, I'm Derek Harmer, General Counsel and Chief Compliance Officer.
And if I could just, so as former chief of the gaming division, you were in that division, right? AG's office here?
I was, yes, sir.
Yes,
I was.
welcome back.
Thank you very much. It's very different sitting in this space than that space.
You just woke them up.
That's right. Very good, very good. So in Iowa, we're registered with the Social and Charitable Gaming Division of what is oddly known as the Iowa Court of Appeals. The Iowa Court of Appeals is sort of the oversight body, and then underneath it is the Social and Charitable Gaming registration. So The distinction for us is that it's not an actual gaming license as much as it's a registration to operate amusement and skill games in that jurisdiction.
The business model is still the same though, where you're placing machines in locations that you don't own, or are you owning these locations there?
We do not own the locations. We're placing machines similar to our other markets. We're
Right.
not the owner of the establishment. We are the provider of the terminal operator.
What's the distinction with the machine then in Iowa versus say, the Georgia machines, or, well, let's stick with that one. Yeah.
Yeah, I think in Iowa, the Iowa machines are slightly different than the COAM machines in Georgia. The Georgia machines are built a little bit differently, and they sort of roll up to the Georgia Lottery Commission, and it's more of a lottery style device versus the amusement machines in Iowa are more sort of skill based. I would say it's sort of a earlier generation of what those machines look like.
Well, in Georgia, they're all connected to a central network. They got a limited number of
Correct.
machines there. You've got to have, I think they even
Correct.
call it skill based, where you have to touch to reveal the result. I know that's part of the lottery there, but if we look at Iowa, same thing, just not a central network, same type of reel spinning looking type of device where I'm touching the screen in order to reveal my result.
Correct.
Okay.
Correct.
It
In
doesn't
Georgia,
have the reveal, but yeah.
yeah, that's what I'm saying. It's a previous version of that reveal sort of technology,
Sure.
which is why it's older and not on a central system.
Uh-huh.
And also in Georgia, we have a master license as a COAM operator versus they're just not structured that way in Iowa. It's just you file for registration. It's a 1 or 2 page document, and then you are able to operate the machines.
But it sounds like if the machines that you had in Iowa were placed here, you will be required to be licensed here.
Yeah, but you would never have those, like those
Yeah.
machines wouldn't be able to be licensed here.
They wouldn't compete
They're
with.
not compliant at all.
Yeah, they wouldn't compete with a VGM machine
There's
here.
no, yeah, because
It's
they're
two
not, they're
different
not on a
markets.
central system. There's no visibility. It's a lot of other issues.
But very, very similar though.
Yeah, I mean, it's a game of chance or skill, depending how the game plays.
Okay.
Okay, so again, to clarify, because that was one that kind of jumped out at me, because in understanding the landscape of the US here, is there any other states that you're operating in that you didn't just mention or license? So we got Illinois, Pennsylvania, Georgia, South Dakota, West Virginia, Iowa, Louisiana, and Louisiana and Montana are pending because of this transaction. Any others?
That's right. No, there aren't any others.
Okay.
And we constantly are looking at other opportunities in other states.
Okay. Yeah, because I just wanted to understand the distinction there in the marketplace, because I didn't have a lot of familiarity with those. So
Sure.
uh,
Neither did we, Member Conceros. And so we actually had a law firm do a white paper for us on the legitimacy of that marketplace to make sure that we were going into a market that would be up to our compliance standards and also that was regulated and in some fashion. It wasn't just a illegitimate sort of gray market that we'd be taking ourselves into. So we felt very comfortable after vetting it with our compliance committee, vetting with our full board, that this was a market that would be suitable for us to be in.
So as part of Mr. Rubenstein's opening, my second point was the compliance plan, because he mentioned you've had a compliance plan since 2012. You weren't required. Nevertheless, you had one. But I did want to talk about that, in particular, the due diligence piece with going into new markets.
Sure.
And the contents of that compliance plan. What does it actually cover? Does it have provisions in there for looking at what?
So our compliance plan was sort of a base shell compliance plan we put together when we formed the business back in 2012. We went live in 2012. And when I came out of the company, I met with outside gaming counsel. I said, I would like us to have a compliance plan as the chief compliance officer to give us a roadmap for how we're going to conduct ourselves internally and as we go outside of our borders. And so in there, the material transactions are reviewed. Diligence is done on new markets. There's political contributions that are reviewed. There's sort of your standard highlights for a compliance plan that we borrowed from some of my experience here and also from gaming counsel's experience in that jurisdiction. So in fact, I think we provided a copy of it to the agents when they were there visiting us. So it's the standard fare, and we understand in talking to Deputy Chief Rippey and others that we are going to have to be a little more forward leaning in our diligence and compliance efforts going forward. We've sort of been more reactive to this are the things that we've done. We looked at our compliance plan, checked our boxes, and this is okay. Understand that we've got some room to grow in how we look at suitable associations, how we look at business transactions we're going to enter into, how we're going to look at new markets. And so being a public company has sort of helped us sort of jumpstart that a little bit and understand that you've got a public company that you need to, its image and branding to take care of and its perception in the marketplace, both by regulators and the investment community. So we're well on our way.
walk me through that process then. You've had a lot of transactions in the last 10 years.
Sure.
After the plan went in effect in 2012, which is essentially when you launched in Illinois. And at that point, you probably had minimal locations. Walk me through what you guys were doing then or now with regard to your partners in Illinois, or when you go into a new market. And when you're entering a new market, it seems you're primarily have been acquiring somebody in order to get into that market, give or
Yeah.
take.
That's right.
Yeah, and what are you doing on the jurisdictional side as well as on the probity side for the individuals and the companies that you're acquiring?
So on the company side, what we do is we've historically been relying on their standing in that regulatory community, right? So if they have a license, we've been taking that as, okay, this is a company that's suitable for us to do business with. And on the personal side, we take a fair amount of time in getting to know our potential business partners, meeting with them over extended periods of time, understanding them and their businesses. The area that I think you're probably walking me towards, Member Katsaros, is that we have not historically done due diligence on individuals. We've relied on the fact that they're standing in that state must be okay because of they're operating in the state without any disciplinary actions hanging over their head and the like. We do lien searches, we do litigation searches, and sort of the basics. We know we can get better at doing more, going into new markets going forward. In fact, it'll be required of us here. So we're preparing ourselves to be able to say, here's a transaction. We're going to look at the jurisdiction. We're going to look at the key personnel involved. We're going to look at the company and do more extensive checks. And we'll work with Nevada Gaming Council here to make sure we have all the right boxes that we need to check.
So lien litigation, what about criminal history?
Criminal history, we have not historically run criminal histories on new business partners.
I mean, okay.
And we know that's something that we're going to have to be doing going forward, and we're prepared to do it.
Yeah, I mean, in the state of Illinois, I mean, the companies we acquire have all been vetted by the Illinois Gaming Board, and their criminal histories are constantly evaluated. They're getting licensed on an annual basis by the gaming board. So we get that. But in some of the other markets, individuals that come on in that market, as Tom said, hasn't the practice because we're relying on that jurisdiction.
Are you aware of the practices of other gaming licensees in the state of Nevada and how they do their background checks or due diligence processes?
I have some familiarity with the way Caesars has done theirs because we were talking to them at one point earlier on. It's public knowledge. And so we do need to get a little more educated on that process, and we'll be leaning heavily on our independent compliance committee member as well as Nevada Regulatory Council on what the requirements will be going forward.
So you don't have a plan in place now for performing a due diligence?
Not for a Nevada required plan. We have our own compliance plan that we rely on in Illinois.
That you've relied on historically?
Yes,
Has that plan worked for you in the past?
it has.
Have there been issues with that plan in the past? Maybe Mr. Rubenstein would like to answer.
I mean, in terms of issues that I'm aware of, not really. No.
So there haven't been any issues that may have been better resolved if you had done more due diligence?
I mean, like personally, I'm not involved in the actual due diligence process, and we rely on our compliance committee as well as the individual employment vetting for the people that work for us. And
But if, say, a gaming regulatory body required that you disassociate, you would know about that, I assume.
oh,
100%.
yeah, 100%.
Right.
Oh, yeah.
Has that
goes-
happened?
Okay.
Have we been required to disassociate with individuals? Yes.
Okay.
Can I jump in here, please, if you don't
Yeah.
mind? Member Watkins. So our compliance plan is designed for us. We rely heavily on the fact that if a person has a license in the state of Illinois, that they have been properly vetted by the agency and that their criminal background check is part of that vetting. If they've been issued, for example, in one case I think you may be talking about, if a person was issued a terminal handler's license, that to us is far more of a background check than we would ever do through open sources as a company. So we rely on that background check of the gaming board that says that this is a person that has been checked out. So we rely on that in being able to enter into a commercial relationship with that person. If subsequently information is found out by the gaming board in their investigations about an individual, and it's brought, and they would, in an open meeting in the Illinois Gaming Board, they would let us know that, hey, we we think that you should disassociate from this person for these reasons. We're provided a letter as to what the reasons are. And then we make a decision as to whether we're going to continue a relationship with that person or not. Because they can request a hearing. And if they request a hearing, it sort of holds the whole proceeding in stasis until it's actually resolved by a final order by the gaming board.
Yeah, we're waiting for that final order.
So you don't have the opportunity to voluntarily dissociate. Is that what you're saying?
We could.
And and with regard to the terminal handler that you contracted with, which I
Yes.
think we're both referencing,
We are.
You were aware of his criminal history. Is that correct?
We were aware of his criminal history, but also aware that he was holding an active license in good
I
standing with the gaming board.
understand that.
Yes.
I understand that. But so you had the opportunity to voluntarily dissociate after you came to the understanding, you became aware of the nature of the incident?
You mean prior to his licensure or post? I'm sorry for being, I'm just trying to make sure I'm answering the question correctly.
There was an incident that involved you and the terminal handler. Is that correct? Not you personally, but the
Yes,
company.
yes.
Is that correct?
Subsequently, there was a matter that is in criminal court now in DuPage County. Yes,
Okay. Now, when that incident came to light,
yes.
what action did you take?
So
What action did the company?
So we met with our compliance committee immediately upon that matter being brought to our attention. The game board informed us that this matter was going to be happening because we've been cooperating with a very long investigation with the gaming board up until that period of time. So we were aware there was something there, but we weren't aware, we didn't know what the conclusion was going to be. So we were active participants in the investigation. When the matter then went and became a public matter in the criminal courts, we went to our compliance committee. We said to the committee, this is not an association that we should continue to connect ourselves to. And we terminated that person's employment. We stopped using that person as a sales agent or registrant for sales agents and bringing us new contracts. We have severed any payments with that person and we've distanced ourselves.
Okay, and this was prior to the order to dissociate.
This was after the order
After
to
the order to dissociate.
disassociate because he had requested a hearing. And in the way our system works is once you request a hearing, that sort of holds everything in abeyance until the final order is issued.
So that's what I'm asking. Do
Yeah.
you have the opportunity, if you would like to engage in dissociation, if you wanted to do that, do you have the opportunity to do
We
that?
do have that opportunity, yes. I'm sorry if it took me long.
So
to get there. We do.
you were not prohibited from doing that. You just decided to wait. Is that what I'm understanding?
We decided to wait because we had a contractual relationship with that person that had terms in it that we were seeing if we could still honor.
Was there no unsuitability language in there that allowed
Pardon me?
you? Was there no unsuitability language in the contract that would allow you to make a determination as to whether or not the person was suitable?
That hinky clause, this was a very old contract in the
Uh-huh.
company's history back in 2010. It didn't have the more full language that we would probably want today in an
Right.
agreement. And so as we were growing quickly and putting contracts together with vendors, with business partners, that language was not fully
So you're saying that you were contractually bound until there was a finding by IGB?
correct.
Okay.
Okay.
So Mr. Harmon, since you're here, let's go back to the Clairvest investment.
Yes.
Okay. So the shareholder agreement,
Yes.
what were the rights that Clairvest had?
So without having it right in front of me, I will do my best to sort of recount them. They were more in the form of negative covenants, and so the company couldn't have us spend above the budget without Clairvest's approval. There were certain CapEx provisions in there that would prevent the company from going past its CapEx requirement, its CapEx it had previously budgeted for that was approved by the board of directors. There were negative covenants there about litigation, about entering material transactions, and so sort of your standard fare of negative covenants. for a
Entering
minority
material
investor.
transactions. So a
Pardon
merger,
me?
for example,
Pardon me?
a merger, for example, was that a material transaction?
Potentially, yes.
Depending on what you're.
Yeah, yes.
So, and any board seats, any
Yes, there were two board seats.
twos?
Mhm.
Okay. And what about rights associated with their ownership?
It was it was sort of a standard minority interest transaction where you would have voting rights on the board, but you wouldn't have majority owner rights. You wouldn't be able to control the board. You wouldn't be able to control a transaction. You were a minority holder in the company with 2 board seats to make sure your voice was heard to the extent it needs to be. And then sort of active participation as a partner with the company and looking at opportunities. Clairvest would bring us opportunities that say, hey, I think this might be a good fit for you guys. Let's go take a look at it together. We oftentimes did diligence trips together in other markets to look at business opportunities. So it was a pretty collaborative effort throughout the transaction.
So as a PE early stage is investing in a company, they want some control or insight into how the company operates, I assume. And then they may want to liquidate, right? If things aren't going well.
Yes, that is correct. They could. Yes.
Okay. So you enter into a merger agreement with a SPAC, right?
Yes.
And there's litigation that's then filed.
Yes.
So could you tell me about that?
We had a fundamental difference of opinion about the vehicle that we were using to enter into the transaction. I believe the Clairvest position publicly was that the company didn't have the authority to enter in the transaction directly the way that the way it was perceived by the Clairvest Group. It was actually a drag of shareholders was the actual vehicle that we used to consummate the transaction. And that drag right was within, we believed, the purview of the company to do. And so the company essentially had a sponsoring shareholder that dragged everyone else within the transaction. And I think at the time, Clairvest, when they filed the litigation, I'm not sure at that moment, both companies had fully connected on the structure of the transaction, because I think if you'll see from your investigative notes that the matter was dismissed rather quickly after they filed the complaint. We had another discussion and it was voluntarily dismissed.
Okay, and the outcome, how was Clairvest situated after the dismissal, after the merger and dismissal? How many board seats did they have?
You have 1.
Yeah,
One.
one today.
Okay.
That's right.
And liquidation rights?
No.
Okay, so they lost some rights in the process.
Yeah, as a minority shareholder, they did lose rights,
All right.
but also gained significant other benefits.
All right, please.
Sure. Just back in the due diligence, I was listening, and basically what it boiled down to is that if somebody's licensed in a particular jurisdiction, that's pretty much sufficient for you, or at least it has been previously, irrespective as to whether or not there may be allegations out there of, say, nefarious background, potential OC ties, what have you. We just dismiss that. We say they're licensed, we don't care. I get that you probably had the benefit of doing that in a particular markets that you operate in, but I'll tell you, when you come, if you're able to get a successful result hearing at the commission level, what we'll look at is your decision, not the decision of the other regulatory authority, but what did you decide to do in order to tie up your business with this commercial partner of yours? So I just want to throw that out there, because I don't know if that's necessarily sunk in yet, simply because somebody is or is not licensed by a regulatory authority or is licensed. That would be sufficient. That would not fly here.
And there's absolute liability on you. You can argue detrimental reliance. You can argue that
Sure.
we licensed or somebody else licensed someone.
Sure.
We'll still bring a complaint.
Yeah, that message has hit home.
Yeah.
And we understand that going forward. I've had conversations with the agents as we went through our investigation about sort of what this is going to look like. And we're prepared to move forward with a more proactive view of compliance, relying less on an agency and someone's status as a licensee and more on our own diligence, our own investigation, to the extent that we have sources and material available to make our own decisions going forward.
Okay, so at this point, in terms of your due diligence of your partners and throughout the various states that you're in, we're still relying on the regulatory authority, but going forward, what you're saying is that you're going to do your own due diligence on that, take into consideration the background of those individuals.
Correct.
Okay. So I won't go through each one of the different deals that you have done and ask you, what did you do in terms of due diligence? Because I'm just going to assume you relied on the regulatory authority in those markets.
We did. For example, if an acquisition target in Illinois had a terminal operator's license in good standing, we relied on that background of those individuals in that company by the Illinois Gaming Control Board. Those people were suitable to do business with and partner with in a combination.
Let's talk about how you actually partner with some of your commercial, what do you call them, the terminal operators? in Illinois in particular.
Yes.
How do you go about your commercial model there in tying up some of those locations? Because I know it's a competitive environment there and
In
everybody's in
terms of the establishments.
terms of the establishments, yeah.
Yeah, so we have a sales team that basically kind of has presentation about what we call the Excel difference, that we provide better service, that we have the ability to invest in new equipment to help understand their business on multiple levels, not just the gaming, hours of operation, customer engagement, and and then most importantly, we partner with them to make sure they understand the rules and regulations that we operate in. And we provide a compliance kind of advisory of kind of this is what you can and you can't do. And we are constantly informing them as rules change, as regulations evolve, that they are required to evolve as well. And there's always a level of separation because they are running their business and we are running our business. We will do our part to always follow the law, the regulations. And if we get uncomfortable with their compliance or their appreciation for the regulatory authority, ultimately we'll exit their business.
Have you ever exited a business?
We've had a couple situations.
What were those circumstances of those situations?
It's just that with licensing, they weren't licensing the right people. They weren't following through in a timely manner. It's usually in conjunction with the regulatory authority saying like, hey, we're having challenges here.
If I could add something to that one.
Yeah, go
Andy.
ahead.
One specific situation I was involved with was one of our relationship managers in processing the licensing application with the location owner heard some discussion about perhaps that person really wasn't the owner of the business and perhaps somebody else was sort of a phantom owner, and they were in the phantom owner category because they had statutorily ineligible convictions that would not allow them to be licensed, right? So when we found out about that, we said we can't do this. And so we reported it to the gaming board, and we have an obligation and duty to do so under the rules of the Illinois Game Board to report those matters. And so we reported that to the game board, and we decided to pass on.
And we don't perceive these people as our customer. We perceive them as a business partner. And part of that partnership is help them grow their business, making sure that they understand the rules. We've been very successful because people perceive us as partnering them and helping them grow their business. But most importantly, as we make very clear to them, we're an agent of the state. We see something wrong, we will report it. And
importantly, as an agent of you, it's critical that you do your diligence into them.
Right. And there's no establishment that is more valuable than our license. And there's no individual that works for our company that's more valuable than our license. So I say this to people on their first day, that the person who doesn't raise their hand when something's wrong, they are putting themselves at risk, because the company will always follow the regulatory guidance and the rules and the laws. And if you're not forefront with issues that you may see or think are wrong, then you're going to have to answer for that.
So in terms of your agents, and those are employees of Excel?
Yeah.
Do you also use third-party agents?
Yes.
And the dealings and the culture of compliance, has this been communicated to those third-party agents as well?
Yeah, absolutely.
And so how are they compensated? Any differently than the employees that you have?
Yeah, slightly differently. It's a similar type of compensation, except obviously we're not paying them a salary. We're not paying their expenses. So they have a slightly higher compensation for each success.
Because when we talk about trying to partner up with some of these locations, as employees, you have a lot more employees that you have underneath your umbrella, have a lot more control over because of compensation, because of employment matters. When you start to use third-party agents to tie up some of these locations, I start to wonder what level of involvement they have in your operation, what level of communication you've had with them as to the do's and don'ts, in particular in Illinois with the inducement prohibition there. You mentioned you foster a culture of compliance there essentially, And there was at least one instance where I would probably say you broached that line that you should not have, and although I know it's still under review by both sides and you're still answering to that. But what, in terms of communication with your agents, have you advised them the do's and don'ts? Do you give them a,
Yeah, so a great example, Member Katsaros, is Rule 350 that went in place, I believe it was 2021, I believe, where the gaming board came out with more concrete guidance on what inducements were permissible, what inducements were prohibited, and what conduct was permissible between business partners. But essentially, we're a business partner with our location establishment owners because we're co-marketing and co-promoting a business that we're both sharing in the profits. And so the way that the Illinois structure is the top 30, now it's 34% goes to the state, and then there's the remaining balance is literally split right down the middle between the location owner and with Excel. So you're a business owner sort of co-marketing, promoting a business that you both benefit from. So as an industry, and I sit on the Illinois Gaming Machine Operators Association Executive Board, we thought to ourselves, there has to be some measure of collaboration with the two of us to be able to promote our business together. And there should be some things that we can collaborate and pay for together without it looking like it's an inducement to get them to sign an agreement. There's some things that are just sort of basic, like marketing expenses and promotion expenses and paying for the electrical to put the machines in. We all thought those were very standard sort of fare that we should be able to carve out of the inducement rule, because as it stands in the statute, it's very broad. And as an industry, as we've grown, there have been iterations of that policy throughout the last 10 years of the industry being live. So come back around the point. Rule 350 brought clarity to that.
could I stop you really
Yeah, of
quickly?
course.
Because I always thought the inducement prohibition was there for a long time.
It was.
Oh,
It
okay.
has been. Yes, it has been.
So-
It's been there from the beginning.
But you're saying only recently did you get more clarity on what it actually meant? Because my understanding of that was always that you just can't do anything. There's no rewards, there's no sign up bonuses, there's no inducement. I don't know. That's the word.
Yeah, with the location owner, right?
Right.
We can't pay a location owner to do a contract with us. It was prevented. It was, of course, in put in place to prevent corruption, right? We all understand that. But what I don't think the gaming board fully prepared for was this business model of location owner and post signing the agreement, right? And how you're going to collaborate and sort of promote your business. And so there have been multiple iterations of rules that came out from the Illinois Gaming Board, extrapolating out of the statute, the inducement statute, section 25. And so it's been an ongoing review to a point where finally the Gaming Board came out with a rule that said, here's hard and fast guidance for the issues that keep coming up to us over the years. These things can be paid for, these things cannot. You can collaborate on these sort of marketing. You can only have 5 signs out front to sort of get everybody on a level playing field for marketing promotion, because there were multiple allegations of TOs diming each other out for you. He had too many signs. He gave away this, when a lot of times it was a legitimate promotion blessed by the gaming board. Just another terminal operator didn't.
So with the promulgation of Rule 350 and this clarification that you're speaking of,
Yeah.
did IGB withdraw its complaint against you?
It did not.
Okay, so it's pursuing it.
It is pursuing our play.
And what amount are they asking for in their complaint?
If you're talking about the DraftKings matter, it's a $5 million fine.
Okay, that's substantial.
It is substantial. And
So did you interface with IGB first before you decided to do this?
we did.
You did.
We did. We provided them a copy of the agreement. We had outside regulatory counsel vet the agreement prior to us entering into it. And so it's active litigation. I don't want to say too much, but of course I will be as transparent as I can with you to
Right.
talk about it. But
Yeah.
the matter, we have a fundamental disagreement on the application of the inducement rule to what the behavior that we were engaged in as a company, because we think it's similar to permitted activity that was already in the marketplace, not prohibited by the rule.
Yeah, see, on the face of it, to me, with my lack of understanding or expert understanding of the marketplace, I would call that an inducement as well. But I won't wade into those waters because I'm not the expert there. Nevertheless, I do appreciate the fact that you did raise it to them
We did.
prior, but in what context? Was it a question? Was it asking for permission, or was it, hey, this is what we're doing and we'll beg for forgiveness later because this is going to benefit our business?
In Illinois, the gaming board does not approve a transaction like this prior to. So we're a little bit in we're a little bit in the, on our own in consulting with outside counsel and making a business decision and a compliance related decision that we think this association with these commercial terms fits within Illinois. Had we thought any differently, we would have never have done it. And when the game board raised their hand and said, hey, we don't like this, we terminated the agreement within days. And there was very little commercial traffic that went from DraftKings to the player. I believe it was $21,000 and some change. And so we have a fundamental disagreement with the fine amount being asked.
The dollar amount's not much, but at that dollar amount with the sort of microtransactions that you're doing with each one of those locations would
Yeah.
say it was pretty expansive then in that regard.
Yeah, I mean,
Based upon on a location basis.
The agreement never got the sort of traction we were thinking it was going to get. And when we found out the gaming board thought, you know what, we just don't like this. We think this is cutting it way close, but we think you've crossed the line. We thought we were inside the line. It didn't make any sense for us so we called DraftKings and said, hey, let's just be done with it.
Walk me through the steps you took though, in terms of communicating with the IGB and saying, hey, this is what we'd like to do. I get that they're not going to approve it. We have communication all the time with our licensees
Sure.
and we encourage that. If you don't know, come ask us. Okay, this is what we do. We're for our state, 2,500 some locations, countless thousands other licensees, we still field those questions and try to get back to you quickly. If we don't get back to you within a few weeks and you move ahead and you've already asked the question though, that then starts to call into question your judgment.
Sure. So in our jurisdiction, that dialogue is not afforded to us.
Okay.
And they don't have advisory opinions like they have here. And in fact, I think they still have advisory opinions when I was here. And so they don't have AGO opinions that come out to sort of give guidance. So we didn't have the benefit of having a conversation with regulator saying, you know what, yes, this is okay with us, or no, it's not okay with us. In most instances, we're told we're not going to give you an opinion on the matter one way or the other. And so that's why we're left with outside counsel, our compliance committee, our best business judgment, and looking at the transaction, vetting it through regulatory counsel to say, does this get close to the line? In fact, in that agreement, we had a very specific section that unfortunately was left off of the complaint that talked about wanting to make sure that these payments that were direct payments from DraftKings to players that just passed through Excel, we had no discretion on the amount of the payment that was set by DraftKings. We had a specific section in our agreement that to ensure that we made that these payments were compliant, and that if they weren't, we weren't going to do them.
To go back to Member Kotsaro's question, I mean,
Yeah.
will you tell us the specific steps that you took? You mentioned that you consulted with IGB. So what
So
steps?
we sent the agreement into them, and we sent the press release into them and said, this is what we're going forward with. And I received a response back from the general counsel of the game board at the time, it's public, that said, we don't give advisory opinions on approvals of these things. And that's it. And we didn't hear from them for quite a few weeks afterwards until the first investigative request came in. And of course, we cooperated and provided the information that they needed. And then once we found out from the administrator that he had a fundamental problem with it, we killed it.
You kind of lost me at one point though, not just there, but I was reading the materials and it was mentioned the same thing as in that you were hinging on, at least in part, that the fact that it was a pass through. Why does that matter in this case? That it was a pass through and you were deriving a monetary benefit, because what you are deriving is a benefit in the ability to get additional locations, which thereby could be considered an inducement or not.
Yeah.
Just educate me here on that.
Sure. So there are other pass-through payments that come through a terminal operator, for example, touch tunes. And it's
The jukebox, yeah. Okay.
on the wall.
Yeah.
And so those payments actually are paid to the company, and the company passes those through to the location.
same situation.
Same situation.
And in that context, in that situation, you're tied up with touch tunes? That's your contract?
Yeah,
or is that-
touch tunes is our device.
That's your device.
Our
Yeah.
device.
Our
Mhm.
device, our contract with TouchTunes.
But that's not gaming related, but I see what you're saying. That's,
The pass-through concept to us didn't offend our sensibilities because we're already doing it with touch tunes, and we're already doing it with, I believe, Golden Tee as well, where Golden Tee payments can travel the same way.
And we do the same thing with ATMs. We get paid by the banks
Yeah.
for the transaction. We pass through the payment to the location.
I think it's important to note, Member Katsaros, that there was no discretion on Excel's part as to what the payment would be. That was between DraftKings and the affiliate, if you will, in determining that if location owner, if you bring 10 people to sign up for the DraftKings and they end up with real money accounts,
Mhm.
you, location owner, we'll get, make up a number, $100 per player. And then that money it just passed through Excel's account because we already had an established ACH transfer with the location. That's how they get paid every 2 weeks.
Understood.
Rather than DraftKings going out and setting up bank accounts for every single affiliate, we just move the money right through us and we'll just pass it on.
No, okay. I understand the parallel now. On the face of it, though, I was saying you bring DraftKings to the table is an actual huge incentive. I would say for each one of those locations, but you're drawing a parallel to some other similar type of things. Okay. I'll hold off on questions on further on that. I just want to digest a bit here. But that's a sizable number.
Sizable number.
What do you know what in terms of the level of fines that have been issued by the IGB over the last 10 years? What sort of numbers are we looking at typically with licensees?
Nothing like that.
Okay.
Not in route gaming,
Sorry?
And
not
even,
in route gaming, nothing close. $1 million is probably the
Okay,
most. route
thank you. That's what I was looking for.
and the fines in the 7 figures usually have organized crime attached to them in Illinois. And we just fundamentally are at odds about the amount of the fine relative to the conduct that
Yeah.
they're believing that we engaged in.
Is Illinois the only jurisdiction that's issued a complaint against you?
Yes, only one. I mean, in full transparency, we did receive a warning letter from the Pennsylvania Gaming Control Board on a matter that we disclosed late. But they just told us, hey, look, you know what, you're a new licensee. These sorts of things need to be sent to us ahead of time, not after the fact. So we've been fully compliant since then.
Okay. And what you were just summarizing, that's because you're disputing the complaint from the IGB, is that correct?
Correct.
And that was the basis of your dispute, right? What you were just summarizing?
Yes, the DraftKings matter, yes.
Have you ever had to investigate an employee for sexual harassment?
Yes,
Can you tell me the nature of that investigation?
sure. So in September of this past year, a member of our leadership team came to Andy and I and said, something happened, I need to talk to you guys about it. And she told us what had happened, and we immediately launched an investigation. I led the investigation and the interviewing of the witnesses along with outside counsel and also with consultation from our board. Informed our board very quickly. Our audit committee chair, our compliance committee chair, our chairman of the board, everyone was notified that a matter had occurred and that we were looking into it. Once we conducted our investigation and did all of our interviews, I think we did it in 2 or 3 days' time, we were able to corroborate the allegation and we made a decision as an organization that that person could no longer be involved with our organization. And so that was, and we gave that person time that we were going to make a decision to separate, and they resigned ahead of time.
Okay, and within what time span from notice to termination or resignation?
I'm very proud to say this, 1 week.
Okay. Have there been other allegations, or is this the only one?
There have not.
Was it termination?
Pardon me?
Was it
It's
termination?
not a termination. The person resigned ahead of the termination.
Mr. Rubenstein mentioned earlier that you have a sexual harassment training. What does that entail?
So all of us go through on an annual basis, at a minimum, a kind of online training about what is sexual harassment, how to identify it, how if you feel uncomfortable, how to handle it.
And who receives that training?
All employees.
Every employee. Now that COVID is behind us, if I might add, Member Watkins, Andy and I historically, prior to COVID, had gone around to each of our regional offices in Illinois, and we do sort of a compliance primer. Andy sort of updates on new business trends. I update on government relations and compliance matters that are important. And at every meeting, we would talk about if you see something, say something culture, and reminding people that if you see something in the workplace that doesn't look right, it doesn't have to be gaming related, just as could be, between human beings. If something doesn't look right, raise your hand, and let somebody know, whether it's your direct supervisor. If that person is involved, you go to your department head. And always, Andy has remarked a number of occasions, you can always come find me or him. And so we give people access to us if they feel like they need to report something and they don't feel that the chain is proper for them to do so. And since going public, we've added a whistleblower hotline, which people have used to inform us of behavior that they think is inappropriate.
Was the person who was the victim of the sexual harassment, were they a direct report to the person who was accused?
They were. She was.
Did you have any forewarning that this time, was there any prescience on your part, anything that might have suggested to you prior to hiring this individual that there might be some predilection to this kind of behavior?
I'm going to say no.
Mhm.
I'm going to say no. I think the matter that was reported to us prior to is I wouldn't necessarily respectfully agree that because
I'm
of,
just asking.
yeah, but because of one sort of choice in behavior necessarily equates to a predilection or a
Risk,
propensity to do the other.
about a risk.
Didn't that other behavior involve the workplace?
It did, but it was consensual.
Okay,
At least as it was presented to us.
but you were put on notice. In what way were you put on notice?
We received an anonymous,
Prior to,
pardon me?
that was prior to hiring, is what you're asking,
Mhm.
prior to hiring.
Oh, nothing prior to hiring,
Okay.
post hiring.
What
So,
about?
Mr. Madamba?
Time to wake up.
What about subsequent to hiring?
Subsequent to hiring, we received a anonymous letter that eventually, in talking to the individuals whose names were referenced in the letter, we came to find out who the person was who wrote the letter. But we found the letter to be not credible, and we dismissed it as something that was sort of an after the fact, maybe taking a shot at somebody that perhaps a relationship, someone was trying to take their pound of flesh, if you will.
So maybe not credible, but it turned out that that kind of activity that was potentially, maybe not presaged, but mentioned.
Yeah, go ahead.
There's a very different view on consensual versus non-consensual activity. And
Tell me about that.
it's just like,
A very
this-
different view.
in terms of, we didn't have any indication that there was non-consensual activity prior when we received this letter.
And so that's the line of distinction that you draw.
There was no line,
Well, I think,
there was no indication.
yeah, in conjunction with interviewing the persons who were named and believing and interviewing them that their statements were credible, that what was alleged in the correspondence didn't seem to marry up with the version that was sort of portrayed in the letter, in the correspondence didn't marry up with the testimony of the two individuals that we spoke to. And so,
But had you had a more substantial due diligence process, perhaps this could have saved you from this incident ever occurring.
perhaps, to sort of echo a theme that I've used earlier, and again, one that we've tripped over, unfortunately, is that we're relying on the association with a gaming licensee and believing that that was sort of green light to be able to engage with this person because of what we believe was a very robust compliance program and affiliation here. So yes, I would agree with you that we could have done better.
What's your policy with regard to document retention?
So document retention policy for us is pretty broad. In fact, it's right now in the process of being revised since we've gone public and trying to figure out what retention levels we need for counting, compliance, for sales. And so we don't have a broad brush retention program. We do have a retention program at the Illinois Gaming Board level that requires certain documents to be kept for 5 years. So I think where you're probably wondering me to go down is personnel files.
Mhm.
And with personnel files, we have historically only kept those documents that occur, that memorialize activity while the person was in our organization, not prior to. So we have background checks that we do. We have, open source ADP background checks that we run on people. We run drug histories on people, drug testing on folks. We sort of put that into the onboarding package.
Let's back up.
Yeah.
You said you did generally only keep documents regarding activities that occurred while the person was employed.
Not employed. So if something like in the matter we're talking about, that was prior to their association with the company. So we did not keep.
But you
that
received the letter during the person's employment
We
with the
did.
company.
We did.
So I guess it depends on how you define activity, right? Because the letter was received during the person's employment.
Yes, I think the line I'm drawing, Member Watkins, is the alleged activity happened pre the company.
The allegations in the letter happened before they were there, but you
Correct.
received the letter while they were there, but
Yes,
did not make a decision to retain that documentation. Is that correct?
that is correct.
And why is that?
We thought the document was not credible and we didn't think it was necessary to keep.
And who's responsible for that decision?
I would say mine as the chief compliance officer looking at, and human resources also reports up to me that document did not seem credible. At the time, it didn't seem like something that we needed to keep.
So, so your research into it, I mean, you did some diligence into that letter, right? So
We did.
you wouldn't want to document that? That makes no sense to me. As a lawyer, I
Yeah.
do not understand. There's risk.
I-
And your own diligence showing that, I mean, you claim that it was not credible, that would help mitigate against your risk.
I will admit that we could have handled that better.
By retaining the
I
documentation.
retained the documentation.
I want to jump back quickly if we can to the IGB action that's currently pending. So the contract, the privity contract is between you and DraftKings, or was between you and DraftKings, right? And there was a fixed payment that you received. It was discretionary to you as to whether or not you passed it on.
Not discretionary.
It was not?
No. Not at all.
Okay, explain that to me.
So the payment was set between DraftKings and the licensed establishment owner. That
Was there any contract, any paper between those two?
there was a program that we were helping DraftKings with using sort of co-branding.
Uh-huh.
That this is the program location owner that you can participate in, and they were given a one-page slick, right?
That they kind of signed up for.
Right.
They had your machines,
Yes.
right? So,
Because we weren't winning any new customers. This was current business.
And so DraftKings had a pre-established payment that would go to the location owner. And we had no discretion on whether they qualified or not. That was between them and Draft.
what about the agreement? Did the agreement allow you discretion?
No.
They sent us the list of people that they were paying.
And said, you need to pay these, the money needs to go out from you to these people. Here's the invoice. And then we will send you the money to reimburse you.
Yeah. That's yeah. It runs contrary to our background materials. And the reason I mention that is that Mr. Marino's, his email, what did he say here? Let me see. He says in August 21, 2020, he asked that the DraftKings agreement include one clause we would like to add, which would make clear that the commission DraftKings is paying will be shared with location for their efforts. We don't want to specify the exact amount because it will be fluid, but we want it in the agreements of the board, the IGP, can see that we're operating as a pass-through to the commission or for the commissions.
Right.
So, I mean, it feels like structuring almost, like a workaround.
Mr. Marino can.
Yeah, please.
Yeah, it's not,
Yeah, I think the key, Michael Marino for the record, the key to that is we were very clear that it was meant to be pass through. Whatever DraftKings wanted to pay the location, they would pay us, we would pay the location rather than DraftKings sign up 500 individual contracts with locations. The reason that we wrote that email to say it could be fluid is at the time of the agreement, we were agreeing to a $200 affiliate fee,
Right.
DraftKings and the player. if sports betting became really popular and they realized that the CLV of these customers was substantially higher, we could recontract with DraftKings to have a $500 agreement, in which case we were always going to split 50% of it with the location. So the reason we wanted it to be fluid was we signed individual agreements with each location when we brought them in and said, would you like to be a part of the DraftKings program? If you would, here's the agreement, which states very clearly, for any customer I sign up, I will get an affiliate payment for signing them up. iLocation, I get a promo code. I'm Excel123. That's my promo code. Anybody who signs up for DraftKings with that code, the location gets $100. We get $100. That was the agreement. We pass, instead of DraftKings, again, paying location, they pay us. We pass through directly to location. The reason, again, that we said it was fluid was because at any point, if that number were to change based on market dynamics, we wanted to make sure that we would compensate the location accordingly through DraftKings.
Without having to go through a renegotiation of contract with a,
Correct.
Yeah, okay.
Again, when you have five, so again, and just the fine was large, as you saw. The total number of players that we signed up was less than 1,000 signed up through this promo at $200 a pop. The location, it's $20,000 of total dollars from DraftKings in the promo. The bigger part of the promo for it was an advertising play, and there was other things for us in the promo. And the key factor I think that everyone should be aware of that we made the IGB clear on, any bar can go on DraftKings website and be an affiliate with DraftKings. So it wasn't anything we were bringing them. They couldn't have gotten on their own. Go to DraftKings.com. There's a sign up button. You put in your info, your need. I mean, if you want to be a personal affiliate, you can be a personal affiliate. So all we were doing was helping facilitate something they could already do. And we know for a fact that many of our competitors were in the process, one with FanDuel, one owns Barstool, right? One of our competitors owns Barstool and sent a letter to their individual location saying, you know, we will have something very soon because Barstool wasn't operational in the state yet. So this was something that most of our competitors were going down the same path. We just happened to be first, which we normally are. And the IGB didn't like that, obviously.
Thank you for that explanation. I appreciate it.
I wanted to touch a bit again on the agents. So are your agents licensed by the IGB? Do they have to be work carded or?
So right now they are registered.
They are registered.
Sales agents. A rule has been passed. It's going to be a legislation was passed last summer that's going to require licensure of all sales agents now. The IGB has not enacted rules or regulations for that yet.
So currently now, what about for your third-party agents? Do they have
That's
to be
what we're talking
registered too?
about. Registered.
They're registered and they'll be required to be licensed as well, irrespective of whether employee or not, their status doesn't matter.
Correct.
Okay.
Correct. Whether you're registered or licensed, remember, Pizarro, you still go through a background check with the IGB. There's still some probity. It's just going forward, you will actually have a gaming license that will be at risk.
Are there any other sort of programs where you're perhaps walking the line in signing up your customers right now that you're aware of that's been sort of telegraphed to you that this might not fly either?
No.
Are there any other partners that perhaps you're aware of that may have nefarious backgrounds, but yet they're licensed and so you continue onward with them that you're aware of?
Not to come to mind.
Yeah,
No.
no, that I'm aware of.
Okay. I'm just trying to figure out again where you guys are at on some of your operations here, because we're going to call into question what your judgment is in dealing with these different operators. This is where a huge risk area is for the companies situated in your position, because rather than dealing with 50 casinos, you're dealing with thousands of different partners. So we would expect and require your compliance program to be robust and understanding who it is that you're doing business with. Because in every model, correct me if I'm wrong, at least in Illinois, it's a rev share there, like you just mentioned. It's probably going to be similar for the other markets that you're in too, right? It's a rev share. It's not a one and done where you're selling machines and you're off.
Right.
Okay.
Right.
I did want to get into where you're sourcing your equipment from, but in terms of okay, where you guys getting your machines, your software, how is this handled?
So today we primarily purchase from IGT, the former Scientific Games, Light and Wonder, Aristocrat, Novamatic. 98% of the.
That's going to be for your sort of traditional regulated markets. What about for the markets outside of those?
Yeah, we've some of the markets we haven't yet purchased because we inherited the existing games. Others we have purchased from the IGT, a company called, is it Vanilla or something?
Vanilla.
Vanilla.
That's for
and-
your Georgia.
Yeah, Georgia market.
Okay.
And we're looking at Vanilla for the Iowa market.
So for your replacement machine, so you haven't actually had to source machines for the, I don't want to call them unregulated, for the non-traditional regulated markets yet.
For
You-
Iowa,
you-
I don't believe we've taken title to any machine. We may have had conversations with them or put in a preliminary order, but we haven't received any machine.
Okay, so in terms of those vendors, is there a plan to do some background checks on those? Because those are going to be another area where you're partnering up, essentially sourcing gaming devices, amusement machines, however you want to term it, as well as software from them on a recurring basis.
Yeah, it's crystal clear to us that we need to have a sort of more KYC approach to how we do things, right? Where we're sending documents and questionnaires ahead of time to folks before we engage in business rather than after, not just assuming. So we don't have a concrete plan in place right now for that, but we will.
Okay, but I do want to understand where you're sourcing it from. Though. Right now, outside of the traditional regulated markets, you're saying vanilla is the only one
There may be one or two other companies that
you've actually purchased from.
yeah, in Georgia, they're all regulated equipment. I don't know the specific ownership structures of those companies at this point. We can do an investigation. We just haven't. That
So when you're sourcing, the machines where you source them from, I'm not asking about the machines that you've inherited as part of your purchase or
we're
acquisition.
buying those same machines. We're not necessarily bringing in a new machine to that market. If that machine's in the market and in our portfolio that we acquired, we may buy more from them.
You may. I'm asking you, have you done that yet? Have
I
you
think we
sourced
have
it?
some. I think we have. I just don't know these.
You just don't
specific
even know that.
purchases.
You don't know who you're purchasing from?
I don't know all the specific purchases that we've made in
Okay.
the last year in the Georgia market. I don't.
And
And we can get that for you. I just don't know the specific purchases in that market.
as we're talking about this, I just want to make clear for the record that we may have left off one jurisdiction is Nebraska.
Okay,
Nebraska is a new jurisdiction for us where we are registered
But we're not operating.
and we're not operating yet.
okay.
And in that, and for that state, we did our diligence in that state and ran our white paper through local council, had them create that for us to the board. There are approved vendors. There are only 2 in the state. So that's all, the only 2 vendors that we will purchase. Those vendors that have GLI certified and approved by the state.
Of course, you'll do your due diligence on them as well, right? What sort of machines are in that market? Is that amusement as well?
Yeah, it's similar to Georgia. Yeah.
I mean, I don't want to use,
It looks like a video gaming terminal, but has different math and kind of reveal. I don't think it's reveal, but different type of kind of prize or win visibility.
and basically you're winning merchandise or nominal amounts?
No, you're able to cash in tickets. Yeah.
So not nominal amounts, but actual.
Correct.
Oh, it is. Okay.
I mean, there's limits, there's regulatory limits that.
Because there's a huge change and shift, I would say, in the landscape of the US right now, where a lot of companies are attacking these, what would previously have been illegal / now are gray market / being legalized, right? Georgia would probably be a good example where they had thousands, 20-some thousand machines. I know it's over 30,000 now, where these weren't necessarily legal. They weren't illegal either, but we would probably call them, gray market machines at that point. And they legalized them, taxed it. I get it that it's regulated now by the lottery over there. So I would be very careful in the markets that you're entering into, ensure that it doesn't go the other way. Because the minute that you get into a market and it's determined, in fact, these aren't legal or constitutional under that jurisdiction, we're going to call into question your judgment there.
Yeah, we absolutely believe that. And Virginia is a good example. We never entered the market.
Another one as well.
Yeah, and until it's legal, we won't touch it.
I'd like to go back to your document retention. Did you consult anyone before discarding the letter?
Andy and I were the only ones that were privy to the matter.
How was the letter discarded?
Pardon me?
How was the letter discarded?
Honestly don't remember. I don't know if I shredded it. I don't know if we threw it out. I honestly don't, I don't remember.
How did you receive the letter?
It's in the mail, I believe.
It was
Came,
mailed.
like anonymously to the company. No,
Who all read the letter?
Andy read it. I read it. The two people that,
Or-
whose names were involved in the letter read it as well.
What about your compliance?
For me,
Compliance director? Your compliance board director?
no, did not.
No, so that wouldn't rise.
No.
Oh, okay. If I can just to sort of summarize right now, I mean, there are a number of different sort of specific issues, but I will tell you that having like a sister jurisdiction like Illinois, with an outstanding matter against you, seeking a $5 million fine on a gaming related item is very troubling to me. It's extraordinarily hard for me to even go forward at this point. Clairvest is I think a very good company, and out of respect for them, I guess we'll continue to consider this, but that's almost a showstopper for me. I also don't like the way that you handled the Clairvest investment. So you merge into a SPAC, you basically you diminish their rights and the value of their holdings. It didn't seem fair. It doesn't seem like a very smart business or a fair business move. That's my characterization. You can disagree if you like. I know it was voluntarily dismissed, but I also understand why that might happen. Having ongoing litigation with a company in which you are invested is not maybe in your interest as a PE, right? No?
they didn't make, I made it clear earlier, they never made an investment into the company.
Well, I mean, okay, don't argue semantics, please.
I know, I'm just saying, but they.
So this was a shareholder to
Right.
company. Yes, I understand. But you understand my point as well,
Yeah,
right?
I do. And as the CEO of the company, my obligation to make the best transaction, get the best return, and treat all our shareholders the best. And when there was a situation where a group of shareholders wanted to drag the company into this transaction, this was supported by a vote and followed that. And I believe it was the best transaction for the company. There's no one individual that if they object to something for their own personal interest, it's not in the best interest of the company.
Mhm.
It's my job to represent the shareholders.
You mentioned earlier that there was another potential compliance issue with a failure to disclose? I may
Never
not be.
timely disclosed. We disclosed it. We were just late.
How late was it and what was it?
Was regarding a follow-on transaction for the sale of securities for the company, going to the open market. And rather than provide that information to the Pennsylvania Game Control Board prior to it happening, we reported it after it happened. So they contacted me and said, hey, these are sorts of things we want to know about beforehand, not after, even though it's a public announcement and everybody knows about it. We would like to hear about these things from you beforehand rather than after. So we're going to issue a warning letter. And since then, we've reported everything ahead of time.
Did you have any other issues with disclosure issues in other jurisdictions?
As I recall, no.
Okay. On this agenda, I don't want to skip ahead. I don't want to pull us out of the substance of this application, but just to sort of deal with this quickly. There's a request for withdrawal, and this is for Ms. Phillips. And so I'll go through that quickly if we can.
Sure.
Jim Yanni, would you like to come forward okay. So she was chair of audit, right?
Yes, please.
And she resigned that position for what reason?
think Derek's probably the best person.
So in speaking with Ms. Phillips, the level of probity and sort of what was going on with the application was sort of not comfortable for her. And she's gone through licensure and other applications in other jurisdictions and sort of, been okay with that level of probity. But when we started getting into significant financial information and privacy issues, she was concerned about it and decided that she wasn't ready to move forward at that level. And in addition to the fact that, she, depending on whether she stays to the board or not for the long term, as we continue to rotate board members in and take on new board members and other board obligation, she wasn't sure at that moment if she was going to be staying long term.
And as a former DAG, you understand that we have, even though she's no longer in a mandatory licensing position, we still have discretion to consider her application.
Yes.
What did she do? Is she still on the board?
She's still on the board.
Okay. And is she on the compliance committee?
She is the chair of the compliance committee.
Okay.
It seemed like you just swapped her from the audit committee and just threw her on the compliance.
Right.
committee.
That's
It looked like, it's fine. You can do that. There's nothing wrong with it. But when the word you just used there was exactly, she had a concern with the level of probity she may have to undergo here. And so, okay. That is a little bit of a red flag. You can appreciate that, I'm sure.
Yeah, I mean, she's been licensed in other jurisdictions before.
Sure.
I just think that,
Sure.
as you commented earlier, the level of detail and the sort of depth of investigation, something I think she was not comfortable with.
Sure.
Did she complete her application?
She completed her application.
She did. So she ultimately went through it anyway.
She went to the application. It was sort of post-application, post-interview,
Right.
where a much deeper dive into trusts for children and wills and things like that. I think is
I see.
she made a
Some
personal
documents.
decision. It's not something that she was to anybody else.
Yeah, the process itself actually is somewhat designed to,
I understand that. Yes.
for that very reason. It's for us to decide what's the reason here. Is it just, this is gonna be a big headache, gonna take up a lot of my time, or is there something behind the green curtain that we're not supposed to see?
Former.
Okay. I have no reason to suspect otherwise, frankly. And then the fact that she's been licensed as well, so I'm not trying to cast aspersions whatsoever. Just it raises an eyebrow when
I
you.
understand.
She's an impeccable record.
Could you, sorry.
Yeah,
so
she's an impeccable record. CFO of public companies, boards of public companies, I think.
Nothing that
Yeah,
I've seen
yeah.
would suggest otherwise.
Yeah,
No.
yeah.
So,
Otherwise.
that I've seen.
Okay.
So can you describe how far she was along in the application process before
So
deciding?
initial document filing.
Sure. So she did the initial document filing, was interviewed by the agents via Zoom, by all of our agents when they came to do their first site visit at our company. And then subsequently, it was the next wave of investigative requests that came through, asking about wills and trusts and sort of a deeper dive into financial information that it was at that.
And what length of time of that was that from application to determination that she no longer wanted to engage in the process?
I'd have to go back and look, Member Watkins. It was whenever that first round of investigative requests, I want to say maybe 4 to 6 weeks after the initial field visit in mid-September, even after the holidays. It's requested investigative. After the agents came back and went through all their notes and interview notes, then said we would like additional information from you. Was it?
Okay.
Okay. Well, the application for, registration as an intermediary company and control and so on. Century is I think a solid company. That's not really the issue. It's you. It's Excel. So, you have questions about Century?
I don't have any questions anymore on the background of the Excel or Century. Century is really very well known to us. In terms of is it Ms. Phillips that we're talking about? We already have the application on file here. I guess my own personal view on that would be to retain it, but not necessarily activate it unless there's a need to. We've got, assuming this application moves forward, of course, because in that regard, we'd have numerous individuals licensed already, both on the Excel side as well as on the Century side. So that's just sort of where my head is on that. Because I can appreciate that, frankly.
Okay, Member Watkins, any thoughts?
Is this only as to the matter of the withdrawal, or would you like to
No,
further
please, I mean, just
discuss?
anything. I mean, we have, yeah, acquisition, transfer of interest,
So
licensing itself.
this is a bit of a topic change, but it's my understanding that staff had difficulty receiving documentation as it relates to, you weren't not, and I'm not saying you personally, but the company was not necessarily forthcoming with regard to the allegations.
I can address that.
Uh-huh.
When we provided the updated org chart, it was missing the person who had resigned. And this literally had just finished up. So we were just coming off of getting our heads wrapped around what we were doing, talking to outside counsel, talking to regulatory counsel. And so we weren't sure how much we should be giving at that stage, other than the resignation had occurred and the person was no longer with the company. We immediately reached out to gaming counsel, Jeff Silver, and said, hey, this is what happened. There's more to this. He said, get in front of this right now. You need to share everything. So we did.
And how long did that take?
Oh, it took,
Months?
Shortly thereafter, I've sent a follow-up email telling everything that happened.
Okay, because it's my understanding that there were issues receiving documentation from Excel as it relates to the allegations of harassment. And I would think that it would be important to provide that kind of information if you recently had someone resign over sexual harassment
Sure.
allegations. I would think that would be important to provide early on.
We did provide it early on.
Okay,
Yeah.
Early on.
all right.
You're familiar with the Act, Gaming Control Act, and with the authority of the board. I mean, we have access, we can have access to everything.
Yes.
Right? Understand that. Candidly, I mean, you say that, yet you say yes, but as I look at your history of due diligence or failure of due diligence, violations, that is associations with people who are problematic, relying on, what you call licensing of jurisdiction, just there are a number of issues here. I don't know that I believe that you're going to be fully compliant. We're a front-loaded jurisdiction, meaning that we have, 425 agents, right? We have they're highly trained, but we don't have one. We're not like some jurisdictions where we can place an agent with each licensee, right? So we rely heavily on making sure that we don't let the wrong people in, right? And that's the reason we're focused so heavily on your history of compliance.
No, Greg Giuliani again. Excel does have a compliance committee. They do have a compliance plan. They are continuously improving on that plan. And I think the current plan is to update that plan, update their processes to comply with what is expected here in Nevada, because what's expected here in Nevada is substantially more than is expected or required in other jurisdictions. And I know that Excel's worked with agents here about their compliance plan. I know Luke Rippey's been involved in this investigation substantially, and we will be updating that. And on top of that, a lot of the Century people will still be here post-transaction. So that culture of compliance, that Nevada culture of compliance, will then be absorbed into Excel, and that become part of Excel's operations and its culture.
Mr. Gimignani, I've known you for many years, and I know you're a person of honesty, so I'll take you at your word. I will tell you that I don't want to be in a situation where we're filing complaints against this applicant.
Agreed.
If anything happens here, it has to be a limited, meaning that they have to refile completely, right? That's the way I see it.
I understand.
is there a current plan in place with regard to due diligence and sexual harassment and document retention?
The sexual harassment policy is in place currently. That training happens, and that's part of our employee handbook. The doc retention policy is still ongoing. It's not formally set, except other than we keep certain records for 5 years or more related to the gaming board and sort of matters that they've requested that we hold for. Certainly, we can revise it and make sure that our standard in the Nevada standard becomes our baseline for everyone going forward.
So with regard to personnel files, you haven't changed your policy?
Only that if things, HR reports up to me, and so everything stays in the personnel file that is in people's files, full stop. Anything happens while somebody's at the company, it goes in the file.
So at this point in time, when you say when they're at the company, you mean that if the letter were received now,
Yes.
even though it referred to a time period prior
It would
to
be in the
someone's
file.
employment, it would remain in the file for a period of how long?
Correct. I don't know why it wouldn't have to be with their file until they left the organization as an active risk, if there was one.
Yeah, I would just say that, you know, you swiftly handled the sexual harassment allegations. You swiftly took action. But with regard to the document retention policy, with regard to the due diligence efforts, those things trouble me. I don't necessarily think that you have to be of the status of a lawyer to assume that something like that would need to be retained, the information that you receive, and determined to discard, especially when there are, you know, allegations like that detailed in the letter. That troubles me.
Yeah.
Understood.
I heard the word, it was not retained, I think, when I was reading the files, and the first vision I had was Enron with things just getting shredded. I know that was just my first vision. That's not what I'm not characterizing in that manner. I've seen the information, but yeah, it's probably something that should have been kept. That's all.
Understand that. And you know, we could have handled that situation very differently.
So as far as our options, just bringing it back to the board, you know, a denial or recommendation of denial is a death sentence, right? It's a very severe penalty. Referral back to staff, there's really nothing more to investigate here. We have, you know, far more information than they're aware of, right? That's clear based on this conversation.
Yeah, I think that's very clear based on some of the responses I've received from you and what I actually have in my report. I don't know that you've been fully forthcoming about, and maybe it's not intentional. I'm not accusing you of intentionally misrepresenting things, but what I've read is not necessarily consistent with everything that you've shared with me here too.
Let me just ask a couple of quick questions, because I'm coming at it from a little bit of a different angle, but you've been in business now 10 years. I think I've got a full picture in terms of the actions or sanctions that you've received over the last decade. And the one we've talked about obviously is a glaring outlier. Anything similar in that regard? Level of fines and so forth. I'd seen a few that, you know, I would call regular, which we have here as well in our marketplace.
Yeah, we've had minor infractions. I would kind of classify it as a violation of a statute related to clearing a machine, whether it's a $1,000 fine or a $5,000 fine related to an employee in the field, perhaps doing something not according to reg. We've had a handful of those in the last 10 years, maybe three or four of those in total, something like that. So, you know, as far as disciplinary actions goes, we've had a relatively clean record up until the DraftKings matter.
Okay, so none of the other markets you haven't been fined then, it sounds like?
No.
Okay, no threat of revocation in Illinois right now?
No, in fact, that was specifically told to us by the administrator that they were not asking for revocation. Look at all of the other disciplinary actions that have been filed pre, ours, and post. Revocation is usually a sought after remedy, and ours decided not to pursue and decided the fine was more.
Any view why the number was, thrown out initially was so high?
I don't have a view on that.
Don't, if you don't have any view there, don't share. I don't want you to
Not speculate.
impugn yourself over there. Okay, understood. Yeah, I mean, where I'm at is I'm looking at a company with a 10-year history, and we don't necessarily have a history or culture of being sanctioned or fined by the markets that they're in. They are a pretty large company too, so it wouldn't surprise me if I saw a higher level of infractions there. However, as Chair Gibson was saying, it's a big matzo ball that we're looking at with a $5 million potential fine there. So I would be comfortable moving forward. I don't know that a 2-year limitation would be inappropriate either, frankly. That's kind of where my head was.
Yeah.
I think my thoughts are that we need to limit, given the disclosure. I don't think that they've developed a culture of disclosure of. I think the document retention issue is very problematic, and I think that needs to be put in place rather quickly if we were to move forward, even in a limited matter. But and the violation, the complaint, outstanding complaint that is hanging over. I think there are a number of issues that may represent cultural issues.
I've thought about your matter after, as we prepare for these meetings, we get the materials about 2 weeks in advance we can have. And I've been thinking about your matter, and I thought, well, maybe we should use the Illinois event as a triggering sort of event. Something should happen at that point, but candidly, I don't think it will work. So, I mean, a limited 2 years is really, it will take that long for you to establish something of track record and then reapply. You understand why I would even be considering a limited license, I assume, as opposed to, right? You understand? What that means is that at 2 years, your license expires. It's gone. You reapply, right, before that expiration. But what that would do is allow us and allow the commission to re-review, right, in a new light with, I hope, I believe, consummation or finality in the Illinois matter, and just reviewing other matters, and give you a chance to, I think, more fully prepare for this meeting, for this kind of meeting, so that you understand everything that we have. You can give fulsome state, responses that are consummate with the materials. Right? That's a challenge. That's another challenge here, is that we have a lot of material, and your memory may be a little bit, not fuzzy, but it's, you don't have the material in front of you.
We don't.
So it's a difficult situation for you to respond to. As far as the request to withdraw, the justifications are I can't support that. I think that that's a good remedy that Member Casaros came up with, that is just hold it in abeyance. Won't activate it, but we'll hang on to it, maintain jurisdiction.
And you understand that's often happens, which is people are in positions of mandatory filing situations. They file, and then we determine which ones we're going to queue up. We have a limited staff where we can't investigate everybody, so we do that on a risk-based sort of approach.
Right.
Understood.
In terms of the outstanding fine too, just following up on Chair Gibson's thoughts there, my head where I'm at with that is the unknown. What might come of that? I wouldn't be surprised if you get a fine. That's not something that in my head would be a reason for denial. But I don't know. There's the element of the unknown there that gives me pause, that I just would think would be appropriate for us to have a second look at that upon the conclusion of it. So
We're heading into the discovery phase as we speak. So we're just barely crossing into that area. And so I think you're right. It's going to take us the time to get to discovery and sort of see where parties are at. And perhaps there's an opportunity for us to settle the matter at some point as we get further into it. Perhaps parties' position soften a bit, and maybe there's an opportunity there.
maybe it's just a function of unfortunate timing, because absent that, I wouldn't have any further questions, frankly.
Have you seen the draft order number 2?
I have.
Okay, and you've noted the new paragraph 9.
Yes.
Yes, yeah, about the sexual harassment policy.
Yeah, would you mind reading that into the record?
Sure. May take a minute here to pull it up. Sorry about that. Oops. A little slow here on the uptake. Came in yesterday at 5. Sorry, we had a bit of an email issue at work yesterday, so I'm
Oh,
pulling it
no
out of my
worries.
email.
I'll take your time.
There we go. Item 9 is that Excel Entertainment shall comply with NGC Regulation 5.250 as a licensed gaming establishment. And as I recall, Regulation 5.250 references having a sexual harassment policy, which Excel does have, and we will be revisiting that to make sure that it's compliant with.
Just
Nevada
to
Sex-
fill that out if I can, DC Rippey, I want that language to include a duty to report certain kinds of issues. Can we make an amendment to that? I want a duty to report. I want a duty to report. A sexual harassment policy is fine, but I want a duty to report to us. Anyone who's separated or.
Yeah, the reg itself, I think, has a duty to
Is that accurate?
Yeah, and as part of their compliance plan, we'll make sure that language is included as
Great,
well.
Thank you. Okay. Before we go forward, we owe it to the individual applicants to have them come forward and appear for the record. So let's have them come forward if we can. So we've heard from Mr. Rubenstein. Mr. Marino, please state your name for the record. Please.
I'm Michael Marino, Chief Commercial Officer, Excel Entertainment.
Thank you.
Good morning, Carl Peterson, Chairman of the Board.
Okay, welcome. And is Ms. Phillips here? She's no appearance? Ms. Phillips? No, okay. And then what about from Century? Do we have any presentation?
Thought I was just get to see.
Yeah, you
her.
thought,
Yeah.
well, I mean, we know you,
Chairman,
so welcome. Please
Thank
state
you,
your name.
Mr. Chairman, members of the board, Madam Secretary. For the record, my name's Steve Arnson. I'm the President, Chief Executive Officer of United Coin Machine Company and its parent company, Century Gaming, Inc.
So United Coin's been around since the 50s, right?
Yep.
What are your thoughts on this transaction?
It's been a rough hearing to sit through.
Yeah.
I've been asked a number of times as to why we thought Excel was the right fit for us, and there was really 3 things. And in a closely held company like we are, there's only 3 shareholders, so we try to always stay on the same page, and we've done a good job with that because we get along good together, and we've had a successful business. And I think part of that is making sure we communicate right. And surprisingly, price was never the main object. I mean, we wanted a fair price, and we knew what the market value generally was, and we wanted to establish that. But what we really wanted to do is to accomplish 3 things. We wanted to try to find a company that didn't overlap significantly with the business area that we operated in. I mean, far too many times we've seen competitors buy another competitor, and who pays the price are the employees. And we believe strongly that the employees are what got us here. And it's a very competitive market in both Nevada and Montana. We can incentivize, and we do. We fight tooth and nail, and all I could see is turning around after I asked all my team members to sit here and say, this is a team and we got to play together and we're going to win. Turn around and say, now we found the right deal, but it wasn't right for you. And so we got past that. They don't want to operate anywhere where we do. And so we like that. The second thing is way back in 2004, when we bought the slot route operation from Bally, we financed the entire purchase with debt. I was a minority partner with Heidi Schmalz, our CFO, and we just got outvoted, and they said that was a good thing to do, and this is a great move for us. Everyone else left the company when the economic downturn happened in 08 through 12, and I negotiated with banks for a year and ended up coming through that as one of the few companies here that never filed bankruptcy. We restructured, but we always had a ton of debt. And so, it's one of those things. I've dealt with debt for a long time. So that got this problem over. We found a company that's well capitalized. And the last thing, and I know this has gone on a long time, but the last thing was to be able to continue to do what we do. Didn't want a new job. None of us do. We wanted to just keep on. I want to be the CEO of United Coin until I retire. In a few days, I'm 67 years old. I see a 5 to 7 year window. And this allowed me to do that. I didn't want any part of the corporate business. I didn't want part of being a public company, and neither do my two partners. So
Well,
that's what
the reason I asked you to come forward is to make an appearance, but also because your company, we've dealt with you all for a long time.
I
You have
appreciate
a very strong history of compliance. Your compliance director is outstanding. You know what it means to operate Nevada.
Yes.
You do it well.
We respect that.
This is a new animal. And I would just ask you to help your new, if something this goes forward and is approved by the commission, to help your new colleagues understand what this means. Because you've been small enough that you've been directly in the crosshairs, right? You understand.
Yes. I heard Andy say the see something, say something. That stuck in my head. As far as if I see something that is different than the culture that we've had before, I'm going to say something. I fully intend to continue. I mean, I've got a lot of fire in my belly yet. I'm not ready to go home and watch Netflix. So it's that culture of that we've established here. All I'm going to say is that we'll do everything we can to continue that.
Yeah, I mean, and it's got to move upward, and this larger company has got to be compliant.
I understand.
Thank you.
Thank you. Thank you all.
Thank you.
Good to see you.
Any more of your colleagues, any more of the Century folks who would like to come forward? You want to? I'd like for you to make an appearance, please.
You want me to say my name?
Yeah, I mean, I do. I won't. Please come up and state your name. This is the way to get your name in the record for history. Right?
Heidi Schmalz, I'm the CFO.
Okay, thank you very much. All right. So you want to take the request to withdraw first?
Yeah, sure. I didn't have any questions of the backgrounds of the individuals. I'll just go on the record. They were clean. So there was probably why everything else dominated the conversation here today. There was nothing really concerning the backgrounds from my standpoint for the three individuals that were licensing, correct? The fourth one, as we already talked about, would be the request for withdrawal. Member Watkins is actually doing the motions today. So, but I didn't have anything further. I appreciated Mr. Arnson coming up. I wanted to see his appearance as well. I've never met you, Ms. Schmalz. So nice to meet you. I didn't have anything further. Thank you.
Mr. McKellar, you can tell me if this motion is sufficient that I'm about to make, but Chair, I'll make the motion. I move to deny the request to withdraw and refer the item back to staff to maintain the application materials on file. Does that comport with what you were trying to achieve? Because
yes, indeed.
And that's sufficient for Ms. Phillips to carve her out of this.
Do we need to make clear that's without prejudice?
That is the default, but there's nothing wrong with adding that, stating it explicitly.
Okay, without prejudice.
Right. Madam Secretary.
Member Katsaros?
Aye.
Member Watkins?
Aye.
Chair Gibson?
Aye. Okay, let's move on to the remaining applications, and I would like to limit it to 2 years.
Agreed. So I'll make that motion as well. I move to recommend approval of the remaining applications in non-restricted item number 1 as read into the record by Secretary Bell pursuant to a 2-year limitation and the order of registration draft number 2.
Okay.
I have a question on that one. Is the limitation just applicable to the Accel PTC entity and the Accel LLC entity, or did you also want that to apply to the Century Gaming and United Coin Machine Company applications?
Let's ask our investigative chief and DC Ripley, what is your recommendation?
DC Hoffman or Chief Hoffman, I would have it blanket and we'll just put everything back on the agenda in 2 years from now. And I would want to use the language, since there's findings of suitability and licensure, I'd want to use the language approvals. I can read out something that can be repeated. I would say approvals to expire at midnight of the May 2024 Nevada Gaming Commission meeting on the day the item is heard.
Okay. Can we incorporate that just by reference, Mr. McKellen?
I think we can, and then that would leave, if the limitation is explicitly applicable to the transfers, those would potentially need to be unwound. So I don't know if you want to carve just the transfers out of that limitation. There would be statutes that would require those to be unwound in the event that the licensing lapsed. But actually, you could have that approved in 2 years as well, and then if it was not approved, it would have to be unwound. So
But we could back out the transfers.
okay.
That seems to make most sense.
Okay, and I'll amend my motion as discussed.
Please.
Member Katsaros?
Aye.
Member Watkins?
Aye.
Chair Gibson?
Aye. Okay.
Great.
Thank you very much.
Thank you very much.
Thank you. Thank you. Thank you.
And thanks to the board staff. Thank you.
Madam Secretary, let's go on to non-restricted number 2, please.
Non-restricted number 2 is the application of Accel Entertainment, Inc. for a continuous or delayed public offering and the application of United Coin Machine Company doing business as Century Gaming Technologies to guarantee securities and hypothecate assets in conjunction with a continuous or delayed public offering.
Okay. Mr. Gimignani, welcome.
For the record, Greg Gimignani, from the law firm of Dickinson Wright on behalf of Accel Entertainment. I think this is just an extension of the matters that we've been discussing prior to this. I think we've covered quite a bit of ground this morning and stand ready for any questions you may have on this.
Well, key to this is the fact that Accel is, CEO of United Coin mentioned that they've been, over leveraged historically, and Accel as well, or is well capitalized. So this I see no, a specific risk here. So ask for a motion, unless there's discussion you'd like to have.
None for me.
No comments from me either. I move to recommend approval of non-restricted item number 2 as read into the record by Secretary Bell pursuant to the shelf order draft number 1.
Member Katsaros?
Aye.
Member Watkins?
Aye.
Chair Gibson?
Aye. Thank you. All right. Madam Secretary, let's go on to non-restricted number 3.
Non-restricted number 3 are the applications of Clairvest Group, Inc. for registration as a publicly traded corporation and for a finding of suitability as a beneficial owner of Accel Entertainment, Inc. It is also the applications of Kenneth Bryce Rotman for a finding of suitability as beneficial owner, controlling beneficial owner, and as an officer and director as noted on the agenda.
Welcome.
Good morning. Dennis Gutwald with the law firm of McDonald Carano. With me is Ken Rotman, CEO of Clairvest. And with your permission, I'm going to have him tell you a little bit about Clairvest and then a little bit about himself. We've got some presentation materials. They're not confidential. And with that, we're ready to go with your permission.
Please.
Thank you. Madam Secretary, Mr. Chairman, members of the board, very nice to meet you. Thank you for the opportunity to present my company to you. We have, my family's had a business relationship operating in Nevada for about well over 40 years. We have other business operations here in Nevada as well, where we're proud to support American troop training here. And we're looking forward to extending our business here. So thank you for the opportunity. If I can, I'd like to talk to you a little bit about my company and just about our core purpose. We partner with entrepreneurs to help build strategically significant businesses. And in so doing, we create value for all stakeholders. We create employment, we foster progress and efficiency. We contribute to economic growth, and we support the communities in which we live. And the owners of Clairvest themselves have very significantly supported the communities in which we live. I realize it may be unusual for people like me to present to you, and the first thing I get up and I talk to you about our purpose and our mission and our values, but it's important to what we've done. Our track record is outstanding in the industry which we operate in, and our track record does stand because I believe it's our people and our mission and our values, and we're something we can believe in. Our vision is to be, we were founded by entrepreneurs for entrepreneurs as principals first. We are not money managers. We are actually principals. We take in other people's money, but we are the largest investors in what we do. So this is our money. In terms of our values, we partnership, integrity, tenacity, open-mindedness, and long-term. And the one that makes most important to me is long-term, which is we build our companies to last, and we look at our reputation as our most significant asset. We're here for a long time.
So Todd, if I can interrupt.
Yes.
Your investment horizon. So as opposed to, relying on management fees, you have a different structure.
Yeah, so it's, listen, it's just math. We charge, much like my industry does, 2% management fee and 20%. But if I invest $230 million of my own money, there's no 2% on somebody else's money.
So you are an LP.
Yes, we're the largest LP.
Right.
So I don't let any other LP on my last fund put in more than 50 million. We put in 230 million. So
you keep open your opportunity to call in capital for what, 5 years, 6 years?
Yeah, so we can call every fund is slightly different.
Right.
I think our most recent fund we can call for 6 years. Traditionally,
and so the time horizon would be what, 10?
The typical time horizon is 10. We have the opportunity to extend it for additional 2 years beyond that.
Mm-hmm.
But what's a bit unusual about Clairvest is if we want to extend beyond that, and we have in certain instances, for example, in Chile, where we own 4 casinos in Chile, that has gone beyond the life of the fund. We have a credibility with our investors where if we'd like to extend it, we can, because we're the largest investor. And to be quite frank, if they don't like it, I'll buy them out.
Mm-hmm.
So, if it's a good investment and we've got good partners in the community and we like the business, I can meet everybody's need. There's lots of people who would like to invest beside me, and we've got lots of money. If people want to leave, we can just find a solution.
Thank you. Please go ahead.
In terms of our organizational history, I'm on page 4. Would you prefer that I prefer the slides or the PowerPoint? I'll do whatever you like.
If you want a PowerPoint for the audience, that's fine. I want to use
Okay.
that. It's not confidential, so
It's all available. So in terms of our organizational history, the firm was started in 1987 by my father and a bunch of his partners who are very well-known entrepreneurs, people who started the Four Seasons hotel chain, the people who invented the steel mini mill. My father was a resources guy. That's when in Nevada, I'm still wearing my original gold strike. He was one of the original shareholders of that gold mine here in Nevada. They came together and the mission was to be the merchant bank of entrepreneurs for entrepreneurs. In the first 7 years, they had a lesson learning that being a great entrepreneur and running a great investment company weren't necessarily the same thing. So after 7 years of struggle, I was doing my career in New York, and I joined the firm in 1994. I was very fortunate to be able to attract some great partners. On our initial fund in 1994, we managed to triple that. And then we had some institutional investors who said they would like to partner with us. But what we did was we made sure that we were always the largest investor in every fund we've invested. And you can see we've had controlled growth as we've controlled our people and our quality. But we continue to invest more and more money behind ourselves. The senior investment team really has been together, it says here for 15 years, but it's really been together for 20 years. And a small note that no member of my management team has been divorced, which I think talks a little bit too about our
divorced from you or
all their marriages are still intact.
I see. Okay. Wow.
So that's a little bit of just from a culture about importance of relationships. We have a deep track record. We have 57 platform investments. We've exited 39 of them. We've made an average return of 4 times our money. which for our business would put us in top decile performance. Slide number 5. So how we create value and how we initially became to know Excel is we start off by successful investment as an industry, company, management, timing, and price. And what I've learned the hard way is you got to pick the right industry first, and then you can work through everything else. So back in the 90s, we decided originally to look at the bingo hall business. And we decided that was not going to survive because slot machines were going to come in. So we started to look at the gaming industry. And then we ended up doing our first gaming investment, a company called Gateway Casinos, where we built the largest gaming company in Western Canada. Talked about that. Over our funds, we've continued to stick with some of the industries over time. So it's industry research, best-in-class operators. We research the industries, and ultimately we try to negotiate a deal, stay out of the auction process. With respect to our gaming on page 6, so we've received gaming licenses in a number of jurisdictions. We started off in, one second, sorry. This is talking to us, I think. That's all right. It either means I'm too loud or too quiet. So we've been focusing, I said, on the gaming industry for since the late 1990s. We've been licensed in Alberta, British Columbia, New Brunswick, and Ontario inside Canada. In the United States, Illinois, Indiana, Pennsylvania, Delaware, New Jersey, and there are some other pending jurisdictions. We've got involvements in India, in Chile, and in the United Kingdom. We got the pending licenses in Nevada, Louisiana, Montana, South Dakota, and Malta. Some of those may have moved from pending to approved name, but they're at a minimum, they're pending. In terms of our track record, I'm going to go back to the slideshow if that's okay with you, please. Sure. So in terms of our track record, we have 39 realized deals where we turned basically 880 million into 3.5 billion. Best advice my grandfather ever gave me was make sure you invest in yourself. So that's worked out well for us. Our fund returns are top quartile, at least. Our investors have made 2.5 to 3.5 times our money. Our most recent fund is showing 2.5 times just because this slide is a little bit out of date. That'll be going up significantly. As we look at the gaming industry, we have a sub-specialization in the gaming industry. We have experience, I'm on slide 8. We have experience in 34 different independent gaming assets. We've been involved with 12 mature casinos, 9 greenfield projects, 10 redevelopments. We've got a VGT operator with Excel we're involved with, and we have 2 online platforms. We have 1 B2C business in India, and then we've got a software support out of the United Kingdom, which will be coming before you shortly. Gaming, as you can see on slide 9, has been a very significant part of our portfolio. We've done, it's roughly about a third of what we do, give or take, for every fund, and we've never lost money in gaming. Our view on gaming, just so you know, is we're not destination gaming type people. We're most part local market gaming, and we work. What I tell my investors, which I believe to be true, is we work for you. We work for the gaming regulators. So it's quite obvious when we had our casino with Neil Bloom in Chicago, we had 500 million in top line. We had 250 million going to the state of Illinois, 125 million going to the employees and the rent. Mm-hmm. So it was quite obvious whose casino this was, and we're managing your casino, and we understand the compliance is number 1. In terms of our human capital, we are based in Toronto, and I'm very proud to say that when I look at our staff, we have a group of very hardworking, professional Canadians. They come from all walks of life. They come from various different backgrounds, but they were hired because they were the best at who they were, and they were the best we could hire. In terms of our board of directors, it's included on our board includes some people who really have been the CEOs of prior investments and built some great companies. And we also have world-class entrepreneurs in the gaming industry who are often involved with us on our portfolio companies. Our typical structure, as you heard about, is, in the best case scenario, we're actually partnering with owner operators and we're not in control because our core mission, we're not a conglomerate. Our core mission is to partner with owner operators and help them take their companies to a next level.
So would you talk about that for just
Sure.
1 minute? How is that in contradistinction to the way that other PEs operate? So you're not going in and seeking to replace.
Right. So it's an excellent question. So the first premise is, we don't invest thinking that we're smarter than the people we bought the company from. So if you make your money by buying a company and you think you're going to run it better than the prior person and then sell it, fundamentally you're smarter than the guy you bought the company from. What we try to do is find quality operators within an industry and then help them take them to the next level in terms of performance. So that's in terms of a partnership approach. With respect to operational control, you referred to, how did it work with Excel? Sometimes we're in a minority interest. Would we have invested in Excel if the Rubenstein family weren't very big shareholders on their own? Probably not. So at the end of the day, we're looking for partners as opposed to employees, the companies we run. But we always have our negative controls, and we always have the right to get liquidity. We generally invest between 20 and 100 million. When we were in Indiana, temporarily we went up to 200 million. If necessary, we can go higher. I just now like to review with you very quickly. I think it might be helpful if I give you some examples. Everything else has been theoretical. So we recently acquired Delaware Park. This is a Racino servicing the Delaware market. We invested 71 million. In this instance, we own 69%, and the balance is owned by the people who are involved in the management. Got 100,000 square feet, 2,300 slot machines, and 37 table games. It's a new investment, and it's going well, and we've been able to, with the partners who bought the company with us, we've already been able to improve operations. FSB Technology, which will be appearing before you in a little while. FSB is a company which was founded in 2007, is based in the United Kingdom. We've been interested in the sports betting business for a long time, but as you understand, the sports betting business is the exact opposite of the slot machine business, right? It's not as predictable, it's more volatile, it's thinner margin, and it's very expensive. So we decided not to be into the direct consumer sports betting business. What we've focused on is really spent 2 years looking for the right service providers. And we were able to do that both at the Meadowlands Racetrack, where we clear 50% of the sports bets in the state of New Jersey, and all through FSB, where we're providing the software platform for people who would like to be into the sports betting business.
I'd just like to ask a question on the investment in that. If I look at your history, it's in gaming, it's primarily been in the brick and mortar, like you said.
Yes.
You've got two listed on here. The Indian company Head Infotech. I'm not really familiar with them. And then you've got FSB now. But is Head Infotech also like an online platform?
It is.
Gaming?
And I will. That is an excellent question. If you could let me in a few slides, I'll do a better job.
Sure. Okay.
But yeah, so when we're, we like the gaming industry and we're heavily involved in it, but there's sometimes, the right place to be changes. So we were always traditionally, when we started off, we were making the bet that gaming was going to expand outside of Atlantic City and Las Vegas, and it was going to be legalized in different jurisdictions. And that was the primary investment thesis. And that started to unfold. And we're still pursuing that investment thesis, but a lot of it's already played out.
Where my question is going, should I be foreshadowing that your view is changing slightly in that you're going to attack the platform side of the business as well?
We're looking a lot at service providers too, because sometimes the service providers are better places to play.
Okay.
In the casino business, like, we're not going to get into the destination gaming business. I think there are people who can do a much better job of that than us. But if we can service Indiana, Chicago, local regional markets, we're open-minded for that. And on the online side, sports betting is, it wasn't around it wasn't in any meaningful way 10 years ago. Now it's huge numbers. So we're trying to figure out how do we play. But what's going on in DraftKings, we're never going to do that.
State B2B. Okay, I got it.
Mostly, except the consumers. Those are online casino. Sorry, the casinos on the ground. We're dealing with consumers there, but we're really cooperating with the government in terms of how to manage their casinos. So gateway casinos. This was our first casino investment in 2000. We grew it from 4 casinos to 10 casinos, and then we merged 2 of those to take it to 9 casinos. Went from 750 slot machines to 3,700. We eventually sold that to the Australians. Great Eagle Casino. This is our first and only casino property where we partnered with First Nations people in Canada. So the First Nations there have the right to build a casino in the southwest corner of Calgary. That is their territory. So we were able to have a casino with a preferred smoking access. I'm not sure about here in Las Vegas, but in Canada, people they prefer to smoke while they game, and so you set up a smoking room and a non-smoking room, and whereas some casinos can't do that. So we helped them construct that casino. We don't own it. You can't own a casino; it's their ownership legally. So we had a contract, which eventually we get the cash flows until a certain date. Then the ownership of the casino reverts back to them.
And your cash flows is purely on the investment side and that you provided in turn to build it. There's no management.
Yeah, it was management, and feel like it was a total contract to manage, to build it to management, and then we get cash flows for a certain period number of time, and then the management reverts back to the First Nations.
Okay, that's similar structure here as well.
We got involved in Chile. So when we were involved in, we always try to keep our companies focused on their core competence. That tends to generate superior returns. When we were at Gateway Casinos, we got an opportunity to invest in Chile, which that company decided was a little bit too far away from British Columbia. But we had a strong local partner in there. So we partnered with the Inchimnetsky family down in Chile. And I would say, if you have any experience with the Chilean regulators or know those people, they get the #2 spot behind you in terms of the most rigorous. Very good people. So we have 4 casinos in Chile: Marina del Sol and Concepcion, Osorno, Calama, which is in the copper mining capital of the world, and Casino Chillán, which we just finished building. We just opened it in 2019. We also built, I'm on slide 21, we also built Casino New Brunswick. We were involved in an RFP. We won that license, and we had a monopoly license to build a casino there, which we ultimately sold to Great Canadian Gaming. In Illinois, we competed for the 10th license. We were one of the 3 finalists to get through. Ultimately, Neil Bloom, the local, won, and the Canadians lost. But it was a pretty hairy time in the capital markets, so an ego is not very helpful in the gaming industry. So we called up Neil and said, "We lost, you won. Would you like a partner?" And it was pretty tough times in the capital market, so he took us in as a partner, and we were with him right from the conception of the Rivers Casino. Ultimately, we sold that to Churchill, our position to Churchill's Down, a little over a year ago, or a year or 2 ago. We were involved in the Indiana market. So we are in the horse racing business, but we're primarily in the horse racing business because of the affiliation with the casinos. The horse racing business is a very tough and declining business. But we ultimately purchased Hoosier Park and then went out of financial difficulty, brought some stability to that. And then when the competitor in the Indianapolis market, Indiana Grand, filed for bankruptcy and the creditors started to take over, we purchased some of the debt securities and worked cooperatively with the other debt security holders to buy that asset and then merge it in with Hoosier Park to create New Centaur Gaming. We ultimately sold that to Caesars.
Back in the Rivers, you said Neil Blum. Is that Rush Street?
Yes.
Do you still have any partnership with them?
We're friendly competitors. So we look at opportunities together. It's public record. We've looked at Massachusetts together and trying to buy, but Massachusetts has been a more cumbersome regulator, and they've not been able to actually get a license granted. But for example, that was one where we looked cooperatively with them.
But you don't have any investment in their other casinos right now, their online side or anything?
So New Meadowlands Racetrack, I referred to that. So we had the opportunity when the New Meadowlands Racetrack was going bankrupt and was about to close. There was a bunch of New York and New Jersey horsemen who wanted to save the racetrack. And so we went in there with them. We ended up purchasing the racetrack from the state of New Jersey. It was losing money. We agreed to help turn it around, invest in it. And then ultimately, we had some things went well, some things didn't, but then ultimately sports betting came in and we got sports betting licenses, and now we cleared 50% the sports bets. And our current program there, our bet is that with the state of New York bringing casinos down, 3 casinos downstate to New York City, that ultimately the state of New Jersey will put a casino in northern New Jersey, because there's only so long it can protect Atlantic City. When the state of New York brings those down, all those people in northern Jersey are just going to go across the bridge. So ultimately, we think there's a reasonable chance it would be good for the state. I think we can generate more tax revenue for the state of New Jersey than all of Atlantic City combined. We have an investment in Excel Entertainment. We've gotten a lot of airtime on that. And then going to your question, we have an investment in Head Digital Works. Really, I refer to this as Ace23. So in India, whereas some people like to play poker and play poker online, the game of choice in India is gin rummy. I'm not sure I know how to play it exactly, but we did not invest in the jurisdiction until it was passed by the Supreme Court that it was a game of skill, which made it legal. And we ultimately bought the #1 player. We've been focused on growing it. The market is maturing. Different jurisdictions find it to be legal, and then occasionally one of them finds it to be illegal, which means we have to shut all the customers down from that territory until we can go to court. And then ultimately, in front of a judge, say, is this legal or is this not legal? And so far, we're 3 out of 3 that the court system agrees that it is legal. So it's maturing. It's a very exciting company. But that's a B2C business.
I was just going to note that. What percentage of ownership do you have on that?
We would, I think we would control 70 to 80% of that company. We've got local partners in India. Obviously, if we're going to go into Chile or India and we're just a bunch of Canadians, you got to have some local people, or it just doesn't end well. We were involved in GTA gaming. So when the government of Ontario ended up legalizing the gaming industry, we participated in that, and we won a few licenses. Ultimately, we sold our position in that one to Great Canadian Gaming as well. So if I could just sum, we've got a 25-year history in the gaming industry. We're very happy to be in the industry. We're committed to the business. We do believe that ultimately we work with you. Your messages today on the importance of compliance and stepping up always is important and rings true to me. We do not control Excel. We're an investor, but we're one seat out of many. The other people on the board are quality people. I understand some people may not want to go through what I go through, but they are quality people, and obviously the company can do a better job of compliance, and we're supportive of that direction. I'm happy to take any questions you've got.
Please, open it to questions.
So how large is your investment team?
How large is the investment team? It's growing. So I think we're 24 investment professionals. I'll go to that slide.
And your approach to investing is essentially, putting your investment team members into a particular domain and allowing them to absorb and educate themselves within that domain.
Yes. So as I said, industry, company, manager, time, and price, finding the right industry is the key. There's some industries which you can repeat. We can continue to do more than one transaction. There's some you can't. But yes, so Angus Cole joined our firm, and we spent a number of years looking at the renewable power sector until we could find the right opportunity, build relationships, build some credibility. We're big in the recycling business.
So you're developing your team members as you're, learning of these various industries. And I think that's great. I think that's commendable. And also they're involved in speaking at conferences and writing articles, et cetera, et cetera. How long are they? What's like the time range that they're typically engaged in these industries before you make decisions?
Listen, in theory, it would be great if it was 6 months, but it's not.
Right.
You have to if we're going to make a commitment, it's going to be anywhere between a year to 5 years before we actually bear fruit. You have to invest and be committed.
Right. Interesting. But can you talk a little bit about your ESG program?
Right. If so, ESG is very important for us. It's always been important for us. But we didn't call it like for those of us who've been around doing this for a while, we just used to call it doing the right thing.
Mhm.
And so the ESG is kind of a new terminology. We've always been focused on doing the right thing, and different people define it different ways. We're proponents of being in the gaming industry. A lot of people don't think that's ESG friendly. We do. Back in the 1990s, there was a big debate at our board of directors, and we felt like it's a good idea to bring the right people into the gaming industry and the right disciplines and foster the growth of the industry. I mean, as you know, push comes to shove, somebody has to fund state Medicaid, and this is an effective way to do it. And if we don't legalize it, it's still going to take place. So let's legalize again. So we find the gaming industry to be, if you can do it the right way, very ESG friendly. We're very big in the renewable power business. We are enabling, I can say with confidence, the 2 investments we've made to date in the renewable power sector are enabling renewable power to happen. We don't need government subsidies to make it make sense. So we are building that. I'm on the board of, and we are the controlling shareholder of the largest solar operations and maintenance company in North America. And so we're actually making the power plants work. We used to previously be the ones collecting the data, but from a software point of view about what was actually going on in order to enable the proper operations. And in the recycling business, which is very part of, I think, ESG, is sending things to landfill sometimes makes sense, but sometimes it doesn't. And so all of our recycling investments, waste management deals, we've done 7. We've got 2 more that we're about to do. Recycling has always been a big part of that. We don't do it because of government subsidy. We do it because it's not only the right thing to do, but it makes money. If you're smart about it and you invest and you do it well, it requires scale and it requires capital. With respect to our people, as I said before, we're ideally, everyone's looking for a diverse workforce. If you looked at I'm very proud to say that we hire on merit. And because we hire on merit, we have people with a diverse background because that's just the population base. We hire the best people. Sometimes that means you're hiring the best you can. One place where I think we could do a better job is getting more women into the investment professionals. As a percentage of my company, I have a lot of very, very competent senior female executives in different roles of authority, but it's been harder to get females into the investment professional role. We've got 2. We should certainly have more. But it's kind of the only area where I say I wish we could do a better job.
Do you guys invest in any pipeline programming?
So the University of Toronto Business School has my last name on it. My father was the primary benefactor for the University of Toronto. It still is. Our family still is the largest benefactor for the university, except one family just may have gone over, but it's how they calculate it. So we're one of the top 2 benefactors for the University of Toronto, which is a world-class academic institution. We are involved with the business school and trying to get more women into finance, and then trying to get them in. But the truth is, we don't hire that many out of business school. I need them to go into investment banking or consulting, and then from there we can take them. We're just not a big enough firm to have the kind of training programs that we need. But so the more of them that go into investment banking and like it enough to stay, but not like it enough to stay for a long time, that's who we're trying to attract. So yes, is the answer. We are involved in some feeder programs.
Okay.
In terms of your investment portfolio, then looking at the gaming investments that you made, then this is probably going to be your first distributed gaming investment.
Excel?
Yeah.
Excel was stepping out a little outside the box for us. Like it was, it was just casinos until Excel.
Okay. I just was looking at this, and then I also looked at, you don't have anything in Quebec, but Quebec, they own all the casinos there, don't they?
Yeah.
For a lot of Quebec. Okay. No, I didn't have any questions on the background materials. Are very clear. Your presentation sort of reaffirmed what we already had in the materials, which was by all accounts a stellar company, stellar track record, no concerns, no issues from my standpoint. So
thank you very much.
I'm happy to support your application.
I don't have any concerns or issues either. Your affirmative presentation was very thorough, and our background materials are as well. So I'm happy to support the application.
Thank you.
Yeah. You're a unique PE firm, let's say. All right. This is very good. I appreciate the consider trading provisions, internal controls, and everything. Understand compliance well. So hats off to you. All right.
If I could just have one comment,
Yes,
your staff is very professional.
the best in the world.
Yes, they are.
They really are.
Yeah, so it was a pleasure. working
Thank
with
you
them.
very much.
Thank you.
It wasn't easy.
That's the point, right? That's the point.
It was a pleasure.
And I don't want to miss the opportunity. Born, and raised in Toronto, probably staying there for the rest of your life too.
That's hard to say.
Okay.
It's hard to say.
I'm just noting that as well. And it came out through your presentation too, that you wear Canada on your sleeve. I love that.
Yep.
That's a beautiful country. Okay. Well, thank you very much for that. That was a great presentation. And thank you for sitting through the discussion about Excel. As a member of the board, I think you understand exactly what we're looking at, and we'll have a microscope on them.
Yeah, you have my full support in your comments.
Right. If there are no further questions, I would ask for a motion.
I will make that motion. I move to recommend approval of the applications in non-restricted item number 3 as read into the record by Secretary Bell pursuant to order of registration draft number 1.
Okay, Madam Secretary.
Member Katsaros.
Aye.
Member Watkins.
Aye.
Chair Gibson.
Aye. Thank you. Thank you very much.
Thank you.
Right. Madam Secretary, let's go to number 5, please.
I believe we're on number 4.
I'm sorry, 4. Yeah, I don't want to skip the 4.
Non-restricted number 4, the applications of MGM Resorts International and Mandalay Resort Group LLC for an amendment to their order of
I just want to see how you'd react. Welcome.
Non-restricted number 4, the applications of MGM Resorts International and Mandalay Resort Group LLC for an amendment to their order of registration, licensure as sole member of Nevada Property 1 LLC, and the pledge as noted on the agenda is also the applications of Nevada Property 1 LLC doing business as the Cosmopolitan of Las Vegas for a transfer of interest, the addition of a racebook and sports pool, and licensure to conduct off-track pari-mutuel race and sports wagering. Lastly, you have the applications of William Joseph Hornbuckle, Corey Ian Sanders, and John Milton McManus for licensure as managers and or key executives. And I believe we have appearances via Zoom.
Okay. Set the queue in, but welcome.
Welcome, Chair Gibson, Member Katsaros, Member Watkins, Executive Secretary Bell. For the record, Sean McGinnis with Butler Snow on behalf of MGM Resorts International. To my left is Pat Madamba, who's Senior Vice President and Legal Counsel for MGM Resorts International via Zoom, and we do appreciate the accommodation to allow the Zoom appearance. You have Bill Hornbuckle, CEO and President, Corey Sanders, Chief Operating Officer, John McManus, Senior Vice President, General Counsel, and Secretary. Executive Vice President, thank you. And in Las Vegas here, we have Anton Nicodemus sitting in the first row, President and COO of ARIA. Next to him is Mark Lefevre, the CFO of ARIA. We also have Chandler Paul, who's legal counsel for MGM. And on the Cosmopolitan in Las Vegas side in the audience participating, we have Erica Okerberg, outside counsel with Greenberg Traurig, and I understand Elijah Tredup, Director of Regulatory Compliance for the Cosmopolitan. It's also here as well. These are the appearances. What I thought I would do, if it's acceptable, is I would give a brief overview of the transaction, and then we'd turn it over to Mr. Hornbuckle and Mr. Sanders to give a presentation on the transaction, and then we bring it back here to address the Reg 3070 items and then answer any questions that you have.
I like the plan. Thank you. Yes.
Well, this is a pretty straightforward application. This is a transfer of interest of an existing licensee. Nevada Property 1 LLC is the licensee for the existing Cosmopolitan in Las Vegas. This would be a transfer of interest, or MGM Resorts International would take the equity of the licensee and become the new owner of that licensee. That's the transfer of interest component of this. It's been determined that this would be a continuing operation, and so it'd be a continuing operation for tax and license purposes. On the agenda, you will see that there is the addition of race and sportsbook offerings, and that's because at present, Cosmopolitan operates that. They have William Hill as an outside operator. What MGM would do, post closing, is transition it to becoming an MGM book operated by MGM. And they would tie it up to the existing central site book that MGM has at Mandalay Bay. So that's why that's on the agenda. And the pledge of the membership interest is on there because, as you may recall, in March, we were before you for a pledge of interest for all the other MGM equity interests of the operations in Nevada. And under that agreement, the credit agreement with the lenders in November of 21, there's an obligation when there's a new company that comes in, that there's an obligation to also pledge those interests. So that's why that is in the on the agenda. So with that, I would turn it over to Mr. Hornbuckle and Mr. Sanders to continue with the presentation.
Okay. Thank you,
Welcome, Mr.
Scott.
Hornbuckle.
Good morning. I still think it's morning. Good morning, everyone. Chair Gibson, members of the board, Madam Secretary. First and foremost, I want to start by simply saying thank you, and particularly recognize the staff for moving this application expeditiously. Obviously, we are moving quickly on all of this, and we appreciate everyone's assistance in that. Also, again, want to express our appreciation for allowing us to do this on a Zoom. We're actually sitting in Mississippi in one of our boardrooms here. We take our board annually to one of our properties. Last year, we were in National Harbor. This year, we're in Mississippi. And so again, we appreciate your accepting us. We hope, provided we get through this, to be before the commission in person when that is ultimately scheduled. Quick overview, obviously, on the Cosmopolitan of Las Vegas. Goes without saying, we are extremely excited by the acquisition. It is something that you can't help but not look at City Center when it was first envisioned and created, and ultimately think it wanted to, needed to be, and should be a part of that complex. We've been interested in that in some time, and obviously now the marketplace has afforded us finally that opportunity to do it. It is a great property. It is massive, been well branded and well run. I think a great credit to Bill Macbeth and the entire team there. They've taken it from a meager beginning and made it into a powerhouse of Las Vegas. And for us to get it to join our portfolio and the market mix it ultimately brings and the customer base it brings to us is extremely compelling. It's not one necessarily that we own, if you will, in the context of the market. And so again, we're really excited to be able to ultimately fit that in. And Corey and Anton will talk a little bit more about those plans. Maybe a little more globally before I turn it over to them to go through that. For us, like I think everybody in Southern Nevada and even in our industry in the country, it's been a difficult 2 years. We have seen literally a reduction of 62,000 employees, and then quickly the reemergence of not only this industry, but our company. And so to say that it's been resilient, I think would be an understatement. Some of you may have not read or heard our conference call of yesterday. We then went again, once we came through last year's COVID, we obviously, like everyone, were impacted by Omicron in January, but came out of March with some records, not only in Las Vegas, which has been incredible, but ultimately throughout our entire system, at least domestically. The weekends have been tremendous for us. Our retail business has been tremendous for us. Programming and everything that's been done at Allegiant Stadium, all of the other activity that we've seen has been additive. Obviously, you saw that the community just hosted the NFL draft. And so there's a lot of excitement in the community. We look forward to things like Formula One, obviously, ultimately the Super Bowl. The other thing that's improving, and it's mindful, and we are in a significant way in this marketplace, it's about 20% of our mix is all of the group business. We are now about 90% of where we want to be and need to be, I think, through the balance of this year. And so that's exciting for us. And 22 and 23 are also shaping up well. I'm sitting in Mississippi, as I mentioned earlier. Regional properties continue to do well, amazingly so. And so we're excited by their future. Obviously, like everyone, we're cognizant of what's happened as late as an hour ago with the Federal Reserve raising interest rates, to what the economy may behold over the next couple of months, if not the balance of this year. But we still have great optimism, both in Las Vegas and our regional properties, that the market will be resilient. I think as a company, we've proven in January, even of this year, that despite a downturn, we're still able to operate in a very effective and efficient manner. And then the other opportunity that presents us more regionally is in New York. You just heard from your prior presenter. There's an opportunity for 3 licenses down there. I know you all know we own Yonkers, which is currently a casino, and we have high hopes and are working aggressively on turning that into a casino through the process that will ensue hopefully later this year. We continue to have in Macau strong headwinds, like some of our brethren in Las Vegas. Well, I guess it's the Wynn, and I was going to say Sands, but no more. We hopefully see that market returning very slowly. The last couple of weeks have been promising, but I think we're going to be facing these headwinds out the balance of that year. Fortunately for us, it's at least at this point, minimal to our overall cash flows. Historically, it's equated to about 20% of those cash flows. But I think, going forward, we fundamentally believe that marketplace is intact, and we are excited to see it ultimately rebound, hopefully next year. You've heard many references already this morning, and I think you all know we're 50% stakeholder in BetMGM. BetMGM is our JV with Entain, UK-based company. We have enjoyed a great deal of success, particularly in iGaming in that space. And so we continue to prosper that, not only throughout, we're in 23 markets, hope soon to be in 30 by year end. Time to tell as legislation makes its way through Ohio, Massachusetts, and several others. And then again, globally, both in Japan and Dubai, last week we submitted our area development plan, which is basically the submission one makes to the government of Japan for one of 3 licenses. We are hopeful to be granted a license later this fall. They say by October, but there's no specific date frame to that. And if that's the case, we would look to build a substantive property in Osaka. We're the representative of Osaka with our partners with Oryx. It's about a $10 billion project. It would take us through the balance of this decade to get it finished. But I think it would change the very nature of the company and how we go to look forward. And then you probably watched with interest, as we have in Dubai, the United Arab Emirates, as they talk about potentially bringing gaming to that region of the world. We're fascinated by that. And we're fortunate in that we started in 2015 a project. Non-gaming was a hospitality project only. There's a small island of 25 acres that would house a Bellagio, an MGM, and an Aria. And if gaming ultimately is authorized in that region, something we're following closely, we'd probably look to participate in that as well. So, overall, companies in really good stead. You obviously saw and witnessed and participated in the approval of the Vici sale that occurred last Friday. So our liquidity, our balance sheet, our outlook for the future has never been better. And so we're aggressively wanting to do things. Obviously, this transaction is one of those. And so with that, if I may, I'm going to turn this over to Corey Sanders, our Chief Operating Officer, and I believe Anton Nicodemus, who's in the room, to actually talk about the transition.
Well, thank you, Bill.
Thank you
and
very
good
much.
morning, everybody. We all share Bill's enthusiasm to welcome the Cosmopolitan of Las Vegas and to be part of our company. Their co-stars do an amazing job. They have a great leadership team, and we're extremely excited about the transition. Assuming gaming regulators approve the transaction, we will plan on closing before the end of May. The Cosmopolitan of Las Vegas will be transitioning to MGM by reporting to the Anton Nicodemus, the COO and president of Aria. We think there's opportunities there between those 2 properties based on experiences and the type of properties to have 2 great leadership teams there. The property will have its own management team, similar to how they operate today. Some of the back of the house functions, including IT, accounting, they will eventually be consolidated into the MGM Shared Service Center when the systems are compatible. From a capacity to add the Cosmopolitan Las Vegas employees into our system, as I mentioned, they're a very talented group. We look forward to them becoming part of the organization. They'll have not only will they have opportunities at their existing property, but they'll also have opportunities at all of our properties, including Las Vegas, regionally and internationally. We would expect some of them to take the co-stars to potentially take roles in our corporate areas also. And from a job perspective, we have over 5,300 job openings in MGM Resorts, so we're not concerned about absorbing them. Potential impacts to the employees, we do not expect any impact to the Cosmopolitan of Las Vegas employees. They will keep their titles, pay, and benefit. Some employees may transfer into corporate roles. From a customer perspective, we think this is a win-win for both the Cosmopolitan of Las Vegas customers and MGM customers. The Cosmopolitan of Las Vegas customers will be able to enjoy all of MGM Resorts amenities, including restaurants, nightclubs, entertainment offerings, and Shadow Creek, while the MGM Resorts customers will be able to have the opportunity of enjoying the many amenities that the Cosmopolitan has to offer. From an integration perspective into MGM Rewards, we will integrate the loyalty program into MGM Rewards. We are studying that now. We're trying to understand systems and methodologies and making sure that there's not takeaways there and how we do that. So we're really spending a lot of time on that. And then finally, as mentioned, the integration of BetMGM into Cosmopolitan, we would expect to happen 90 days after the acquisition. With that, I'll turn it over. Anton, if you have anything to add.
No, I'll just be prepared to answer questions. So, thank you.
Thank you. Well,
What I may do, if you want to do questions now, we still have the Reg 3070 piece.
you do. I just want to pause for a moment. Mr. Hornbuckle and McManus and Sanders are on the agenda for finding suitability. Do you have any questions for them? No?
I didn't have any questions on their background, no. They've been licensed numerous times. We're very familiar with them, no concerns.
We are.
I don't have any questions either.
I would note that Mr. Hornbuckle, McManus, and Sanders were key to standing up and funding themselves to the company a point of distribution for vaccines. And as we were sort of put in charge of that effort, that was very helpful to us. So I appreciate that greatly. Thank you very much for that.
And thank you for your effort as well. None of that was easy. I appreciate what you've all done.
Okay, let's go through the 3070.
Well, yeah, we'll bring Chandler Pohl up. He's going to do this analysis.
Welcome, Mr. Pohl.
Hi. Hello, my name is Chandler Pohl, and I'm legal counsel with MGM Resorts International. Chair Gibson, Member Katsaros, Member Watkins, Executive Secretary Bell. I'll address the multiple licensing criteria as per Regulation 3.070 specifically. The experience of MGM Resorts International and its personnel. And I'll also address the acquisition of the Cosmopolitan of Las Vegas, which I'll refer to as the Cosmopolitan, by MGM Resorts International, which I'll refer to as MGM. And it poses no problem with the inimical to Nevada's gaming industry, nor does the acquisition create a monopoly. MGM is a global entertainment company with national and international locations featuring best-in-class hotels and casinos, state-of-the-art meetings and conference spaces, incredible live and theatrical entertainment experiences, and an extensive array of restaurant, nightlife, and retail offerings. The company is a current licensee of 9 gaming establishments in Las Vegas, Mandalay Bay, Luxor, Excalibur, MGM Grand, New York, Park MGM Aria, Bellagio, and the Mirage. MGM and its Nevada operations, both past and present, are well known to the board and the commission. MGM has been a registered public company since January of 1988. The entity that operates the Cosmopolitan was established as a limited liability company in 2008. MGM submits that the board and commission can base a conclusion as to the effectiveness of the existing operations of both MGM and the Cosmopolitan. MGM has sufficient key personnel to operate an additional location, but it should be noted that existing team members at the Cosmopolitan will be retained at closing. Accordingly, there would not be a dilution of effective managerial capacity or control at MGM or the Cosmopolitan. Reg 3070 subsection 7 requires the applicant provide certain calculations for the foregoing criteria. These calculations were previously submitted to the board MGM provided two percentages for each calculation. The first percentage included data from the Cosmopolitan, but did not include data from the Mirage. A sale of that property is expected by the end of this year. The second percentage included data from both the Cosmopolitan and the Mirage, and this is the percentage that is reflective of this transaction today. However, it should be noted that the change in percentages between the first and second calculations is minimal and likely insignificant, but was nonetheless included for the purpose of transparency. By review of those percentage calculations, this acquisition would not pose problems or create a monopoly. The most recent instance where the Board and Commission conducted a multiple licensing criteria review of MGM was when MGM was licensed for the Aria Resort Casino in November of 2009. At that time, it was determined by the Board and Commission that MGM's operations would not pose problems or create a monopoly. Since that time, MGM has sold and divested itself from the following non-restricted operations in Nevada: Railroad Pass Hotel and Casino, Gold Strike Hotel, Silver Legacy Resort Casino, the 50% interest, Circus Circus Hotel and Casino in Reno, and Circus Circus Hotel and Casino in Las Vegas. In addition, MGM has entered an agreement to sell the Mirage. This equates to 5 non-restricted operations divested to date, with a 6th in process. Accordingly, the addition of the Cosmopolitan would result in MGM having fewer properties in Nevada than it had when the multiple licensing criteria analysis was last performed with respect to MGM in November of 2009. As to the Strip or Las Vegas Strip area, MGM currently has 1 less property than it had in November 2009, and the addition of the Cosmopolitan would net even. Once the Mirage is sold, MGM would again have 1 less property in the Las Vegas Strip area than it had in November of 2009. Should be noted that significant existing competitors with multiple operations are located in the Las Vegas Strip area. Caesars, Venetian Palazzo, Wynn Resorts, Phil Ruffin's properties, to name a few, not to mention new competitors like Resorts World Las Vegas. As such, MGM's addition of the Cosmopolitan would not materially alter the competitive landscape in Las Vegas or in the Las Vegas Strip area. So in summary, the proposed acquisition would not create a significant change to the competition to Nevada statewide, countywide, or on the Strip. And I'd like to extend my thanks to Senior Economic Analyst Michael Lawton at GCB for his assistance in guiding me through the extensive data available in GCB's publications.
Thank you, Mr. Paul. I just note on with regard to NGC Reg 3070 and the multiple licensing criteria that in addition to the Hart-Scott-Rodino review that FTC does, we do our own under our own statutory authority, and our board, or I'm sorry, our staff has made the determination that that this multiple licensing event is in the best interest of the state of Nevada. And so I would just put that on the record. Our staff has recommended this. Thank you.
And with that, we're ready to turn to questions. Bring Mr. Nicodemus up because I'm sure the questions will be a lot about transition.
Welcome, Mr. Nicodemus.
Good afternoon, Chair Gibson, Madam Secretary, and the members of the board.
Okay, so tell us what's going to happen here. So this is a continuing operation, at least legally, right?
Absolutely. It's a beautiful property, incredible co-stars and executive team. We believe those experiences are complementary to a number of our properties, specifically within that area. We're looking forward to not only enhancing those experiences and opening them up for not only MGM Resort customers, but also the customers of the Cosmopolitan, but also creating opportunities for those employees and those executives, as in that it was a standalone property. Given our vast properties that we have, especially a corporate culture. In addition to that, there's tremendous opportunities for a very talented team that exists at that property.
Thank you. I would open it for questions, please. Any questions?
I did want to go back to the 3070 analysis, but while you're here, Mr. Nicodemus.
Nice
to meet you.
Very nice meeting you.
Just the transaction itself, just a couple of points. We're looking at 1.6 billion for the transaction.
I believe so, yes.
Okay. It's truly a operational purchase, business purchase. It's going to be continue on with the asset light mantra for the company. So you're not going to own the brick and mortar there. I think we've already touched upon in the opening statement with regard to the employees and staffing, so comfortable there. Really where my questions came in was on the 3070 analysis, actually. So if we could get Mr. Pohl back up here, I did want to just flush that out just a bit. I agree with the conclusion, agree with what Chair Gibson just mentioned there, but I did just want to talk a bit about the differences with how it's presented versus the end number. The end number in the end, right? I don't think a monopoly has been created here. Where some questions do come into my head is, are we creating an environment though where we're reaching that point? I don't think we've gotten there. The fact that you have less properties is less important to me, as opposed to the percentage of the market that you control. We have to look at it on a statewide basis, county basis, but it's more localized in this instance. The state in itself is its own destination. But I'll just go on the record wanting to be clear in terms of comparing it to numbers of properties, not really all that interesting to me. What's interesting is the raw data and the percentages that we'll see post-transaction in terms of hotels, slots, table games percentage. And again, I'll reconfirm, I don't have a concern from that standpoint.
Okay.
So I didn't have any questions, so.
Thanks.
I'll add that given the 2009 analysis and the current status of MGM, the 2009 analysis with regard to the multiple licensing event, that I don't have any concerns either. We've been advised by our staff that this is in the best interest of the state. And I've read through the criteria. I think they're met.
I guess since we're mentioning the staff, I just want to make sure that we recognize the staff members who worked on this application very diligently and expeditiously. So we would like to thank Micah Tepe, Sean Crowley, Jake Abba, Russell Teggio, Luke Rippey, and also Chief Hoffman. They were all very integral in helping us work through this application in a very expedited manner. That's most appreciated.
One of the reasons for that, if I can just make it clear for the record, is that to allow you to maintain as many of the current staff as possible, especially the leadership team. We understand that there's a tight labor market and lots of movement, and so that motivated us to get this done.
That's greatly appreciated. Thank you.
All right, so do you want to, Ms. Radamba, welcome. So it's great to see you. Would you like to step forward and just tell us where we're at? So we had Vici acquisition of properties, right? The physical plan.
We closed it on April 29th. My 60th birthday. It was the best present.
Oh, yeah.
Even though I didn't get the 4 billion, but nevertheless, it was a very, very nice present.
And this item before us is, did you summarize it quickly, where we're at as far as where this leaves us? As far as where this leaves us, as far as what's you're purchasing?
Bigger picture.
In the bigger picture, there's a few different things. We just announced Leo Las Vegas, which is it's a European online gaming company. Does a little bit of sports betting, but mostly it's an iGaming company. We're going to close the Cosmopolitan. We're very, very excited about the Cosmopolitan, and as Mr. Hornbuckle noted, that there's development opportunities elsewhere, and we're going to try to exploit them. As I've said at several meetings, very excited about the Las Vegas market. It's astounding how quickly the market has come back. There's been bumps in the road, but I said to Bill, I said, can you believe it? I'm the good news guy. I'm usually said Gower. So I've become the good news guy for the company. So now it's a really good time for the company. But I really have to express my thanks to your staff.
Thank you.
We've had a number of conversations about this particular transaction. The reams of data went through. It's just astounding how quickly we've got. And we really are very excited about closing this transaction in the next few weeks.
Okay, so asset light, and this is sort of equivalent of that. And so Mirage is for sale. There's already a document in place, so we'll wait for that.
We do, and again, we are appreciative as well. I know that application is moving along. It's my former firm that's co-representing Hard Rock. They represent Hard Rock around the country. And so I happen to know it's moving very quickly, and I really do appreciate it. It's going well.
Absolutely.
really do look forward to coming back sometime in the next half of the year to see that transaction.
Absolutely. Excited to get another sovereign tribe and in the state, although they operate as a traditional state. Make it through. Any further questions about the transaction or anything else?
Yeah, who will be responsible for the maintenance and upgrades to the property?
From the facility standpoint, we will be. Yes,
And is there a capital expenditure requirement?
I believe there is.
There's a minimum capital expenditure, but it's a basket across our entire universe of properties. There is a CapEx basket. There's not a limit. We can put in what we want in our properties, and we're very proud of our properties. We believe we're best in class in every single, come into our properties, as you know. We are best in class in the industry. We truly believe that. That will stay if there's no limitation, our ability.
Mr. Madama, is that a function of, is that included in the master lease?
It's included in the master lease.
Okay.
The master lease isn't really substantively changed. Really, the Vici transaction, we essentially took the MGM Growth properties. I've called it before regulators, the big slide. All we've done is MGM Growth properties. See, was merged with the Vici entity, but all the entities that were sitting underneath it, they simply slid over. MGP lessor continues to be our landlord. We send the check to New York now rather than to ourselves in Vegas, but nevertheless, it's the same landlord. It's the same master tenant, MGM lessee.
Do you have a sense of what kind of capital investment would occurred prior to having a landlord and having a mandatory amount?
I'm going to defer to Corey.
Chairman Brim, I'm sorry, we had a hard time hearing, or Chairman Gibson, I'm sorry, we had a hard time hearing you. Were you asking about the investment?
Mr. Hornbuckle, we're reviewing REITs internally just to understand them the best we can. My question was, under the master lease, there's a percent reinvestment requirement, capital improvement requirement. I was wondering if prior to the master lease requirement, what you did on your own as far as percentages, and if it's comparable.
I can tell you aggregate, you mean in the balance of the company, or obviously not for the Cosmopolitan, but in the balance of the company, it varied anywhere from 400 million to 800 million a year in CapEx that was specifically focused on the properties, whether it be small growth or really recap for maintenance, facility, room remodels, those equipment, those type of things. And that's pretty much been historic, and this will continue. Obviously, with the pending sale of the Mirage, it frees up some capital allocation we had. Cosmopolitan is in pretty great shape. There is a commitment with Blackstone to continue to spend capital in and against it, which we all agreed to is the appropriate number. And off the top of my head, I want to say, I can't remember the exact number. Over time, the main tower will need a room remodel. Over time, there's a couple of restaurants that we're looking at. We'd like to do some more with the entertainment programming there. We think that's obviously a strength and a core that we want to lean into. Rest assured, having spent $1.6 billion for the operations, sitting in the heart of everything that we do, it'll be a property we tend to with great amount of attention and frankly, a significant capital commitment to it.
Thank you, Mr. Harmon. Okay, any questions?
Yeah, so there may have been some concerns initially or issues with the application because there was maybe not a clear understanding of who would be operating the sports book. Could you talk about that and how that's been clarified?
Well, I think I was talking to Special Agent Crowley about this. I think part of the issue is that the trade name that MGM uses for its sports books is BetMGM.
Mm-hmm.
And that doesn't mean that BetMGM LLC, which is the joint venture, is operating the MGM sports books.
Right.
So MGM operates its own sports books in Nevada. They're operated under the trade name BetMGM. And I think that's where some of the disconnect came in, but it still is the same. MGM operates all its sports books. And the intention here would be is once Cosmopolitan gets added to the MGM group, that the operations at the Cosmopolitan for sports books would be operated by MGM just like they are today at Aria, Bellagio, and the other MGM properties.
The Mandalay Bay serves as our central site for all of the strip books. The Cosmopolitan would simply be added and essentially connect to the central site. BetMGM is the brand that we use. BetMGM LLC, the entity, provides services. Board is aware, and those services, with some tweaks or things we're working out with the board currently, the services will be one and the same as they provide for the other strip properties.
Thank you for that clarification.
We're going through an iterative exercise with the board now as to what the appropriate scope of those services are.
And you plan to submit the internal controls for the sports book soon?
Yes, as I understand it, that there's some proposed license conditions, and actually, I'm glad you raised that because I wanted to make sure we got it on the record that the license conditions for the sports book that these would address the MGM operation of the sports book and would not apply to the existing William Hill continuing operation. So that my understanding of staff is that is the intention of those conditions, that they apply to MGM and Nevada Property One and not to William Hill. But yes, they would need to submit the internal controls to the audit division just to do exactly what Mr. Madamba just mentioned, to tie it to the central site book of Mandalay Bay.
The exit of William Hill is not immediate after the closing. There will be separate for William Hill exits by the sport book.
Okay, Member Katsaros.
I don't have anything further, no.
Well, this is an exciting day. It's been a long time in coming, and we've all worked closely on this with our colleagues inside the board. So thank you for your cooperation. What you've done. This is a good outcome, I think. For that, I'd ask for a motion.
I'll make that motion, Chair Gibson. I move to recommend approval of non-restricted item number 4 as read into the record by Secretary Bell pursuant to the 55th revised order draft number 1 and the following conditions. Prior to the commencement of race and sports and/or pari-mutuel wagering pool operations, an executed reserve agreement must be received and approved by the Nevada Gaming Control Board Audit Division pursuant to Nevada Gaming Commission Regulations 5.225 and 22.040. Prior to the commencement of computerized race and sports and/or pari-mutuel wagering pool operations, the attestation letters regarding the race and sports and/or pari-mutuel internal control system must be received by the Nevada Gaming Control Board Audit Division pursuant to Nevada Gaming Commission Regulation 6.090. Prior to the commencement of race and sports and/or pari-mutuel wagering pool operations, an adequate written internal control system for race and sports and/or pari-mutuel that documents compliance with minimum internal control standards must be received by the Nevada Gaming Control Board Audit Division pursuant to Nevada Gaming Commission Regulation 6.090. Prior to the commencement of race and sports wagering operation, the surveillance system must be inspected and approved by the Nevada Gaming Control Board Enforcement Division and thereafter be maintained at or above the standard that has been approved.
Okay.
If I could interject, Member Watkins, I just wanted to confirm that the draft number 1 that we're working off of is the one dated April 19th, 22, because I know that as we were getting close to getting the agenda, I was working with Deputy Chief Teggio and it did change. I just want to make sure because the April 19th, 22 date is the last version.
Is that accurate? Sure. Please confirm that, Chief Hoffman.
The one I have in front of me is April 12th.
That's the one I have in my background materials as well.
There's an updated.
Is there?
Updated
Is he
one.
repeated? Do you have that? Okay. And you were working with
Deputy Chief Teggio. He sent it to me.
He pushed out a later one.
Yeah, he pushed out a later one as we were working out exactly how the race and sportsbook items would come in. I can give you the copy that I have here. I believe
I'm sure it was a minor change.
it was a minor change. It was
Chair Gibson, can you hear me?
Yes, please go ahead.
The major change that I caught when I was talking with Mr. McGinnis was in the paragraph, for paragraph 13. What wasn't included in there was the manufacturing and distributor's license that would have came over with the approvals for that with the purchase of Nevada Property One.
Okay. All right. Right. So we are working off, according to you and based on you're confirming that it's the April 19th draft.
Was it?
BC
Sean,
Tech,
what,
Yeah,
um,
April 19th, 22 is what I have. That's the draft that you sent me.
yes. So in paragraph 13, I added the approvals that um, Nevada Property One had previously, which was a manufacturing and distributor's license.
Is it the paragraph 13 from the one previously dated in April?
Yes, so paragraph 13 on the one that you probably have is dated April 12th. Is that
Yeah.
correct?
It is.
Okay, so, and then my discussions with, and I thought I had sent them out to Kathy Cabral and Stacy Chance to have redistributed.
Please.
But so at the very bottom of paragraph 13, you'll see the manufacturing distributor's license.
And part of, just as an explanation, part of that went to the whole continuing operation
Right.
versus non-continuing operations. When it became continuing, then needed to make sure everything
We have to make
came
sure
along.
that we're preserving all the licenses.
Yes,
that are
exactly.
sitting there.
Understand. Thank you.
Okay, so then I will amend my motion to reflect the updated version. Is that's still draft number 1 dated
Yes,
April?
it says draft number 1, April 19th. Yeah.
Okay, we got that.
All right, please.
Member Katsouros?
Aye.
Member Watkins?
Aye.
Chair Gibson?
Aye. Thank you very much. Congratulations.
Very
Thank
much.
you.
Appreciate it. Thank you.
Thank you all very much.
That back. Please. No, we'll get it. We'll get it. from this. Thank you.
Thank you. Right. You don't want to lead those. Yeah.
All right, Madam Secretary, want to go on to the next item?
Non-restricted number 5, the applications of Interblock Luxury Gaming Products DD, doing business as Interblock DD for a transfer of interest and to convert to a limited liability company as noted on the agenda. You also have the applications of IBOCM Boat Co. for registration as a holding company and for a finding of suitability as a member of Interblock Luxury Gaming Products Limited, doing business as Interblock DOO. Next are the applications of Interblock Luxury Gaming Products Limited, doing business as Interblock DOO for registration as a private investment company, licensure as sole member of Interblock USA LC, and as a manufacturer, distributor, and an operator of a slot machine route. Lastly, you have the applications of Matthew Charles Wilson, Jordan Lewis Cruz, David Benjamin Quick, and John Joseph Connolly IV for finding a suitability and or licensure as a shareholder, officer, director, and or manager as noted on the agenda. I believe Mr. Cruz is joining us via Zoom.
Okay, wonderful.
Good afternoon, Chair
Welcome.
Gibson, Member Katsaros, Member Watkins, Madam Secretary. For the record, I am Erica Okerberg. I am Nevada Gaming Counsel to Oak Tree. Here with me today in person are 2 of the applicants and controlling persons, Matt Wilson and Dave Quick. And as Executive Secretary Bell just mentioned, we have Mr. Cruz via Zoom. Mr. Chairman, thank you for the courtesy in allowing Mr. Cruz to participate in this via Zoom. We really do appreciate it. Also here on behalf of Interblock are A.G. Burnett of Counsel, John Connolly, CEO, Heather Rollo, CFO, and Matt Heinhold, General Counsel. We would like to proceed, if acceptable, with an affirmative presentation to consist of the following elements. First, I will provide an overview of the transaction and the regulatory structure. Then we would turn to the PowerPoint deck that is being distributed at this moment. We would ask that that be treated as confidential and not be made part of the public record.
Okay.
And then I would bring up each of the 3 controlling persons who are new applicants, and they can provide a bit of background about themselves.
That sounds great. And we'll cover most of the bases. So please,
Wonderful.
go ahead.
Well, thank you. The transaction we have before you is structured in compliance with Regulation 15C. Pursuant to Regulation 15C.0101, a private investment company consists of the following elements. First, 100% of the economic securities must be held by private investment funds that are controlled with an investment manager who has at least $1 billion in assets under management. Second, 100% of the voting securities must be controlled by the individuals, the key executives, or controlling persons of the investment manager. And lastly, that company must not be a publicly traded corporation. If you will refer to slide 13 in your deck, that's the first slide in the appendix, you will see the anticipated post-closing structure, and you'll see Interblock listed in the middle there. In this particular circumstance, Interblock is the private investment company. If you look on the left-hand side of the chart, you will see an entity labeled as non-Boatco. That's OCM Luxembourg Baccarat Bidco. That is the entity that holds 100% of the economic securities. And you'll see in the simplified structure above that, we have Oaktree Special Situations Fund 2. That is the entity that is the private investment fund. And then at the top there, you'll see Oaktree Capital Management, which is the fund manager. Then if you look on the right-hand side, you will see an entity labeled as Voteco. That is IVOCM Voteco. That entity owns 100% of the voting shares. And as you'll see, is owned equally 1/3 by the three controlling persons, which are Jordan Cruz and Matt Wilson, who are also the co-portfolio managers for Special Situations Fund, and Dave Quick, who is assistant portfolio manager and managing director, of Special Situations Fund. Additionally, I would note, of course, for the sake of the record, that Interblock is not a publicly traded corporation and therefore meets the regulatory requirements. Lastly, I would note that Oaktree Capital Management has executed a non-interference letter as required pursuant to 15C.050C3, and that is provided to the board and board staff, so I believe you should have that in your report. With those elements, we do think that the regulatory structure is compliant with Regulation 15C. I am, of course, happy to discuss any questions you have about the structure. Otherwise, I can turn it over to Mr. Wilson, who will start to talk through the PowerPoint presentation with you.
Please. Seth,
Thank you.
come on.
Mr. Wilson.
Good afternoon.
Good afternoon.
Madam Secretary, Member Watkins, Member Casaros, Chair Gibson, I'm Matt Wilson for the record. I am a Managing Director, Co-Portfolio Manager, and Co-Head of the Special Situations Fund at Oaktree. I'm joined by my two partners today, Jordan from Madrid and Dave, who's here with us today. What I thought I would do is, if you would indulge me, to take you through Oaktree at a high level, our strategy, how we invest, answer some of the questions that you asked before of my colleague in Clairvest, and then have David take you through the transaction and our thesis on Interblock.
Please.
Okay, thank you. So Oaktree's been around for approximately 3 decades. We were started in 1995. We've grown today to approximately 166 billion of assets under management. We are a global firm that we consider to be an alternative asset manager because we're in multiple strategies. Our largest piece is credit, but we also manage real assets, infrastructure, real estate, private equity, and listed equities. The team, as I said before, about 1,000 people, approximately 200 of which are investment professionals, led by 44 portfolio managers, averaging about 2.5 decades of experience each. That's exactly what Jordan and I have today, and we are the heads of this group for the last 8 years. In terms of our philosophy, Oaktree is different than a lot of our peers in that we come out of the credit side. The focus on capital preservation and risk management is the key to our model. Our chairman, Howard Marks, always said, if you avoid the losers, the winners take care of themselves. So what you find at Oaktree is a focus on consistency and emphasis on risk management. When we talk about investments, we talk about risk management. When you come to the investment committee on a Friday morning to see Jordan and me about an opportunity, the first question we don't ask is how much money we're going to make. We talk about how we're not going to lose money for the next 2 hours. And when we finally beat that horse and decide we found a structure that works or a valuation that works, then we decide if the upside's actually there. In a lot of cases, as you might imagine, you can't have it both ways. But our process is very disciplined. We're very excited about this opportunity specifically. This is a long-term investment in gaming for us. We have one other portfolio company in Illinois, also a distributed gaming business, ironically, called J&J. But we think gaming as a sector, as we look forward, will be very much a focus for us in both Nevada and globally. In terms of our strategy within the Oaktree platform, today we manage roughly $5 billion of committed capital. 150 million of that is the partners' capital. The rest is from blue chip LPs, pension funds, endowments, the best universities, large sovereign wealth funds, high net worth individuals, all well vetted by Oaktree's compliance. We have a strict focus on FCPA, internal compliance, to make sure that we have full KYC on any one of our clients. To be an Oaktree client, you must go through a rigorous process of screening, so we know who we're dealing with. And we've been very fortunate to have repeat clients. We are in the market right now with a new vehicle. We're aiming to raise $3 billion in that vehicle to do a new set of investments over the next 4 years. We've been very blessed to have our LPs re-up in most cases and increase their size of investment in a lot of cases as well. In terms of our team today, we are a team of 28. We are based mostly in Los Angeles. We have a couple of people in New York. We have a team in Sydney, Australia. But 90% of where we invest will be in the United States and Canada. We do like Australia for the reasons that its legal system and the opportunity set are very much aligned with what we have here in North America. But ultimately, it's a small market. So for us, we think our capital is uniquely positioned to take advantage of that. We've got a very strong team we built out there about 6 years ago, and it's something we'll continue to focus on across a broad spectrum of industries. Dr. Watkins, you asked about ESG and you asked about D&I. At our size and scale, we have to be in the focus for all of these things. People look at us, folks like us, as the vanguard, if you will, for that type of thing. We've had ESG as a part of our organization for years now. It started because our European clients, frankly, demanded it. Our European clients were focused on the industries where we invested, the type of things we were doing with fossil fuels, for example, firearms, countries that had very poor labor and safety records, those type of things that they were not going to tolerate with their capital. So it's been a focus of ours for a long time. Leave aside any personal and moral view of what we believe ESG is. And I think we have a lot of us that believe very strongly in it. I believe economically, the world is going to shape the ESG investing into something that's going to be powerful, because you won't be able to sell assets that are not ESG compliant in the future. And that curve is changing very quickly every day. And so at Oaktree, we're very focused on making sure we stay ahead of that curve. In terms of D&I, you talked about pipeline. I'm very proud to say that both Jordan and I sit on our diversity and inclusion committee. We have for years. Our team last year, a team of 28, hired 3 members from underrepresented groups last year. And we have, I think, really something very exciting for us. And listen, to be very clear, very self-serving. We've done a partnership where we and 2 other of our peers in the industry have committed $90 million to fund a pipeline in from historically Black colleges to universities. We think this is a huge opportunity to start. The hardest part is I've seen this be in this business for 2.5 decades is you've got to get people in early. My colleague earlier said that we don't hire them right out of college because it's just hard for us. We want someone else to train them in the investment banks, and then we'll take them from there. But we're finding that that's a very difficult thing to do. We want to get them earlier than that. So we're going to the colleges and universities now and trying to drive them in and finding teaching programs and ways to build a bridge from college to Oaktree. And I think we'll be successful over the next couple of years. That, to us, culture is everything. When I look at all of our most successful investments, I look at our CEOs that win, I look at how we win at Oaktree. It's about having a winning culture. And I think the turnover rate at Oaktree is very low. Other than the rotating junior folks on our team that go every couple of years in cycles, we've had almost no turnover, certainly not any that we regret over the last 4 or 5 years. And I think during a pandemic and all the things that happened in that pandemic with working remotely and doing things on Zoom every day, it's a testament to the strength of this team. And we're very proud of that team. I'm very proud of the team we've built together. And I think we're best positioned in the marketplace that we've ever been in the history of our group. So with that, I'll pause for any questions you might have for me or Oaktree, and then I'll introduce my partner, David Quick, to come up and talk a little bit about the transaction.
That not everybody that comes before us talks about it out of the gate, so I appreciate you doing that. And
thank you.
Definitely think that organizational culture is a very important part of attracting talent, and perhaps not enough businesses emphasize that. So
100% right. 100%.
Okay. Any questions? Concerns?
Not just yet. I do have a couple. I guess the first one, business side, since that's what.
Yeah. Thank you. You as well.
First time here, right?
It is.
First time ever watching, even because we have Zoom available. You could have availed yourself of that over.
No, I want to be here in person. I'm excited to be here. It's been a long journey, and I should have said it up front. I want to thank your staff.
Sorry. You could have availed yourself to watch.
Oh, I understand now. I want to thank your staff, particularly Agents Scott Woodbar and Jason Mullins, for their professionalism. It's exceptional. Their pragmatism, their very polite demeanor throughout this very tough process, and we're just glad to be here today.
So we have a lot of materials in front of us, so we understand the philosophy that you just explained there through reading through it. I did want to understand a little bit on the business side though too, when you talked about J&J Ventures.
Yes, sir.
That's your first sort of venture into investing in the gaming side.
It is.
Okay.
It is. At least for under my leadership, that's correct.
And that's a route in building.
It is Excel's biggest competitor. We're bigger than Excel, not to poke at them, but
okay. And so this is going to be your first, again, on the machine supply side of the business.
Correct.
B2B type of situation. I guess B2B and nevertheless supply side.
Yes, sir.
How did that vetting go through? How did you go through the vetting process then with Interblock then?
Yeah, I mean the due diligence process. Yeah.
I didn't have my microphone on. You just got.
Oh, okay. I could hear you.
That's all right. Well,
let me ask my colleague quick to join me for this because he actually led the day-to-day. But what I will say here is that our diligence process was incredibly rigorous. I mean, we spent, I would say, 6 or 9 months on diligence. It's full stop. It's not just the business model. It's looking at the market. We engaged McKinsey on $1 million study to look at the supply side gaming to figure out what the dynamics were. Is this a real trend? Can we really get behind this idea? We had consultants come and look at the technology. Is their technology better than Aristocrat or some of the other competitors in the marketplace? Why do they have a right to win in this market, right? We did it on the financial side, going through all of the quality of earnings, using Big Four accountants to come in and scrub the numbers on everything they do. We looked at all the ESG materials we have. We have a proprietary model on ESG that we use to evaluate every company on a scored quantitative system. And, on top of that, we do a lot with personnel. I mean, we use a firm called BIA, which are a bunch of ex-Central Intelligence Agency, interrogators, or I don't know what they did. They don't really tell you. But they're expensive, but they find pretty much everything. It's an incredibly thorough process on the managers themselves. And so making sure that we are backing the right horses. When I said before that culture is everything in a business, the worst thing we can do is back a bad manager. And every deal that we've gotten wrong or things have not gone to plan, it's typically because we back the wrong CEO. And we've learned a lot of lessons from that. The scars that you have in this business. And I tell my kids, experience is what you get when you don't get what you want, right? So we had a lot of experience in these things, and I'd say, and I would tell you that for us, at least, getting that part right is paramount to us. And John Connolly is a fantastic CEO.
Okay, and that's kind of what I was looking for, just that process, what you were doing to vet out Interblock. Have you looked at other companies, other suppliers in this space, or?
Yeah, for the record, David Quick, having us. Yeah, we spent a lot of time in gaming in the past several years. It was a focus area for the strategy before Matt and Jordan came in as portfolio managers. Ultimately, had a Nevada license for a period of time, exited when we sold that investment, and we've really made a rededication to the sector. And really starting in early 2020 when I first met John Connolly, and that led to the J&J investment and obviously Interblock as well.
Okay.
2019.
Or sorry, yeah, we met in 2019.
But you have started to look at other manufacturers as well over the last few years as you decided to have a refocus on the industry here.
Yes.
Okay. I didn't have anything on the business side just yet.
So with that, good afternoon. Thank you for having us. I'm going to take you through the transaction, and I'll probably refer to the pages a little more, just that you have in front of you. But as I mentioned, in December of 2020, we signed a deal to acquire Interblock, 100% of the company, subject to the purchase price with ordinary course adjustments for working capital and true-up of estimates. We are excited to partner with the company, and maybe I'll take a step back. Interblock is a provider of electronic table games. They, in our opinion, are the leading supplier. They have a luxury product that is known industry-wide. They're licensed in hundreds of jurisdictions, have products really spread throughout the world. Because of that leading position, we're really excited to partner with the company, acquire the company, and partner with the management team. The ETG category as a whole, I think, has a lot of compelling dynamics. I think you've seen increasing adoption of the ETGs, particularly in North America, and quite frankly, I think COVID helped accelerate some of that demand, and it's brought in a new player base, maybe someone who was afraid to try a table because they didn't want to be embarrassed. It's really a growing market segment, so we're excited to partner and find a business in that space, but particularly the leader in that space. The company generates strong returns, very good margins, very good return on invested capital, and so obviously it checks a lot of the boxes financially. We really like the recurring revenue nature of the company. That's as a testament to John Connolly. He really built that recurring revenue model in North America once he was hired as CEO by owners of the business. And we really think this is an investment where we can provide value by being active board members. We think this is typical to most founder-owned businesses. It's a business that is just run a little bit differently, a little bit tighter purse strings. For example, one of the things in our contract that we negotiated when we were acquiring the company was for the ability of the company to hire a CFO. It had been operating without a CFO. We think there's several spaces where we can continue to invest into the business, invest into the people, add systems, and really help this business grow. So that I'll turn to page 9, which lays out planned capital structure. this business has a ton of growth opportunity and is capital intensive with a recurring revenue lease model. So they need to build the product, put it on the floor, and then you start earning your revenues over time. Because of that, we want to make sure we have plenty of liquidity for the company. And as you see, the quantum of debt here is actually higher than we probably need in order to do this transaction. But we're going to have $35 million of cash put on the balance sheet in order to have sufficient liquidity. On top of that, we're going to have a $20 million revolver, and there's also going to be a $25 million delayed draw piece of the term loan. So there's really $80 million of liquidity available to the business to support growth. And so, we, as Matt had mentioned, we try to be very conservative, try to avoid losses, we try to avoid over levering. Generating return through leverage is not how we try to set up our businesses. On the left side of the page, you'll see kind of the key terms of financing. The rate as contemplated, we think is for a company this size is actually very attractive. Importantly, from a covenant standpoint, we'll have a covenant holiday for the first year. And then after that, we'll be testing a total leverage covenant at a very wide cushion. And then I think one other item of note, I think it's worth noting that over 50% of our net capitalization, you'll see on the right, is coming from sponsor equity, which is a much higher percentage than a lot of private equity owned companies. If you turn to the following page, on page 10, it just talks a little bit about the management team. As Matt mentioned, management is so incredibly important in every investment we make. We're very, very excited to be partnering with John Connolly as CEO. He has been CEO of the business since 2015. He has 30 years of experience in gaming, previous experience as an SVP with Bally Technologies. And before Bally, he was at a division within Scientific Games and was a senior account executive at GTech. Heather Rollo, who is the CFO that the company was able to hire, John was able to hire while we've been in this period of getting licensed, has been a tremendous asset. It's a great addition to the team. Then turning to page 11, we talk a little bit about our plans for Interblock, and I've alluded to this a bit, but we think our mission will be to continue to push John and team who are running the business day to day to expand the team. I think in many of the positions they've had to do too much in each specific role. So I think investments into the R&D team will be very important. Investments into the finance team as Heather continues to build out the finance team, and quite frankly, investments into the compliance team. I think they just don't have enough bodies for the size of the business today. That'll be a key area with that. As a board member, we'll be pushing forward to make sure we're expanding, because I think they stay on top of everything, but I think given the size and scale of the company, I think it's an area that is of most importance, obviously, and an area for additional growth. So that largely takes us through kind of plans for the company. And you mentioned you had a few questions potentially about the business itself, but I just wanted
actually, you were covering a lot of the points, and I see it in here now in terms of leadership, though. So, Mr. Conley, him continuing on in his position, for instance, and then I didn't know what your view was internationally, because, it's very difficult to run a business with sort of, I don't want to call it, I guess, slim employment numbers. And covering the globe, because when you're licensed in 100+ jurisdictions, I understand what the needs are on the compliance side of the business side. Yeah, and it seemed you're without a compliance officer for a bit now. Not exactly sure what the makeup of the compliance department is, but you need that head there. So, and I know that's something you guys are looking to fix. So.
Absolutely, that is obviously we have no ability to really do much now, but as the board members, will be very focused on making sure that department is fully staffed.
I would like to get an update just from Interblock, just on where the business is at right now.
Certainly. We'll have John Connolly come up.
Mr. Chair, members, Madam Secretary, thank you for having me. John Conley, CEO of Interblock.
Just in general, just give us a world tour where the business is at right now.
Yeah, sure. So if I was to summarize pre-COVID and over the past, let's say, 2.5 years where we ended up,
As Mr. Quick was expressing, COVID had an accelerating effect on the company. I think it was a catalyst for electronic table games worldwide. It really indoctrinated a lot of new players that perhaps historically were intimidated to try table games or try electronic table games. With the closure of live table games, it really forced players over to our products. And as a result, the company's more than doubled. It's a 28-year-old company, privately founded many years ago, and in the past 2.5 years, it's more than doubled in size. And I think that's a testament to, obviously the technology and innovation of the team, but also COVID was definitely a catalyst. So as we sit today, that momentum continues. Q1 was a record quarter for the company, although we're private. We're in the process of installing, I think, close to 1,000 seats in the next 90 days. And don't really see at this point the revenue per day off these products or the trajectory and demand slowing down. So at this point, as David mentioned, we're just scaling the company to handle that kind of growth. So we spend a lot of time interviewing and hiring and building out the foundation, not only in North America, but in Europe, Asia, and Latin America. What you may find interesting is one of the biggest questions we had when we came out of COVID globally, not North America somewhat, came out much earlier than other places. Latin America seems to be next in line. Europe probably just after that, and Asia lagging last. Asia Pacific region, mainly Asia. And Latin America, as it's coming out of COVID, we're seeing similar trends for our company that we've seen in North America the past 2 years. So, things seem to be. It depends where we're talking. And in Europe, it's going very well. In Nevada itself, very competitive, very difficult market to find talent and find, the resources needed at certain categories. I think if you're looking for, non-production, more skilled labor forces, R&D, finance, sales, compliance, those sorts of positions. I think with the onslaught of online gaming entering Nevada and many parts of the United States, a lot of corporations are housing themselves in Nevada to support other states. So the demand here for talent has grown astronomically in the past 12 months. So it's difficult in Nevada, but outside of Nevada, in other parts of the world, we're having great success.
It seems we hear that story a lot. It's a very competitive market out there right now for the employment.
Very.
So the 1,000 seats or devices, well, I guess it would be seats in your case. The growth there, is that primarily North America that you're talking about?
It is. Although, as I mentioned, Latin America, in the past 60 days has really exploded as they come out of COVID and open things back up. We're seeing similar trends the past 60 days there. But yes, the majority of the past 2.5 years growth we've seen has come out of Canada. Only recently, they've had some tough situations in Canada with closures, but they're coming out. And then obviously the United States. I mean, Nevada itself, which is relevant to today, we've placed over 1,000 seats just in Nevada since COVID, and that continues to grow.
And you're primarily a recurring revenue model?
Correct. In North America, strictly recurring revenue. And there are parts around the world that we're grandfathered in with a couple of sale markets, but generally speaking, we're recurring revenue.
Starting out in Slovenia, perhaps?
Yes.
Okay.
Yes.
I see you're bringing on Marco Herrero. Did you guys work together at Bally?
We did. Yeah, I've been hiring. There's a few new people that are coming on board as well from the old Bally days.
Okay.
So reaching out to some of the old friends and some of those people, Heather, our CFO, is an example. A lot of people that have lived internationally and left North America to be in gaming due to COVID and the closures. Many people are starting to move back to the US and to Nevada. So when they do, it's a great opportunity to get some great talent.
Okay. Yeah, I bumped into both of them in my days overseas as well. So I know of them. I've never really met them though.
Yeah. So Marco, just in that sense, Marco, I hired him to have him go back to Europe and after transition He just got home and he's going to go back to Europe and run Europe for me.
Okay.
Yeah.
I just wanted to get just an overview of the business where you're at right now.
Thank you.
You were uniquely positioned in the COVID sort of pre, during, and post era, given your product set. So
Yeah, no, we've been very one of the fortunate companies.
thank you.
Thank you.
I would just note for the record that with regard to the individuals who are on here for findings of suitability, that is Mr. Wilson, Cruz, Quick, and Connolly. There were no adverse findings, so clean backgrounds. The structure seems to fit, or it does fit within 15C, so that's not problematic at all. Are there any questions? Is there anything else? Compliance plan issues that you're going to take care of?
On one of the individuals, Mr. Cruz, what's his status as an attorney? He is an actually licensed attorney. Is that correct? Or did he just go to law school?
Yeah, so I believe that he is licensed. Mr. Cruz, I'll defer to you if you want to expand.
It's not without complication. I did go to law school. I graduated from law school and I practiced law for about 3.5 years, the beginning of my career before I joined Oaktree in 2001. I maintained my license, but in an inactive status in the state of Illinois. And in 2021, I inadvertently checked the active box on the re-registration, which put me into a CLE penalty box in Illinois. So what it says now, and I think I supplied a letter to you all confirming this, is that I'm not licensed to practice law in the state of Illinois. If you're inactive in Illinois, you do not have to do continuing legal education. Of course, if you want to become active again, you have to go back and do all the CLE. I have no intent of doing it. I just kept the license, frankly, because I passed the bar and I wanted to keep the license, but I have no intent of ever practicing law again. So I'm a little bit of a never land in terms of the designation, but the bottom line is that I passed the bar. I'm technically, filing registrations with the state of Illinois, but I'm inactive and I couldn't practice law there.
Okay, thank you for explaining that. I was a little bit confused. So thank
Yeah,
you.
yeah. So was I when I figured out I'd made an error in the registration.
And if it's acceptable at this time, if there aren't any questions on Oaktree or the transaction, we can have each of the individuals provide you with a little brief background about themselves.
Yes, that'd be great. Please have them come up.
All right, then I would like to start, if I might, with Jordan Cruz, since he's on the video right now.
Okay.
Mr. Cruz,
Great.
maybe you can give a little bit of background.
Great, thanks. Good afternoon, Madam Secretary, Member Watkins, Member Castoros, Chairman Gibson. I want to echo Ms. Okerberg's comments about allowing me to do this by Zoom. I truly appreciate the accommodation. My background, which was just alluded to, is pretty straightforward. I've had 2 employers in my adult life. I graduated law school in 1997 from Northwestern in Chicago. I went to Kirkland and Ellis for 3.5 years and did corporate M&A there. I then was hired by Oaktree Capital in April of 2001. So I just finished my 21st year at Oaktree. Basically spent my bulk of my career at Oaktree, and alongside Matt Wilson, we were named co-portfolio managers of the Special Situations Group in the summer of 2014. So we've been running the group since then. And that's pretty much it.
Okay, thank you very much.
Thank you, Mr. Cruz. And now I'd like to ask Mr. Wilson to do the same.
All right, Mr. Wilson.
I'll keep it brief as well.
Thank
Originally from Cleveland, Ohio. I attended the University of Virginia with Jordan, although we didn't know each other. We were 3 years apart. I began my career in New York. I was an investment banking analyst that was talked about earlier. Did the 2-year program, cycled out as fast as I could, got into private equity at a time when it was a very different world in private equity. That was when a $400 or $500 million fund was considered a big fund. I thought I was going to stay in that career until the recession or the tech bubble burst in 2000. You probably remember, with all the internet stocks trading, and things became a lot more difficult. So I applied to the Harvard Business School. I was accepted. Thought I'd camp out there for a couple of years and learn something. And had one of the best experiences of my life. I got back into private equity on the distressed side after business school. I worked for a firm called HIG Capital in Miami for 4 years before joining Oaktree about 15 years ago. I currently live in Manhattan Beach. I've got a lovely wife of almost 20 years and 3 beautiful children.
Wonderful. Thank you.
And last but not least, I'll have Mr. Quick do the same.
All right, Mr. Quick, welcome.
I'll be brief as well. David Quick. I grew up in small town Grand Haven, Michigan. Went to the University of Michigan, and decided I had enough of the cold. Moved out to Los Angeles for 2 years with UBS Investment Bank. Did the 2-year program and jumped to Oaktree thereafter. So like Jordan, I've only had 2 employers. I'm coming up on 18 years, I believe, this summer at Oaktree. I also live in Manhattan Beach with a lovely wife and 3 daughters.
I'll just say to that, to your comment about attending the University of Michigan, go green.
Oh no, I remember that.
You know,
I will refrain from comment.
I will
Good
add to the
idea.
record that I did live in Lansing from 1979 to 1980 when my dad was getting his doctorate there. And that was the Magic Johnson years. I was 5 years old, so it was not as, I didn't appreciate as much as I might today.
Yes, a
I,
wonderful place.
I just want to add one thing, if you don't mind. I have a wife who's lovely as well and 3 children, and I don't want the record to reflect that I didn't say that when these 2 guys did it.
That's why I said it.
And that concludes our affirmative remarks. I just did want to get on the record. We really appreciate the board staff and the board agents, all of their help. I would like to specifically recognize Special Agent Mueller, Senior Agent Widmar, Agent Molitz, Deputy Chief Tagio, Supervisor Kolsnikova, and Supervisor Ava, and Chief Hoffman. All of their help. We couldn't have done this without them.
That is the A-team. Thank you very
That's
much.
right.
Okay. Any additional questions?
3 Midwest boys moving out west. All right.
Love it.
Nice. No, I didn't have any other questions. Thank you very much for being here today. Thank you very much, Mr. Cruz, as well.
Thank you.
All right. If there are no further questions, I entertain a motion.
I move to recommend approval of non-restricted item number 5 as read and directed by Secretary Bell pursuant to the following conditions. Interblock Luxury Gaming Products Ltd. shall fund and maintain with the Nevada Gaming Control Board a revolving fund in the amount of $25,000 for the purpose of funding investigative reviews by the Nevada Gaming Control Board for compliance with the terms of this condition. The Nevada Gaming Control Board shall have the right without notice to draw upon the funds of said account for the payment of costs and expenses incurred by the Nevada Gaming Control Board and its staff in the surveillance, monitoring, and investigative review of all activities of Interblock Luxury Gaming Products Ltd. and its affiliated companies.
Okay, Madam Secretary.
Member Katsouros?
Aye.
Member Watkins?
Aye.
Chair Gibson?
Aye. Thank you very much.
Thank you.
All right, we're going to take a 10-minute break for this court Let's come to order, please. We will start back up. Madam Secretary, would you please read the next item into the agenda?
Next item is non-restricted number 6, which are the applications of Kenneth Joseph Ostumpowski for licensure as a key executive and key employee of Circus and El Dorado Joint Venture LLC.
All right. Well, please come up to the Madam Secretary.
Mic's not on, right?
Mic's on. Welcome. It's good to see you, Mr. Burnett.
Good to see you, Mr. Chairman, Member Katsaros, Member Watkins. Pleasure to see you, Madam Secretary Bell. Before you today is Kenneth Joseph Ostumpowski. He is with what we call the ROW, Circus and El Dorado Joint Venture LLC, which, as you see on the title page, does business as those three properties: Silver Legacy Resort Casino, El Dorado Hotel Casino, Circus Reno. Mr. Ostumpowski is the Senior Vice President and General Manager of that entity. And he, as always, is happy to give you an overview of himself for your record, and we'll be happy to answer any questions you may have after.
Wonderful. Please step forward, Mr. Ostumpowski.
You got it.
All
There
right.
you go. Perfect. So yeah, all
About
my
you.
life I had to hear people get through this. So Madam Secretary, Member Watkins, Chair Gibson,
Welcome.
Member Katsaro. See, I can have a hard time with your last name too. So it's an honor here to be here today. It truly is. I grew up in Buffalo, New York. Yes, go Bills. So longtime fan and with two wonderful parents, two brothers. Went to the University of Buffalo and graduated with a degree in accounting. Went to work for a CPA firm, BDO, where they gave me really incredible experience of working with firms in Boston, Chicago, New York, and Las Vegas. I was part of the audit team and helped write the initial public offering for Lady Luck Gaming Corp. While during the audit, Isle of Capri was acquiring the Lady Luck Gaming Corp at the time and offered me an opportunity to come out to Nevada to be the head of finance at Lady Luck in downtown. Which is
When was that?
Grand. That was in October of 2000. So long time ago, but it was truly unbelievable. I can't tell you how excited and thrilled and honored to be back here in Nevada. I have a lot of love for it. My youngest daughter was born here in Las Vegas, so that connection is very close and dear to me. So while there, they decided to actually sell that property, but they wanted to keep me with the enterprise, so they moved me to Mississippi, then to Louisiana, which ironically, while I was operating in Louisiana, a company came in and bought the Hollywood company called El Dorado. I had no idea who El Dorado was, and I said, okay. So and then they said, hey, we're selling that property, so I want you to go up to Iowa. And then while in Iowa, they said, hey, we're moving our corporate office to St. Louis, and there's two properties we want you to run there in finance. So I moved down to Central Missouri in Columbia, where I made the decision to stay for about 10, 11 years. I wanted all four of my children to get through high school in one location rather than moving them around through the high school years. So while there, that little company El Dorado popped up again and acquired us as Isle of Capri, and where I had the honor to meet the Carano family, which truly is an honor and wonderful family. And I found that we have the same type of values in making sure that everyone's treated like family, positively and with respect. I think it's something that they hold dearly, and it's something I hold dearly. From there, they said, okay, you've spent enough time in Missouri. Why don't you go run our property in Ohio? And so I was at Columbus for a little bit. And then they're like, hey, you knocked that out of the park. Why don't you go do Black Hawk, Colorado? Okay. And then Anthony called me up and said, hey, my Uncle Glenn's retiring. Can you come run the row? And I said, I'll be honored. And it truly is an honor, as I know that is their, their patriarch grandfather, Don Carano, started all of that. And to continue on that family mentality, making sure that all the employees there, everyone feels that sense of respect, of family, knowing I got their back and we all work together. And again, it's truly an honor to be here today.
Wonderful. So you have moved a lot.
Yes, I have. Yes, I like to think that my children are diverse and that they've had a lot of perspective. So they're all wonderful kids. One's a lieutenant in the Army. He's out in Fort Knox. I'm very proud of him. My oldest daughter is actually working in gaming and slots for us. I have two other daughters who are still in Missouri going to school.
Wonderful. I mentioned that because the only blemishes on your record are just a few things, a few liens that relate to, cleanup items as you probably moved along.
I think it couldn't be. Every time I moved, you think you transfer your address forward correctly and not, and then clearly they didn't. As soon as I did, I made sure they were paid. I'd like to think that hopefully moving forward, we got that all under control.
Well, otherwise clean. I have nothing to ask, but thank you very much. Let me turn over.
It's a pleasure.
Yeah, I would say the same, is that there were just a few lien items, and I think one you may have forgotten to disclose.
Yeah, and again, I was not even aware of it when I took. Your staff was fantastic and thorough, clearly finding things that I wasn't even aware of, and I said, yeah, absolutely. So
absolutely, and I understand that you have been consistently moving about, so it seems very reasonable that you may have missed some mail or a thing of that sort, and so I'm not really concerned with it, and I'm happy to support your application.
I appreciate it. It's one of those things that I'm happy. I'm in the age of technology, I get things quickly now through email. Whereas mail, sometimes hard mail didn't always follow me quickly. So.
Yeah, the numbers we're looking at in the liens here probably cost them more to serve you with it than the actual amount.
Yeah, if I remember one was like $61 or something, I was like, yeah.
Waste management will get you no matter.
They will.
$20 or whatever you around. So no, I'll echo my colleagues' comments. Didn't have any concerns from a background perspective. I think we had met.
We have.
Okay, at a function.
Up at in our property, not our property, our corporate office in Reno.
Okay, that's where it was at. Thank you. I couldn't remember the exact location. I did want to just get briefly though, understanding again. So the intersection with the Carano family would have been around 2017.
That's correct.
Okay.
Yeah.
So now you've been at the row
since June 1st.
Okay.
Yeah.
So
yeah.
a year.
Yeah.
What's your initial thoughts? Have you made any changes? Have you brought any different perspectives from some of the other markets that you've been in?
Sure. So I think, again, the culture existed of family, and that's always something I've been living strongly. But I also try to infuse my philosophy of positivity and respect. So culture is very, very important to me. Also, leadership training. We focus a lot on being good leaders with good emotional intelligence, and I spent a lot of time working with the teams, making sure that they're viewing, we're working with our employees, with our vendors, with the community, that we exercise that same philosophy. So between leadership training, focus of culture, they're all wonderful. I'm so lucky to have a fantastic team. So there was no need to make any changes, so everybody there has completely jumped on, adopted the philosophy, and also an exercise of fun. I'm thrilled to share some of the, I won't do it now, some of the events and experiences that we've created that really has the team, everyone has commented regularly, while anecdotal, of course, just how much more fun we've been having. And I want to continue to have that because it's fun to go to work, and I want to continue to do that. So
it's not always fun to forward.
But sometimes it's not fun, but I do my best to keep that within my own head.
A lot of team building then is where you focused on a lot. Has there been anything operationally that you've drawn upon from some of the other markets you've been in and said, you know what about this and that?
Yeah, from a slot programming standpoint, one of the things I take a lot of pride in is being able to analyze the slot floor and try and make a decision on where to optimize game performance. So we've done a lot on our high limit rooms where we've been able to put some new games, finding games that customers truly want to play, And sometimes it's just adopting a different denom, putting it into the room, creating an experience, adding a feeling of it's easy to get to. Oh, I have, to create the excitement around the sense of winning every time somebody does actually hit a jackpot. So that operational element too. The other element too that I like and very proud of that I've used in other outlets is creating an additional tier for guests to be able to try to accomplish. We all know Caesars Rewards is a wonderful program, but we are looking very closely at enhancing that program. Something we did when I was in Saddle Downs when we were just El Dorado, we had a millionaires club. And so but what we did was we made it achievable so that it's an additional 10,000 tier credits or an additional 10. So now we're looking to add that here as well. And so both from a slot performance as well from a marketing customer give back, because we want to make sure our guests are feeling like we're the place to go.
Yeah, it's that fine tuning that makes all the difference. And that's a great property there, the Row, biggest little city in the world, right?
It really is. It's we're so honored and so lucky. We're about to kick off our inaugural Cinco de Mayo festival, cultural we pay a lot of attention to the cultural experiences in Reno. So we're excited to be able to offer that. We do a very large Lunar New Year festival. We always have a big Italian festival. Please come join us every October. And so we're going to continue to lean into that culture.
And so you report up to Stuart Massey.
Yes, I do.
And you're in the Mountain West region. So what does the Mountain West region entail?
Yes, the Mountain West is the 5 properties, Lake Tahoe 2 properties, the 2 properties in Black Hawk, Colorado, and Laughlin, which is it's little, yeah, it's Mountain West, but it's
right.
It does fall into its own category. So so Stu gets a chance to get down to Laughlin once as well.
Okay, well, thank you. As I mentioned, didn't have any concerns from your background. Good to see you again.
Absolutely.
Congratulations. Welcome to Nevada. Welcome back to Nevada.
Yeah, again, I'm thrilled. And I this is, my wife and I have regularly said, this is someplace we want to be for a long time.
You have 6 direct reports, is that correct?
So yeah, I have 6 direct reports. Yeah, all wonderful individuals, overseeing all the various departments. They do an excellent job.
And can you talk about a little bit about your duties and responsibilities?
Yeah, absolutely. I look at it as making sure that I am giving my team the tools they need to make sure they succeed properly, take care of our guests. So I'm interacting on a regular basis with each department head, not only on strategy, but interacting and going down onto the floor, being part of, hey, talk to the employees. How do they work? How can we improve? So my responsibilities include making sure that the strategy is properly executed. We're taking care of our team and we're taking care of our community. I have a business philosophy that I've always leaned on. It's called servant-based leadership, where I look at, I report to my team. My team doesn't report to me because I believe giving them the tools necessary to succeed. So.
Thank you.
Okay. With regard to his background, is there anything further you'd like to ask?
Nope, not from my standpoint.
Okay. All right, we've covered that then. Member Watkins, you're good?
Yeah, I'm good.
Okay. All right, is there anything further?
Mr. Chairman, the only thing on our end,
Please.
thank Agent Ashlenberg for her work on this. She did a great job. She helped Mr. Ostapowski clear up all his liens.
That's
great.
And she was professional and thorough, and I really enjoyed working with her. She did a fantastic job. I truly thank her. So
Thank you very much for that.
Yeah.
All right, I'd entertain a motion for ready.
I will make that motion. I move to recommend approval of non-restricted item number 6 is read into the record by Secretary Bell.
Madam Secretary.
Member Katsouros?
Aye.
Member Watkins?
Aye.
Chair Gibson?
Aye. Thank you very much.
Thank you all.
All right, Madam Secretary, let's go to the next item, please.
Next item is non-restricted number 7, which is the application of Sean Joseph McBurney for licensure as a key executive and or key employee of Desert Palace LLC, Corner Investment Company LLC, Flamingo Las Vegas Operating Company LLC, Harrah's Las Vegas LLC, Paris Las Vegas Operating Company LLC, Harball Newco LLC, Rio Properties LLC, PHWLB LLC, and LV Newco LLC as noted on the agenda.
Welcome.
Good afternoon again, Chair Gibson, Member Katsaros, Member Watkins, Madam Secretary. For the record, I am Erica Okerberg. I am here with the applicant, Sean McBurney. As described by Executive Secretary Bell, we are before you in connection with his applications as the Regional President of the Las Vegas operations for Caesars Entertainment, as well as the positions of General Manager for the properties Caesars Palace and the Cromwell. As I'm sure your record will indicate before you, Mr. McBurney has had a long and successful career with Caesars Entertainment, having served in various roles over 16 years leading up to today. But this is the first time he's appeared before the board. So if acceptable, I'd like to ask him to provide a brief background about himself and his job duties and responsibilities.
Please step forward, Mr. McBurney.
Madam Secretary, Member Watkins, Chair Gibson, Member Katsaros, it is a true privilege for me to be here in front of you in consideration for my licensure. I've lived in Las Vegas now for 16 years. I've worked for Caesars the entire time. I'm originally from Southeast Ohio. I graduated from Latonia High School. I went to college in Flint, Michigan at a small engineering school called Kettering University. I worked for General Motors while I went to school. I graduated as a mechanical engineer and then remained with GM at their Detroit Hamtramck assembly plant. I then went to Stanford for my MBA during the second year of business school. Harrah's was doing on-campus recruiting, and that's really where I learned about the industry. It's where I learned about the company. And I was recruited as part of their President's Associates program, which is effectively an onboarding program for those people that are graduating from business school but haven't worked in the industry. The first real job I had at Harrah's was to oversee the casino marketing team at Harrah's Las Vegas. It was a 6-person junior host team. I moved into gaming operations as the director of slot performance for Harrah's, Flamingo, and O'Shea's, and then back into casino marketing for Harrah's, Flamingo, and O'Shea's, as well as the Imperial Palace at the time. When the company acquired Planet Hollywood, I moved over to run casino marketing for Bally's Paris and Planet Hollywood. I was part of the VIP marketing group as part of Enterprise Shared Services. I was responsible for the casino marketing teams in the western half of the country. And then I moved into general management as the AGM for Bally's Paris and Planet Hollywood, then the general manager for Caesars Palace. And I've been in this role as regional president since February of 2021.
Thank you very much. That's an interesting trajectory. So from mechanical engineering to casino management, that's great.
There are more similarities in the two businesses than you might think.
What are they? Because I was interested in that as well. So
Yeah.
what are they?
When you think about manufacturing, if you're going to manufacture something at high quality and consistently, it's really all about process, and it's about having the right people. And when you look at the facilities that we have here to operate consistently, to provide service at scale with as big as these buildings are, it's about having the right people, and it's about process.
Oh, okay. Thank you. You also have some, you sit on a couple of boards. Is that correct? You want to talk about that?
Sure. I'm very proud to be on the community board of Dignity Health. Dignity is the largest nonprofit hospital group, part of Common Spirit in America. As a community board member, it's my responsibility to provide the perspective of the community to Dignity, to monitor the quality of care that they're providing to the community and help them with their mission, which is to improve the health of those that they serve. We have almost 20,000 employees in Southern Nevada, and many of them are helped by Dignity. So this is a bit of us helping them to help us. It's a wonderful organization.
Yeah. Well, you have an amazing background. You're from Michigan, or you.
Born in Ohio, but I
spent some time
went to school and spent a lot of time in Michigan for sure. Yeah.
I'm from Michigan, so.
And Kettering didn't have any sports team, so I'm agnostic to no Spartans.
I was gonna say, so
Yes.
Okay.
I'm agnostic too. I like them both. So. And I saw Kettering. I thought I was reading materials. There's a high school in Detroit called Kettering as well. And so, but obviously that's where you went to university.
That's
right. I was curious how you got from engineering over into gaming. What did you say there? Because our materials don't go back so far. Where were you working at in Chrysler?
It was General Motors, and I worked at a number of their facilities. One was the Lordstown Assembly Plant in Ohio. I worked at the Warren Technical Center, and then I worked at Detroit Hamtramck. Then between my first and second year of business school, I worked at the GM Treasury in New York City. And when I went back to business school the second year, that's when I started to look at other industries, and Harrah's was doing on-campus recruiting, and the rest was history.
Okay. I know the tech center well. It's in Warren over there. I was on 10 Mile. That's on 12 Mile.
Oh, yeah.
I know the area. So, yeah, interesting.
Okay. So Stanford, that's great. We've had a long history in gaming, done well. Background is clean. Is there anything from background you'd like to ask? Questions?
No, not on background.
No,
Okay,
no issues of concern.
thank you.
Just talk about, if I could just get a bit on your current role. You've got a very large purview here, frankly. You don't have Laughlin, as I
That's
noted
true.
on the last item.
Sure. So I'm responsible for the 9 properties in Las Vegas. We have a very coordinated and aligned operating philosophy. So, my responsibility is to create the operating plan for the market, to ensure that that operating plan meets the financial service and employee engagement objectives set forth by the senior management team. We're fortunate to have a very strong group of operators in Las Vegas. So we create these teams together. It falls to the local property teams to execute against that plan and run the business on a day-to-day basis.
And one of the first questions I had was, how have you slipped through our clutches over all these years? Because you've been in a very, key role, but it wasn't required, as I was educated on. But you've got some licensed individuals underneath you in the form of 4 general managers.
That's right. That's right.
at
And
the
I believe
property
they've
level.
all went through the licensing process somewhat recently.
Yeah, that's what it appears. So
We're happy to have your caliber of talent.
Thank you. It's an honor. It really is an honor and a privilege, and one that I take very, very seriously. We're a large employer in Las Vegas. How we operate our business reflects clearly on the industry, and that is an awesome responsibility and one that I take very seriously.
Yeah, no, I appreciate your work with St. Rose. St. Rose de Lima, right, is Old Henderson.
That's right.
My dad was on that foundation board for years and years, back when Rod Davis ran the hospital. And it's grown significantly since.
We've just celebrated the 75th anniversary.
Did you?
You can believe that. Yeah.
Thank you for your service. Okay, I have no additional questions. If
No
my colleagues don't,
questions for me.
I would ask.
Nor do I.
I move to recommend approval of non-restricted item number 7 is read into the record by Secretary Bell.
Okay, Madam Secretary.
Member Katsaros.
Aye.
Member Watkins.
Aye.
Chair Gibson.
Aye. Thank you.
Thank you very much. Thank you.
Let's go on to our next item.
Next item is non-restricted number 8, which is the application of Genting Bhd for a continuous or delayed public offering.
Okay. All right, you should just stay there.
I
Welcome.
joked that maybe I should have an anti-fatigue mat up here. Good afternoon, Chair Gibson, Member Watkins, Member Katsaros, Madam Secretary. For the record, Erica Oakberg. I am outside gaming counsel to the company Genting Bhd. Here with me today is Gerald Gardner. He is the General Counsel and SVP of Government Affairs for Resorts World Las Vegas. For purposes of the record, I would like to note that Genting Bhd has had a shelf approval in place since 2016, so that makes this the second renewal. Additionally, Genting Bhd meets the requirements of Regulation 16.115. In particular, it has at least $10 million in shareholder equity on the Bursa Malaysia exchange, and it also has filed all required reports with the exchange. And then lastly, I note for the sake of the record that the shelf order draft number 1 dated 4/13 is in proper form, and we had no comments on that. With those introductory comments, if it's okay, I'd like to ask Mr. Gardner to provide a brief update on Resorts World. Of course, as you know, we were fortunate to have an update in March from Genting Bhd CFO Yifan Wong and the executive, so we thought this would be appropriate for this forum.
Okay, please. Welcome, Mr. Gardner.
Thank you very much, Chairman Gibson, Member Watkins, Member Katsaros, and Madam Secretary. It's a pleasure to be here. And I'd also like to thank you for accommodating Genting Bhd and our CFO and again in Malaysia for allowing me to present on her behalf. I think it's 4 a.m. over there right now. But that said, I would love, I know it's only been a few months, to give just a brief update on things that are going on here in Las Vegas with Resorts World Las Vegas. We're continuing to ramp up since the beginning of, approaching actually our 1-year anniversary in June of this year. It'll be 1 year since we had our grand opening in June. So we're continuing to see a very, very significant ramp up and even a very notable uptick in property revenue and EBITDA since our last appearance in front of you in March. Casino revenue picking up very nicely. Our food and beverage experiences are looking very healthy right now. We're experiencing sellout weekends in all 3 of our hotel brands, Hilton, Conrad, and Crockford's, and just seeing a great guest energy that has come about since the variants kind of slowed things down at the beginning of the year with the Omicron in particular.
How was NFL draft weekend?
We were sold out that weekend. It was a great weekend. Again, tons of energy. The focus of the event taking place down more Central Strip kind of sucked a little bit of the life out of our property during the day, but at night we had a lot of people around and a lot of great activity. But sold out in all three of our hotel brands, so it was a great event. We have Michael Bublé performing in residency right now through the end of the weekend. Great Mother's Day weekend event, by the way. And recently just announced our summer concert series, which is going to be a series of great acts on our 5-acre pool deck outdoor concert events with some great talent. Finally, we are going to be opening up a new restaurant called Crossroads Kitchen, which is a really sort of a celebrity all vegan restaurant in Los Angeles right now. It's their first expansion. Chef Tal Ronin is bringing his first expansion of this restaurant to Resorts World, opening up on May 28th. So we're really looking forward to that. And that's really all I have to say, but it's a pleasure to be here. Thank you.
Okay. If you would, just for the record, this is a request for application for a shelf public offering. Genting Hong Kong, which has some financial challenges. This is not part of the Genting Bhd. Is that accurate?
That is accurate.
Okay. Thank you.
And you don't currently have any, or you're not contemplating any offerings at this time?
No, there are no additional public offerings being contemplated at the moment.
Ms. Okerberg laid it out perfectly for me. I didn't have any other questions. Thank you. Anything further?
I don't have anything further.
Okay. Well, thank you very much.
Thank you.
For a motion.
Yes. I move to recommend approval of non-restricted item number 8 as read into the record by Secretary Bell pursuant to shelf order draft number 1.
Okay, Madam Secretary.
Member Katsaros.
Aye.
Member Watkins.
Aye.
Chair Gibson.
Aye. Thank you.
Thank you.
Thank you.
All right. Next item, please.
Next item is non-restricted number 9, which is the application of MEI GSR Holding LLC for a transfer of interest.
Welcome.
Good afternoon.
How are you?
Chair Gibson, members, Madam Secretary. For the record, my name's Alan Stoller. I'm Chief Financial Officer of Morello Group. And continuing with the Midwest trend, I'm from Wisconsin. I also have here Mike Longi.
Hi, Mike Longi, Executive Vice President, CFO of Morello Game.
And we should have Alex Morello logged in too.
I'm on.
Great, there he is. We are here to seek approval of a transfer of a 5% interest in MEI GSR Holdings, the licensee of the Grand Sierra Resort. The 5% interest transfer would be from Louis Armona to Alex Morello. This transfer would change the ownership between Alex and Louis from a current 90%, 10% ownership to a 95-5. So it's the same owners, just a 5% shift between the two. And it would be effective within 10 days of approval by the Gaming Commission. Mr. Morello, Mr. Armona purchased the Grand Sierra Resort on March 31st, 2011, made significant improvements to the facility since that time. The sale of the 5% interest by Mr. Armona to Mr. Morello is part of his long-term estate planning, and Alex's purchase of that, I think, is evidence of his long-term commitment to the success of GSR. That's pretty much it. We're open to any questions.
Okay. Thank you very much. I put it to questions.
Sure. Can you talk a little bit about the improvements?
Alex,
you want to ask Alex or myself? I mean, the property is market leader. He's had it for over 10 years now, and it's continually being reinvested in. And right now, the rooms are being remodeled. The portico share is under remodel, and there's going to be more attractions to come on the property itself, the outdoor part of it. But continual investment, and that's why it does so well. the team members there. Not only does Alex invest in property and keep reinvesting in property, but the team members are treated well. And that's why it's the market leader in many aspects. Alex can talk about it probably more excitedly about how great the property is and what the investments have been.
Alex?
A comment? Yeah, we have spent probably in the neighborhood of over the last 10 years between $350 to $400 million, and we've done everything from the rooms to the casino floor to the outside to the restaurants. And now we've got a couple more projects ongoing, which is going to be the beautification of the lake. We have basically the lake in the back area. We're looking at doing some more improvements to the pool, and also to the, we're looking at improving the golf range and just taking it to a different level. That's it.
Any additional questions?
Nope, simple transfer for me. I didn't have any
It is
further questions.
Okay. With that,
Very
I'd ask-
straightforward.
I have no additional questions. Ask for a motion, please.
I move to recommend approval of non-restricted item number 9 is read into the record by Secretary Bell.
Madam Secretary?
Member Katsouros?
Aye.
Member Watkins?
Aye.
Chair Gibson?
Aye. Thank you very much. Thank you, Ms. Farrell.
Thank you.
We're next up.
Next item.
All right, let's go to the next item.
Thank you.
Non-restricted number 10 is the application of Alex Murillo to pledge 100% of his membership interest in Las Vegas Resort Holdings LLC, as noted on the agenda.
Okay. Welcome again. And do you just want to describe the item quickly?
We're here to seek approval of pledge, as said, of the membership interests of the Sahara Hotel and Casino to Western Alliance Bank as part of a loan package, which closed on November 5th, 2021. Those membership interests are held 100% by Alex Morello, who obviously is also the majority owner of the Grand Sierra Resort. The Sahara was purchased, as you know, on March 29th, 2018 by Alex, and he's made significant improvements to the facility since that time. Because of the Sahara's failing operation at the time of purchase, and that's a lot what Morello Group does,
right.
We a lot of times have to take over the existing debt at that time. Commercial banks can't do it until we improve upon it. That has been done. Property is profitable now. So as part of that, we refinanced what we took on of high interest debt at the time, refinanced it with Western Alliance Bank, paid off the prior debt. And now as part of the new debt package with Western Alliance, of course, they require the pledge of the full membership interest as part of that loan package. So that is what we are here for, to request approval of.
Okay, well, thank you for that explanation. I'd open it for questions.
I didn't have any questions either.
Pretty straightforward as well. I don't have any questions.
Right, well, so this is just pledge for better terms or for loan?
Much better terms, yes.
It allows you to pay down debt and gives you better terms.
Yes, saves us a lot of money in interest.
Right. Okay, I'd ask for a motion, please.
I move to recommend approval of non-restricted item number 10 is read into the record by Secretary Bell.
Okay, Madam Secretary.
Member Katsouros?
Aye.
Member Watkins?
Aye.
Chair Gibson?
Aye. Thank you. Thank you very much.
Thank you.
Thank you.
Thank you. All right, Madam Secretary, let's go on to our next item, please.
Non-restricted number 11 is the application of Stuart Edward Ritchie for licensure as a key employee of Circus LV LLC.
Hi.
Hi.
Good
Welcome.
afternoon, Chair Gibson, members of the board, and Madam Secretary. My name is Erin Elliott of the law firm Brownstein Hyatt Barber Schreck. I'm here today on behalf of Circus LV LLC and with our applicant, Stuart Ritchie, who has applied as a key employee. He's the executive vice president and general manager. He isn't new to the board. He was previously licensed in 2014, but he's prepared to tell you again about himself and answer any questions that you have.
Okay, please step forward.
Afternoon, Chairman and the board. Thank you for having me. A little about myself. I'm from Oklahoma. I hope that's okay. It's kind of close to Michigan. I'm a graduate of the University of Oklahoma. I got into the casino business almost 30 years ago. I've heard people mentioning Laughlin. That's where I got my start. I started at Harris Laughlin in 1993. I had a marketing degree from the University of Oklahoma, and that's where I started in marketing. Spent time there, a few years there, and then went to the Midwest and worked in St. Louis when the riverboats were just coming on board in the early 90s, and then got an opportunity to come back and be part of the opening team for the Paris Casino. and worked at Bally's in Paris. I held marketing positions there and the Stardust after that, which is unfortunately no longer here, Stratosphere, and my last job, I was the general manager at Prim Resorts, where I spent 10 years driving back and forth to Prim, and I still have the car to prove it. And now I'm working for Mr. Ruffin and have been there since his acquisition in December of 2019.
Okay. Thank you very much. I would just note for the record that we have no areas of concern that have been noted in the application, but my colleagues may have some questions about the property and just general business operations, so I'd open it up.
Yeah, you were involved in some consulting, is that correct?
Yes, I was.
Can you describe that?
Yeah, I had a person that I'd worked with in the industry who started a marketing and advertising company, and had considered moving to Las Vegas, and recruited me to be a partner in that business. So I spent several years kind of getting off the merry-go-round of the casino business and having holidays off and weekends off, and enjoyed a few years of that. She had started a business that was working with a lot of Native American tribes and riverboats who were not quite as sophisticated in their marketing efforts. So it was a nice business venture. And spent a few years doing that, but got the itch to get back into the business after sitting on the sidelines for a while. But that was the work in consulting.
Okay.
Just real briefly, how's the property going right now? I know you guys are going to benefit a lot from the opening of the convention center when the lights are fully turned on, all the traffic starts flowing.
Yeah, looking forward to that. It's a very busy job. Mr. Ruffin has taken great pride in trying to bring the property back to its glory, and we've got a lot of projects and have completed a lot of projects in the first couple of years. We've added a food court. We've added 4 new rides to Adventure Dome. We've expanded Midway. We're in the process of building a new pool. I'm replacing all of the elevators, the hotel elevators, and a lot of HVAC units, and the list goes on and on. And every time he's at the property, it's all about what can we do to make it better. So it's been a whirlwind. We've done very well since the time he took over financially. So the investment is working, and it's a pleasure to be at such an iconic property.
Okay, thank you for that.
Okay. Anything further?
No, you've worked in the gaming industry for a long time, and there are not any issues or concerns. So I'm happy to support the application.
As am I. And it's good to have someone who we know well in front of us. So ask for a motion, please.
I move to approve. I move to recommend approval of non-restricted item number 11 as read into the record by Secretary Bell.
Madam Secretary?
Member Katsouros?
Aye.
Member Watkins?
Aye.
Chair Gibson?
Aye. Thank you. Thank you. Let's go on to our next item, please.
Non-restricted number 12 are the applications of Phyllis Ann Gillen for finding of suitability and or licensure as an officer, director, manager, and or key executive of Golden Entertainment, Inc., Golden Casinos Nevada, LLC, Golden Holdings, Inc., 77 Golden Gaming, LLC, Golden Gaming, LLC, Stratosphere Gaming, LLC, Aquarius Gaming, LLC, Arizona Charlie's, LLC, Fresca, LLC, Colorado Bell, LLC, and Edgewater Gaming, LLC, as noted on the agenda.
Welcome.
Thank you. I started to say good morning, but good afternoon, Chair Gibson, Member Katsouros, Member Watkins, and Madam Secretary. I was going to laugh and tell you about my background, but it starts with the first person I met for the Gaming Control Board was A.G. Burnett when he came out unannounced to American casinos to review our board meetings for compliance purposes. So that is how long ago that was. So my background is really quickly law school, KPMG, Principal Financial Group, mergers and acquisitions, Principal Financial, International GC, mergers and acquisitions, accounting at night during law school, and so a few odd and turns, large national construction company, back to Principal Financial Group, large national construction company with Goldman Sachs. I came when Carl Icahn sold American Casino Group to Goldman Sachs, and the rest is history. Golden bought American Casinos, and as they sometimes like to say, you're one of the girls standing. So the women. So that's my background.
Okay. And just for the record, you're here for finding suitability for the positions that the late Sean.
Yes. Sean Higgins had through 2020, fall of 2020.
Wonderful. We know you well, and I won't make the joke about lawyers representing themselves.
You know, I thought about that as I was sitting there and everybody else was bringing everybody up, but I watched every and I think we're good. So hopefully.
Okay, any questions?
Oh, you're well known to us. I don't have any questions or no areas of concern.
You are well known to us, and you've always been honest with me, straight, taking responsibility for things even when they broke down. So I appreciate that very much.
So
There's a lot about your character.
I laugh and I say my street cred's very important to me.
Yeah.
That's pretty much what you have at
Street
this point.
credit.
Street
That's it.
cred.
That's it.
You all have my phone number and that's very important. And like to take care of things as they come up.
Yeah, I didn't have any questions either. Clean background, been licensed, what, 10 years ago, right? Just
2009, 10, yes.
okay. Anyways, happy to support your application. Good to see you here again.
Thank you.
Ask for a motion, please.
I move to recommend approval of non-restricted item number 12 is read into the record by Secretary Bell.
Okay, Madam Secretary.
Member Katsouros?
Aye.
Member Watkins?
Aye.
Chair Gibson?
Aye.
I would also like to thank Senior Agent Eric, I'll ruin his name, Bartholomew. He was very nice and worked with me very well. I appreciate it.
Thank you.
Thank you. Have a good afternoon.
All right, let's go to our next item.
Next item is non-restricted 13, which is the application of Jacobs Entertainment, Inc. for a pledge as noted on the agenda.
Welcome.
Good afternoon once again, Chair Gibson, members of the board, and Madam Secretary. Erin Elliott with the law firm Brownstein Hyatt Farber Schreck, appearing today on behalf of the applicant, Jacobs Entertainment. With me should be Brett Kramer, the CFO of the company, appearing via Zoom. Give it a minute. I know he's been watching and patiently waiting to join.
There we go.
There we go. Hi, Mr. Kramer.
I am
Okay,
here.
he's here. So the application before you today, Jacobs Entertainment recently entered into a credit agreement whereby it pledged its membership interests in the Nevada licensees. Those pledges, they aren't effective until the commission approves them. So we're hoping to get your recommendation for approval today. And Brett and I, Mr. Kramer and I can answer any questions you might have on the application.
Okay, thank you very much. So any questions, colleagues?
Just the row, sorry, not the row, excuse me, the Neon District. What's going on there? Are you going to use some of this capital, I imagine, obviously, for the upgrades and developments? If you could share a little bit.
Sure. I could speak a little bit to that. Mr. Jacobs, individually and through his trusts as our owner and CEO, has a background in urban development. So with his passion for that and the opportunity to expand a bit beyond our casino operations, we believe it's going to enhance our areas and Reno's downtown area as well. Also, being a private company, we have a longer time horizon for the return on invested capital. And so excited to be able to help the city and also enhance our properties. We started a very difficult process of accumulating properties back in 2016. We've accumulated about 28 acres of land in the vicinity between our two properties in Reno that we've named Reno's Neon Line District for future development. We've done 42 assemblage acquisitions under Jacobs Entertainment and another 18 with related entities for that opportunity, both for guests and for workforce housing. We've currently constructed 7 art plazas on the spine of 4th Street and have an 8th under construction today. This provides a new pedestrian connectivity between our 2 casinos, and properties in the area have space for festival grounds and events during the summer as well. Next week, we're actually breaking ground on an apartment complex for 60 units and on this, it's 2nd and Arlington. And that follows up an area called Renova Flats that we opened a little bit previous to COVID. We currently have 2 land parcels that are available to sale to developers for market rate apartments to help the growing need for housing in the area as well.
Okay, thank you for that.
Sure.
We have some additional plans for a zip line, an amphitheater, and
Oh yes, we've master planned an awful lot out there. So we've got a lot of exciting stuff as we move forward, but it's a pretty long-term thought process.
sounds very exciting.
It's
Thank
great
you
for the
that.
city. Sure.
Yeah.
Okay. Well, let's see here. So just quickly summarize the use of the funds or request. Assuming this is approved, what you'll do with the
use of the funds. Do you wanna
What's that?
address
Oh, the use of the funds. Yeah. So we had a $50 million revolver that was coming due in February. So it was a good time to refinance the company. We increased the revolver from 50 million to 80 million. And then we also had $385 million in bonds that were coming due in 2024. And we went ahead and refinanced those. So they're now due in 2029. And we increased that from 385 million to 500 million, which is giving us the financing to do some of this work. And we're also extensively renovating the Sands property as well, which will also be rebranded here within the next year and a half.
Okay, great. All right. Any further questions?
Nope. I don't have anything further.
All right, ask for a motion, please.
I move to recommend approval of non-restricted item number 13 as read into the record by Secretary Bell.
Madam Secretary.
Member Katsaros?
Aye.
Member Watkins?
Aye.
Chair Gibson?
Aye. Thank you.
Thank you.
Thank you.
All right, thank you.
All right, let's go on to our next item, please.
Next item is non-restricted number 14, which are the applications of Elko Resorts Operator LLC and Wendover Resorts Operator LLC for the pledges and to grant possessory security interest as noted on the agenda.
Welcome.
Good afternoon. Chair Gibson, Member Katsaros, Member Watkins, Madam Secretary. For the record, my name is Glenn Light with the law firm Lewis Roker, and I'm accompanied at the podium by Eric Person, who is the president of the Wendover and Elko properties, and Corey Hatton, who is the treasurer of the Wendover and Elko properties. And I'd like to note that Mr. Hatton does have an application on file with the board. So in a nutshell, I should also say in the audience is Justin Beltram, who is the COO, and Kim McCabe, who is the Senior Vice President of Compliance. In a nutshell, in September 2021, Maverick Gaming, which is the landlord entity for the Wendover and Elko properties, refinanced its existing debt. The loan was secured by a pledge of the membership interests in the 4 Nevada licensees, and we are here today to seek approval of those pledges. If you have any questions, I'm happy to turn the podium over to Mr. Hatton, and then following that, we can address the proposed licensing conditions.
Okay. All right. Do we have any questions about the pledge? No?
No.
Okay. So let's follow up on our discussion last month.
Absolutely. So we have 4 license conditions. 2 of those are to do with a compliance plan, and then the other 2 are to do with a revolving fund. For the compliance plan, we went ahead and filed a draft with the Gaming Control Board 4 days after the Gaming Control Board hearing. So that is currently being reviewed. We reached out to them yesterday, and it's still in review. We've also put together a compliance committee, which includes Shirley Springer, who is the former chief of the audit division. So she's going to bring just a wealth of expertise to the commission.
And she's not going to let you get away with much. I'll tell you that.
No, she won't. Other than that, I don't really have any additional updates at this time. If you have any questions.
Before we open it to questions, I just note that I've met with your colleagues, your clients, and following that meeting, I'm more comfortable with your trajectory. And despite the large number of violations early on, yeah, I think you're headed in the right direction. So thank you for getting that compliance plan in so quickly. And thank you for your willingness to meet and to help us understand where you're going.
Perfect. Thank you.
Colleagues.
As we talked about last month, there were a significant number of compliance issues and understanding that those numbers have been brought down from the historic compliance issues. I agree with my colleague that you are on the right path, but I note that there was, I was concerned last month with regard to the amount of time being spent on property by upper level management, and just hope that maybe you have an update about the time management is spending on property.
Absolutely.
Does want to speak to that?
I think we addressed it for the most part at the last month's meeting, but again, sorry, Justin Beltram, COO for the record. But yeah, Mr. Frayne lives up there now. He spends considerable amount of time on property, as well as he lives just an hour away, which is the closest housing we could find for him at the time. And Mr. Sirianni spends a significant amount of time in Elko. So we believe we have both cities covered with full-time people.
Well, so last month, my understanding was, from my staff, that had not been historically been the case, that there was enough time being spent by the leaders in the organization. So has that changed, is my question, since the last time we spoke?
For Mr. Frayne's housing, yes, he was based out of state, but now he's in northern Utah. So he is there driving that was the closest housing again. So
Northern Utah, you mean Park City?
No, he's actually in South Jordan.
Oh,
So
is he?
he's closer. It was so he's about an hour and a half. I have a house in Park City, but
oh, that's right. Yeah.
I do. But again, I still reside in Las Vegas. My family is here in Vegas, but Mr. Frayne moved to northern Utah.
Okay.
So he is there.
Well, thank you. I appreciate that.
Mhm.
So you've seen the conditions and you're amenable to the conditions. Is that correct?
Yes, we have, and we have no revisions.
Yeah, from my recollection, it was more of the refocus on the Wendover properties that was needed. It looked like you had the Elko properties sort of in check. It's kind of replicate that over there. Easier said than done. I don't know.
Much easier.
Yeah.
It's a smaller city, so getting the boots on the ground is a little tougher. But yeah,
That hour distance, is that we're talking about from Elko to Wendover, or are we talking about from Salt Lake to?
From Salt Lake to Wendover. So he lives
one or the other.
Yeah, Keith lives in Utah. Steve lives in Elko.
Okay.
Okay. Well, look forward to seeing and approving hopefully this compliance plan, which is something that we will go through carefully. With that, I'd ask for a motion, please.
I will make that motion. Brace yourselves. It's going to be a long one. I move to recommend approval of non-restricted item number 14 as read into the record by Secretary Bell pursuant to the following conditions. Elko Resorts Operator LLC shall establish and maintain a gaming compliance plan for the purpose of, at a minimum, performing due diligence, determining the suitability of relationships with other entities and individuals, and to review and ensure compliance by Elko Resorts Operator LLC and any affiliated entities with the Nevada Gaming Control Act, the commissions, regulations, and the laws and regulations of any other jurisdiction in which Elko Resorts Operator LLC and any affiliated entities operate. The plan, any amendments thereto, and the members of the Gaming Compliance Committee, one such member who shall be independent and knowledgeable of the act and regulations shall be administratively reviewed and approved by the chair of the Nevada Gaming Control Board or by the chair's designee. Elko Resorts LLC shall amend the plan or any element thereof and perform such duties as may be requested or assigned by the chair of the Nevada Gaming Control Board or by the chair's designee relating to a review of activities relevant to continuing qualifications of Elko Resorts Operator LLC under the provisions of the act and regulations. Wendover Resorts Operator LLC shall establish and maintain a gaming compliance plan for the purpose of, at a minimum, performing due diligence, determining the suitability of relationships with other entities and individuals, and to review and ensure compliance by Wendover Resorts Operator LLC and any affiliated entities with the Nevada Gaming Control Act, the Commission's regulations, and the laws and regulations of any other jurisdiction in which Wendover Resorts Operator LLC and any affiliated entities operate. The plan, any amendments thereto, and the members of the Gaming Compliance Committee, one such member who shall be independent and knowledgeable of the act and regulations shall be administratively reviewed and approved by the chair of the Nevada Gaming Control Board or the chair's designee. Wendover Resorts LLC shall amend the plan or any element thereof and perform such duties as may be requested or assigned by the chair of the Nevada Gaming Control Board or the chair's designee relating to a review of activities relevant to the continuing qualifications of Wendover Resorts Operator LLC under the provisions of the Act and regulations. Elko Resorts Operator LLC shall fund and maintain with the Nevada Gaming Control Board a revolving fund in the amount of $12,000 for the purpose of funding investigative reviews by the Nevada Gaming Control Board without limiting for foregoing. The Nevada Gaming Control Board shall have the right without notice to draw upon the funds of said account for the payment of costs and expenses incurred by the board and its staff in the surveillance, monitoring, investigative review of all activities of Elko Resource Operator LLC and its affiliated companies.
I think we need to add a couple words in condition 1 and 2. I think the word operator got left off on both conditions. In the last sentence of each condition should say the beginning of the sentence should say Elko Resorts Operator LLC. And in the second condition, it should say Wendover Resorts Operator LLC. Somehow those two got dropped off and buried in.
Okay, so noted. And the final condition, I believe, is where I was. Wendover Resorts Operator LLC shall fund and maintain with the Nevada Gaming Control Board a revolving fund in the amount of $12,000 for the purpose of funding investigative reviews by the Nevada Gaming Control Board without limiting the foregoing. The Nevada Gaming Control Board shall have the right, without notice, to draw upon the funds of said account for the payment of costs and expenses incurred by the board and its staff in the surveillance, monitoring, and investigative review of all activities of Wendover Resorts Operator LLC and its affiliated companies.
Okay. Wow. Madam Secretary.
Member Katsaros.
Aye.
Member Watkins.
Aye.
Chair Gibson.
Aye. Thank you very much.
Thank you. And we'd just like to thank Agent Brad Barnard for his work.
Thank you.
Thank you. All right. Madam Secretary, let's go to our next item, please.
Next item is non-restricted number 15, which is the application of Nevada Restaurant Services, Inc., doing business as Points Casino number 211 for a non-restricted gaming license.
Welcome.
Good afternoon, Chair Gibson, members Watkins and Consaros. Madam Secretary, for the record, my name is Cannon Smith, and I'm General Counsel for Nevada Restaurant Services. With me today is Paula Graziano. She is NRSI's president. And we're before you today on non-restricted application, or non-restricted item number 15 for NRSI's application to conduct a one-day opening at Points Casino number 211. The one-day opening is necessary to preserve the non-conforming use at the location. NRSI and myself, I'd really like to thank Agent Amber Dastrup for her work on this application and the previous applications. And in discussions with her, it seems we may have found a way to, the next time we're up, have it on for a permanent licensure, maintain the license instead of having to come up every 6 months. Happy to answer any questions.
Thank you. I just like to ask Ms. Graziano if she'd like to make an appearance.
I
Welcome.
am Paula Graziano, and I just want to say I'm happy I'm not in Wendover anymore. I'm happy to answer any questions you guys might have.
All right, so we're attempting to preserve a grandfather. All right, I'd ask for any questions.
You spent some time in Wendover?
Yes, I did.
That's nice. No, it's very clear. I'm glad you guys found a path or a mechanism to be able to avoid having to do this. what is it, 6 months for doing it?
It's been every 6 months.
Every
Yeah,
6,
due
okay.
to the Clark County's code. It's on a 6-month time.
Okay. Mm.
So apparently there was some redesign in this. Can you talk about that a bit?
Yeah, it's just making sure that we're putting our building or our entrances, where we need to. We've also talked with Clark County about the best way. So this property may have had some issues in the past, but the best way to keep it the safest safest possible for the community.
Oh, so it was the the redesign was for security purposes? Or
That and ease of our guests to enter and
Raise the seal.
monitor the parking lot.
Oh,
and
right.
stuff like that.
Okay, just curious. I'm happy to support the application. It's straightforward.
Okay, so plans are to operate 16 machines.
Correct. 16 machines and a trailer.
Right, okay. All right, with that, I ask for a motion, please.
I move to recommend approval of non-restricted item number 15 as read into the record by Secretary Bell pursuant to the following condition. The location is limited to the operation of slot machines.
All right, Madam Secretary.
Member Katsouros?
Aye.
Member Watkins?
Aye.
Chair Gibson?
Aye, thank you very much.
Thank you very much.
Thank you.
Thank you.
All right, Madam Secretary, let's go to number 16, please.
Number 16 is non-restricted. Non-restricted 16 is the application of United Coin Machine Company doing business as Century Gaming Technologies, doing business at Moulin Rouge Hotel and Casino for a non-restricted gaming license.
Good afternoon, Chair Gibson, Member Casaros, Member Watkins, and Madam Secretary. For the record, my name is Debbie Cornine. I am with Century Gaming Technologies, and also with me today is Mr. Glenn Light. He will be here answering any questions you might have with regard to RH Capital LLC, the entity in which we entered into a space lease agreement with to conduct a one-day operation at the property formerly known as the Moulin Rouge. If you have any questions, I'm here to answer anything.
You're the compliance director, is that right?
For Century, yes.
Yes. Well, you've got some work cut out for you.
I have a lot of work coming
Yeah.
my way and hopefully some additional staff.
Yeah, lucky to have you.
I wanted to get that on the record.
I wanted to ask you. Right. Okay, let me open it up for questions.
I don't have any questions. Pretty straightforward. to me.
I don't have any questions either. Thank you.
I've done this a few times.
Yeah, all right. With that, I'd ask for a motion.
Chair Gibson, I move to recommend approval of non-restricted item number 16 as read into the record by Secretary Bell pursuant to the following condition. The location is limited to the operation of slot.
Madam Secretary.
Member Katsouros?
Aye.
Member Watkins? Chair Gibson?
Aye. Thank you.
And thank you very much.
All
Appreciate
right,
it.
that ends our 9 a.m. agenda. And we are past 1 o'clock, so we can begin, but I need to get my book. So let's take a 5-minute break. Thank you.
Whoa, I didn't switch over.
Let's come back to order, please. So, Madam Secretary, let's proceed with our restricted consent agenda, please. There are no questions or issues associated with these items. No appearances required.
The items on restricted consent are restricted number 5, which is the application of Nevada Restaurant Services, Inc., doing business as Dottie's number 217 for restricted gaming license. Restricted 6 are the applications of Gusar Sodar Corp. to receive a percentage of revenue from Century Gaming Technologies, doing business at 7-Eleven store number 27438, and Amandeep Bath for licensure sole officer, director, and shareholder, as noted on the agenda. Restricted 7 are the applications of Pata Enterprises, Inc. to receive a percentage of revenue from Century Gaming Technologies, doing business at 7-Eleven store number 32780, and Satinder Paul Pata for licensure as sole officer, director, and shareholder, as noted on the agenda. Restricted 8 are the applications of Lottie Inc. to receive a percentage of revenue from Century Gaming Technologies, doing business at 7-Eleven store 29656, and Rajit Dhillon for licensure as sole officer, director, and shareholder, as noted on the agenda. Restricted 11 is the application of Sartini Gaming LLC, doing business at All Star Bar and Grill for restricted gaming license. Restricted 12 is the application of Shortline Gaming LLC, doing business as Shortline Gaming, doing business at U.S. Market Lake Mead for restricted gaming license. Restricted 13 is the application of Shortline Gaming LLC, doing business as Shortline Gaming, doing business at U.S. Market for restricted gaming license. Restricted 14 is the application of Crawford Coin Inc., doing business at Green Valley Grocer number 74 for restricted gaming license. Restricted 15 is the application of Jet Gaming LLC, doing business at Terrible's number 430 for restricted gaming license. Restricted 16 is the application of Jet Gaming, doing business at Terrible's number 429 for restricted gaming license. Restricted 17 is the application of Jet Gaming LLC, doing business at Terrible's number 428 for restricted gaming license. Restricted 18 is the application of Jet Gaming LLC, doing business at Terrible's number 432 for restricted gaming license. Restricted 19 is the application of Jet Gaming LLC, doing business at Terrible's 433 for restricted gaming license. And restricted 20 is the application of Jet Gaming LLC, doing business at Terrible's number 431 for restricted gaming license.
Okay, would either of you like to hold out anything?
No, sir.
All right, I'd ask for a motion, please.
I move to recommend approval of restricted item numbers 5, 6, 7, 8, 11, 12, 13, 14, 15, 16, 17, 18, 19, and 20 pursuant to the following conditions. As to item number 12, the surveillance system and/or mirrors must be inspected and approved by the Nevada Gaming Control Board Enforcement Division within 60 days of issuance of the state gaming license, and thereafter be maintained at or above the standard that is approved. As to item number 13, the surveillance system and/or mirrors must be inspected and approved by the Nevada Gaming Control Board Enforcement Division within 60 days of issuance of the state gaming license, and thereafter be maintained at or above the standard that is approved. As to item number 14, the surveillance system and/or mirror must be inspected and approved by the Nevada Gaming Control Board Enforcement Division within 60 days of issuance of the state gaming license, and thereafter be maintained at or above the standard that is approved. As to item number 15, the surveillance system and/or mirrors must be inspected and approved by the Nevada Gaming Control Board Enforcement Division within 60 days of issuance of the state gaming license, and thereafter be maintained at or above the standard that is approved. As to item number 16, the surveillance system and/or mirrors must be inspected and approved by the Nevada Gaming Control Board Enforcement Division within 60 days of issuance of the state gaming license, and thereafter be maintained at or above the standard that is approved. As to item number 17, the surveillance system and/or mirrors must be inspected and approved by the Nevada Gaming Control Board Enforcement Division within 60 days of issuance of the state gaming license, and thereafter be maintained at or above the standard that is approved. As to item number 18, the surveillance system and/or mirrors must be inspected and approved by the Nevada Gaming Control Board Enforcement Division within 60 days of issuance of the state gaming license, thereafter be maintained at or above the standard that is approved. As to item 19, the surveillance system and/or mirrors must be inspected and approved by the Nevada Gaming Control Board Enforcement Division within 60 days of issuance of the state gaming license, and thereafter be maintained at or above the standard that is approved. As to item number 20, the surveillance system and/or mirrors must be inspected and approved by the Nevada Gaming Control Board Enforcement Division within 60 days of issuance of the state gaming license and thereafter be maintained at or above the standard that is approved.
Okay, thank you. Madam Secretary.
Member Katsaros.
Aye.
Member Watkins.
Aye.
Chair Gibson.
Aye. Thank you. Let's take number 10 out of order. Is a request for withdrawal.
Restricted number 10 is the application of Sartini Gaming LLC doing business at Juan's Flaming Fajitas and Cantina for a restricted gaming license. You also have the request to withdraw the applications of JFFC2 LLC doing business as Juan's Flaming Fajitas and Cantina, Juan Vasquez and Darcy Vasquez as noted on the agenda.
Okay. Any discussion on the request to withdraw?
I don't have any discussion.
I don't have any. Either of you like to make a motion
I'll make that
regarding
motion.
that item?
I move to grant the request to withdraw without prejudice.
Secretary.
Member Katsaros.
Aye.
Member Watkins.
Aye.
Chair Gibson.
Aye. Thank you. All right. So regarding the remaining application for restricted gaming license, Sartini Gaming. Any discussion?
None for me.
No?
I didn't either.
All right. Would either of you like to make a motion, please?
I move to recommend approval of the remaining application and restricted item number 10 as read into the Secretary Bell.
All right. Madam Secretary.
Member Katsaros.
Aye.
Member Watkins.
Aye.
Chair Gibson.
Aye. Thank you. All right. Let's step into our agenda then. Madam Secretary, that brings us to restricted items that were held out. So we take 1 and 2 together.
Restricted number 1 is the application of JR Tavern Holdings LLC doing business as Fred's Tavern for restricted gaming license and the applications of Richard Slaw and Stephen Ellis Jr. for licensure as a member and manager. Restricted 2 is the application of RJ Tavern Group LLC doing business as Fred's Tavern for restricted gaming license and the applications of Richard Slaw and Stephen Ellis Jr. for licensure as a member manager.
Welcome.
Welcome. Thank you. Good afternoon, Chairman, members of the board, and Madam Secretary. My name is Serena Choi with National Licensing Services, representing the clients, Mr. Rick Slaw to my left and Mr. Stephen Ellis to my right. The applicants are applying for 2 tavern locations. They are known as Fred's Taverns. Our initial due diligence during the review, when we did the applications, we were informed that there was an information that was omitted on the application. It was in complete oversight. So I wanted to just address that. When we did our initial review for both applicants, we pulled FBI reports. We also do TLO background checks. When we did that due diligence, there was nothing that was reported or there was nothing that we didn't find that we didn't put on the record. So we listed everything that was on the forms. When we were notified by Agent Peters, he found an item with Mr. Ellis's background, which was a driving with a suspended license. As soon as we were aware and informed, Mr. Ellis did obtain his driving record from both Wyoming and Utah. He did provide a explanation to Agent Peters. And so we're hoping that that would answer the question as to why it was omitted. It was just a complete oversight. Again, it was not intentional. Mr. Ellis did disclose all of his other matters in his PHR. So again, he understands that this is a privileged license and that information is always complete. It does ask for all details. And so again, he apologizes for the oversight, but we did notify Agent Peters immediately about the suspended license, and we did answer any questions that he had. Both applicants have signed up for the June compliance course and have a licensed slot ride operator for both locations. With that, we are here to answer any questions that you may have.
Thank you, Ms. Choi.
Thank you, sir.
Mr. Ellis, please step forward. Good there. Please state your name for the record.
Stephen P. Ellis.
Okay. Thank you for appearing today in person. Would you please describe the incident that we're talking about? Omission.
Yeah, something I completely I forgot about. It was 20 years ago. It was a night that we was out with friends, and I was actually the designated driver that night, and I'm the one that got arrested because I forgot about. Well, I didn't know my license was suspended because it was in Utah, but I was living in Wyoming at the time, so I had no notification. And after that night, I believe it's the next month, I swapped my Utah license to Wyoming and got it all straightened out after that.
Okay. All right. Well, I will open it for questions.
Were there any other driving related issues?
In 2 years later, yes, I had a alcohol related incident in Utah. And I disclosed that.
What was your license suspended for?
It was for a lapse on my SR22.
Which is?
I had an SR22. It's for high-risk driving for too many speeding tickets.
Ah, okay. Understood. Yeah, so that's when you didn't disclose. Yeah, I just want to understand that because I was reading through, I couldn't recall, and I didn't know what an SR22 was, and I failed to ask.
Yeah, they're based on point system, so too many speeding tickets or a DUI or something will force you.
Okay.
Sorry.
And as you just mentioned, so there was basically 3 items that you should have reported or disclosed. There's 2 of them that you did. The other one I would consider probably the most minor. Well, I don't want to say the most minor, but equally non-egregious. And so I can understand the oversight there. But as Ms. Choi mentioned, you realize this is your obligation to report. It is your obligation. Should you get a favorable vote here today as a licensee to maintain compliance with our rules and regulations, some of that has to do with reporting to us. So
Absolutely, yes, sir.
because it is a privileged license, as she mentioned.
Yes, sir.
There was also an issue of a lien. Is that correct?
Yes, ma'am.
Can you talk about that a bit?
Before I moved out of Wyoming, I cashed out a 401k to redo my whole entire backyard so I could get the value of my house up. And it was just a oversight with the taxes that was paid, but I paid it off, and I didn't even know that they were after me until they slapped that lien off my house after I moved to Nevada.
And it's my understanding that you're disputing the issue. Is that?
My accountant is definitely, he's trying to dig into every bit of why, because when I had when I cashed it out, because I wasn't working for Baker Hughes anymore, I had them pay 50%. I had them pay more than needed for the taxes. So I didn't have any problem. So if I remember right, it was 120,000 and I had them take 60,000 paying taxes because it's a 40% already. So I had them just take the next 10.
Okay.
And so he's still working on that. We are not getting anywhere with it yet, but.
Okay. All right. Thank you for that.
Okay. Are you satisfied as to the omission?
Yeah, I am satisfied.
I'm satisfied and happy to support the application.
And you work for Kinder Morgan, is that right?
Yes, sir.
Okay, so you're in Wyoming?
I'm actually in Houston, Texas.
Houston. So please state your name for the record, make an appearance.
Richard Elvenslaw.
Okay, welcome.
Thank you.
Appreciate you coming out and appearing.
Thank you guys for your time.
Okay.
So this is going to be the first venture in a bar business.
Together, yes.
Yeah, together for you guys.
We've
First
known
time.
each other for quite a while, so
Sorry.
it's time to expand our horizons outside of the oil and gas industry. So,
Okay, yeah. What made you decide to want to do this?
well,
Was there a coming of the minds over a beer at some point, or
there you,
what
that's the
happened?
best, I couldn't put it better myself right there. It
Okay.
was just a discussion and an opportunity as well.
Any other ties or connection in Nevada though in terms of businesses? Mr. Ellis?
I own 702 well service. It's I rent out equipment to the oil field. Plus I have SE consulting where I do consulting work, oil and gas companies. Where I was in travel into Utah, North Dakota, Wyoming.
Okay.
And I was helping get their oil wells put on production and the whole completion.
So this question is about ties to Nevada.
Oh, Tyson, Nevada.
Yeah.
Yeah, just 702 well service. I have a Bobcat. I will run and do some dirt work in town for people.
Okay.
That's about it.
Okay. So oil and gas, now bars. Okay. Well, I didn't have any questions on your background, Mr. Slaw. It's clean. But as part of our process, this is the licensing procedure that you go through first, us and the commission later on. So it's nice to meet you both. I'm satisfied. Thank you.
Thank you. Okay, I'd ask for a motion.
I move to recommend approval of restricted item number 1 as read into the record by Secretary Bell pursuant to the following conditions. The licensee shall demonstrate successful completion of a regulatory compliance seminar for restricted licensees, which is deemed acceptable to the Nevada Gaming Control Board chair or the chair's designee within 90 days of the issuance of the state gaming license. This condition may be administratively extended by the Nevada Gaming Control Board chair or the chair's designee. Prior to the issuance of the state gaming license, the licensee shall enter into a service contract with the licensed slot route operator. The term of the contract shall be for at least a 1-year period of time.
Please.
Member Katsouros.
Aye.
Member Watkins.
Aye.
Chair Gibson.
Aye. Thank you.
Thank you so much.
All right, so item 2.
Oh, that's right. Number 2, I apologize.
It's okay. Watkins, would you read? Did you make a motion for item 2, please?
Oh.
Okay.
I move to recommend approval of restricted item number 2 is read into the record by Secretary Bell pursuant to the condition that the licensee shall demonstrate successful completion of a regulatory compliance seminar for restricted licensees, which is deemed acceptable to the Nevada Gaming Control Board Chair or the chair's designee within 90 days of the issuance of the state gaming license. This condition may be administratively extended by the Nevada Gaming Control Board Chair or the chair's designee.
Okay, thank you. Secretary.
Member Katsouros.
Aye.
Member Watkins.
Aye.
Chair Gibson.
Aye. Thank you.
Thank you again.
Thank you. Thank you for bringing. All right, let's go to number 3, please.
Next item is restriction number 3, which is the application of Double Dice RV Park LLC doing business as Double Dice RV Park Bar and Grill for restricted gaming license, and the applications of Travis Shumway and Jonathan Lund for licensure as member and manager.
Welcome.
Thank you. Good afternoon, Member Watkins, Member Katsaros, Chair Gibson, and Madam Secretary. For the record, Jennifer Gaynor from J. Gaynor Law, here with the applicants for Double Dice RV Park and Grill, and I have with me the 2 co-owners and managers of the LLC, Mr. Travis Shumway and Mr. J.J. Lund. Both Mr. Shumway and Mr. Lund are longtime business owners focused on the construction and healthcare industries. Both are new to gaming in Nevada and look forward to operating as part of our state's great gaming industry at the Double Dice and Elko. They understand the board would like them to have some additional assistance with operation of gaming, given that they are new to the industry. They are in talks with a slot route operator. They also have a longtime gaming employee manager, Shauna Shull, who will be applying as their key employee. Although they are prepared to accept these conditions, we did have one request. Would there be any consideration of removing the slot route operator requirement condition, given that Shauna Shull, who is their manager, has operated the grill, the bar and grill with the gaming for over 15 years and nothing will be changing. And if not, that's okay, but we just wanted to put that out there.
Well, I mean, if we did that, it'd have to be a key employee condition from Ms. Shull.
Yes, and there is already a key employee condition for her and we're prepared to meet that.
Any thoughts?
So we'd remove the provision for the SRO and we'd then have the key employee condition. Okay, and say again, the key employee, who is that?
Her name is Shauna Sull, and she has worked there for more than 15 years.
Okay.
It's pending.
Let's see. I'd like to see her background before we do that. So we'll make it contingent upon successful licensure or finding suitability of Ms. Shull, something like that. A crafted condition. Chief.
How would that work though?
Well, I think the way it could work would be condition can stay on now, and then when the key employee comes onto the agenda, there can also be an application to remove that condition at that time.
Okay.
When is the key employee slated to go on the agenda?
Sure, do we know?
Not yet,
So in the meantime, you'd have to have an SRO
until she's approved.
until she's approved. That's something you guys are looking for.
Chair, if we have a key employee application on a future agenda, the license of this entity would not be before the board. So the
That was my
entity
concern.
would have to submit a separate application to add, remove, modify conditions.
Right. So back to my original request. Is there any way to craft a motion that would?
You could add another sentence that says that the chair may administratively remove this condition.
Okay.
Actually, Julie just pointed out that the condition becomes moot after a year anyway. So depending on when the key employee gets on, this condition is a temporary one.
Mr. Chair, just conferred with my client and we're thinking it might be easier just to keep the slot route operator conditioner on so we don't delay the licensure.
Okay. All right. Let's do that. All right. Let's open it up for questions. So Provo, Utah, and Idaho Falls, and now Las Vegas. Welcome to Las Vegas.
Thanks for having us.
All right, you want to make an appearance? Please state your name for the record.
Yeah, Jonathan Lund, born and raised in Richfield, Utah. I'm a super nice guy, if that helps out at all. Been an entrepreneur. I started my first company when I was 15 years old. Also, for the record, I have a great, wonderful wife. I heard a guy on the TV say that. Thought that helped. But anyways, got 5 little kids under the age of 10. I'm in construction. I build homes. We do lots of millions of dollars in construction every year. We are expanding, have multiple different LLCs, different companies, different things. This one fit the bill, and we're really excited to be hopefully part of the Nevada Gaming, and we're excited to be here. Thank you for having us, and here for any questions you have for me.
Why the segue to gaming?
We looking for different business opportunities and ventures, and we found this RV park that we really were interested in, and it came with gaming. And so at that point, we love the idea, right? And want to keep the establishment the way that it was, and it's been for a lot of years for the local residents that come and use it, and just trying to make it better and be a good part of the community.
How do you guys know each other?
Just do other business deals. We do land development stuff, and I mean, just friends, go camping together and know each other for quite a while.
Is Springville and Lehigh next to each other? Or are they?
No,
Sorry, am I looking at the wrong one? Or is that
potentially?
Which one who's from Springville? Who lived in Springville?
I lived in Springville for a time. Yeah, I don't live there
that
now.
was you. Okay.
Yep. Yeah, we live quite a ways away from each other now, but still spend quite a bit of time together.
Talk about your experience in the healthcare.
That's Travis. I'm the construction guy.
Okay, well, talk about your experience in construction.
Yeah, so I build multi-family housing. I build a couple hundred units a year. Actually have a background in Las Vegas with different low-income housing that I've been a part of. Build a lot of custom homes as well. Develop land. I'm big into farming, cattle ranching. Have 1,000 head of mother cows and raising my kids to ride horses and be cowboys. And just work hard.
1,000 head of cow.
Yeah.
Where is this?
I have a couple different ranches. I have one in Oregon, in Utah, and southern Arizona.
Wow. Was your family in that before?
No, I just started. My dad was a truck driver, and
hauling cattle.
No, actually hauled cheese. So close. Hauled cheese.
Byproducts.
Yeah, exactly. I'm trying to create the cheese for other guys to haul.
Nice.
Very interesting.
Thank you.
Yeah, this is an interesting application. It's always interesting to see the background of people who come into this space. You've heard the discussion prior to this, I assume?
Let's say it again.
This is a difficult space to operate in. There are strict rules.
Oh yeah,
Understand
we've
that, right?
learned it for sure. Just in this process, it's been fun. I mean, I love new processes, but the phone calls that I got from the agents, they were all super nice. But I was like, oh, what are you asking? No, kind of. It was nice. It was a good process, but I understand the strictness of it, and we'll take that into account and do the best we can for sure.
All right. Does your partner want to make an appearance?
Sure. You have any questions?
State your name for the
I'll
record.
make it quick and easy. What do you got?
Please state your name.
Travis Shumway.
Okay. And you're Lehigh or Springville?
I'm in Blanding, Utah.
Oh, okay. Yeah. Blanding.
Yeah.
Right. Any questions for?
Yeah, can you talk about your experience in healthcare?
So when I was in college, I set up a home healthcare company. In the last 10 years, we've grown it, 12 years now. Went from kind of a business in a basement to now we have over roughly 2,000 employees, and we're in 30 states across the country.
So home healthcare.
Amazing. Well done.
Yeah.
Thank you.
You lived in Romania. You did a mission there.
Yeah.
You speak Romanian?
Yeah.
Okay, Bună ziua. That's about all.
Oh, ce faci?
You speak Italian as well then, or a little bit?
No, ce faci is Romanian.
No, but do you also speak, because they're both
They're
Latin
similar. I
based,
can
they're
understand
similar,
a
yeah.
little bit. It's La Revedere and La Revedeci. Those are
Okay.
the similarities.
Couple of keywords.
Okay.
I can understand it, but
Interesting background, guys. Both spotless. I didn't have any questions or concerns.
Yeah.
thank you.
Well, thank you. I'd ask for a motion.
I move to recommend approval of restricted item number 3 is read into the record by Secretary Bell pursuant to the following conditions. Prior to the issuance of the state gaming license, the licensee shall enter into a service contract with a licensed slot route operator. The term of the contract shall be for at least a 1-year period of time. The licensee shall demonstrate successful completion of a regulatory compliance seminar for restricted licensees, which is deemed acceptable to the Nevada Gaming Control Board chair or the chair's designee within 90 days of the issuance of the state gaming license. This condition may be administratively extended by the Nevada Gaming Control Board chair or the chair's designee. A key employee application must be filed within 60 days of issuance of the state gaming license and thereafter be refiled within 60 days of any change in the person occupying that position.
Okay, Madam Secretary.
Member Katsouros?
Aye.
Member Watkins?
Aye.
Chair Gibson?
Aye. All right, thank you very much.
Thanks,
Good
guys.
to see you. Good to see you, Ms. Cannon. All right, let's go on to number 4.
Restricted number 4 is the application of Timbers LLC doing business as Timber Saloon for restricted gaming license and the applications of Michael Van Overbeek and Cheryl Webster for licensure as a member and manager. I believe they are in Carson City.
Okay. Thank you and welcome.
Good afternoon, Mr. Chair. Chris McKenzie, the Alice McKenzie Law Firm for the record. Here on behalf of the Timbers LLC, and I have with me Ms. Cheryl Webster, and Mr. Van Overbeek. You might be familiar with this application. It's taken a long and winding road. It started as a transfer application early last year. We had the unfortunate passing of Ms. Betty Larson, who was Cheryl's mom and Michael's wife, last fall. And we were before you in January forgive me if I'm repeating things that you already know. But we were before you.
No, I appreciate the record. Please go ahead.
Yeah, we were before you in January for a temporary licensure for Mr. Van Overbeek as special administrator. During this process, we were proceeding with the application to transfer throughout, and at some point rather recently it's recommended that this be amended to be a new licensure. So that's a new licensure. This might look very familiar to you with the people in front of you. It's been a long, winding process, a very unique process, and I'm sure you're familiar with some of the history of why we're here. That being said, we have them, both of them here for any questions. We did interview Mr. Van Overbeek in January. We spoke to you, but they're here for any questions you might have, or from me. Thank you.
Okay. Thank you. I appreciate that opening statement. I think we're as familiar with this restricted application as any I've seen my time on the board. So you know it well. I'll just open the floor for questions.
I don't have any questions. I'm very familiar with this item as well.
Same for me. Thank you very much for being here today.
Yeah, thank you for appearing. With that, I ask for a motion.
I move to recommend approval of restricted item number 4 is read into the record by Secretary Bell pursuant to the condition that if an equity owner is no longer functioning as a key employee for this location, a key employee application must be filed within 60 days and thereafter be refiled within 60 days of any change in the person occupying that position.
All right, Madam Secretary.
Member Katsouros?
Aye.
Member Watkins?
Aye.
Chair Gibson?
Aye. Thank you for appearing.
Thank you very much, Mr. Chair, members of the board, and Madam Secretary. We just want to say thanks to Mr. Brandon Peters for his assistance in the investigative process, and Mr. Mark Robertson in the application process. I know they've been very patient throughout, so we appreciate it. So thank you.
Thank you.
Thank you.
Thank you. Thank you both. Good luck to you. Okay, let's go to number 9.
Restricted number 9 is the application of TLC Gaming, Inc. for a transfer of interest.
Okay. Welcome.
Good afternoon. Chair Gibson, Member Katsouros, Member Watkins, Madam Secretary. For the record, my name is Alicia Ashcroft. I'm with the law firm Armstrong Teasdale here on behalf of TLC Gaming. With me is Mr. Terry Cottle. If you recall this item, which is for a transfer of interest of 5% from Tim Logger to Mr. Cottle, who's already the existing 95% owner, came before you in January of this year. And at that time, unrelated to the transfer, There were some matters that needed to be addressed with respect to a licensed key employee requirement. The board had some concerns at that time, referred this matter back to staff. My client and I worked very diligently to address those concerns and come back to you with those resolutions. We hope that we've done so. I'd like to take this opportunity to thank Investigator Brandon Peters for his patience in working with us to address those matters. We're happy to answer any questions, and we hope that you will recommend approval. Thank you so much.
Thank you. Mr. Cotto, welcome.
Thank you. Good afternoon, Mr. Chairman and board members.
And thank you for addressing the compliance issues, compliance concerns that we had. Really appreciate it. I know that you've been in the industry for many years and you know your way around. So
We are very strong believers in internal controls and the entire process. And when it was suggested that we had a way that we could actually strengthen our controls even more, that was fine. We had no problem with that. One more layer of security will never hurt.
great. Thank you very much.
So thank you.
Any questions, colleagues?
Yes, can you affirmatively address the changes that you have made to the compliance plan or the compliance process, given the oversight from last time that we were concerned about?
Sure. Thank you, Member Watkins. As I understood it, and I apologize, I was not at that meeting in January. So I've read the transcript, I've watched the meeting. And as I understood, the board's primary concern was that there be a person specifically designated to ensure that that licensed key employee condition was met. And so I think there was some concern that although there is rather a compliance committee, that perhaps there's too many cooks in the kitchen. So who's the person? And so if you'll look at kind of the overview of the way they've structured it, it is the gaming controller's responsibility to ensure that that application is on file at all times with the board. And then oversight over that person is the corporate controller that ensures that that condition is met as well. So I think we've addressed that. Your question was really, who's the person that knows what the condition is, understands the requirement, and ensures its compliance? And I think we've done that.
Yeah, I think that's correct. That was one of my concerns, but also as it relates to process, I think there was an email that was sent out and that was supposed to take care of.
I think it was a misunderstanding about a letter that was sent from then Gaming Council to then Chair Nylander. I think.
No, I mean with regard to the process to assure that the application was filed and that process somehow broke down. And so now I understand there's another layer of the process where there's a meeting where it's ensured that is that not correct?
But yes, and more importantly, that they understand that it doesn't show up on the report where they thought it did. Okay. That the filing of the key employee application with the board meets the condition, which may be processed at that time or later, but that their records need to reflect that it has in fact been submitted and the application requirement met, as opposed to thinking that that is something that's going to be on the, say, NGC 9 report. Okay. And understanding that process. And I think that we've clarified that and have that internal understanding, again, at the gaming controller level and also at the corporate controller level that oversees that position. So thank you.
Thank you.
Yeah. Okay. Any further questions? All right, that I would entertain a motion, ask for one.
I move to recommend approval of restricted item number 9 as read into the record by Secretary Bell.
Madam Secretary.
Member Katsaros?
Aye.
Member Watkins?
Aye.
Chair Gibson?
Aye. Thank you very much.
Thank you
Mr.
so much.
Cotto.
Thank you.
Good afternoon.
Thank you for your time.
Okay, that was number 9. All right, so Madam Secretary, that brings us, let's see here, we have a casino player dispute appeal.
Yes, you have one casino player dispute appeal. The hearing examiner recommends the agent's decision denying payment be affirmed. That item is Elam Oz versus Excalibur Hotel and Casino.
All right. Is there any discussion?
No, I agree with the hearing examiner's findings. That's it.
I've had an opportunity to review the record and I support the hearing examiner's findings.
As do I. Okay. With that, I would ask for a motion.
I move to approve the hearing examiner's recommendation that the agent's decision denying payment of $8,524.23 be affirmed.
All right, Madam Secretary.
Member Katsouros?
Aye.
Member Watkins?
Aye.
Chair Gibson?
Aye. Okay. Madam Secretary, this brings us to our last agenda item, public comment.
This item is placed on the agenda to give the public an opportunity to comment on gaming-related matters.
All right, anyone wishing to make a public comment, please step forward. Podium, is there anyone in Carson City? I see no one. All right, anyone in Las Vegas? I see no one. All right, with that, that concludes our Gaming Control Board meeting for the month of May. We are adjourned. Thank you.
There will be a 5-minute break between the end of the board meeting and the beginning of the workshop.
You're right.
Hi, how are you? Are you here for the workshop?
Oh, that's what I remember.
I thought you might want to listen in on all the restricted and unrestricted items today.
because those chairs are so comfy.
Are they not? I see it. I don't want to tell you which attorneys I see sleeping, so they look pretty comfortable. There's a couple of. There's a couple of them. I'm like, they can sleep anywhere.
How was
Niga? Yeah, it was good. I sent it.
Niga now?
They did change it to I apologies. So I got back on Friday. So I
All right, let's come to order, please. It's time and place for the workshop before the board for possible action regarding proposed amendments to Nevada Gaming Commission Regulations 522 and 26C regarding, without limitation, information technology service providers, race books and sports pools, off-track pari-mutuel horse race account wagering systems, call center systems, information service license and application requirements, and a book's responsibility for services provided by information service. Welcome, Madam Secretary. This workshop has been noticed in accordance with the open meeting law.
Yes, it has.
Okay, let's start with public comment then.
This item is placed on the agenda to give the public an opportunity to comment on gaming-related matters.
All right, are there any comments at this point? Carson City? I see none. Las Vegas, you're not here for comment. City Exams. All right, and we have some that have been sent in, right? And they've been posted.
Any regulation comments that we have received have been have been posted on our website and are also available by the door.
All right, wonderful. Thank you very much. Welcome, Senior Exams.
Thank you, Mr. Chairman, board members, Madam Secretary. For the record, Mike Somps with the Attorney General's office. And as was read into the record, today's workshop is to consider proposed regulation amendments to Regulations 5, 22, and 26C. These changes have been developed with the help of Chiefs Barbie, Colvin, and Taylor, and were initiated by you, Mr. Chairman. So the changes to Regs 5 are contained in a March 30th, 2022 draft, and the changes to Regs 22 and 26C are contained in April 18th, 2022 drafts. And hopefully the board members all have copies of those drafts. I'll also indicate for the record that drafts were made available to the public by posting them on the board's website back on April 20th. Very generally, these changes in these drafts are intended to make some changes to the definitions of information technology service provider, which I'll refer to as IT service provider, just to shorten it up a bit, account wagering system and call center system, and to create some additional structure concerning information services. Obviously, what I'll do is I'll start with the proposed changes to Reg 5.240, where we have a change to the definition of IT service provider. The changes to this definition are really refinements designed to remove ambiguity as to the activities of an IT service provider, what they're allowed to engage in, and to address concerns that the current definition is being interpreted a bit more broadly than what was intended. And the intent of this type of service provider is to capture for registration those that support the IT infrastructure of games and associated equipment. That would be the hardware and the network services. It wasn't intended by the board to capture a service provider that's making decisions regarding or related to the applications of games and associated equipment. That would be something that in the board is historically viewed as appropriate for the operator to engage in. So that's what the purpose behind these changes are. Next, going on to the changes in Reg 22.010 to the definition of account wagering system. The primary goal here was to remove the located in Nevada requirement for the account wagering system. And this change is a recognition now of the multi-jurisdictional nature of sports pool operations and is consistent with the recent hosting center and cloud computing regulations that were recently adopted by the commission, and that allows hosting centers and cloud computing services service providers to be located outside of Nevada. And the other goal of these changes is really just to modernize the definition to reflect that the system is the hardware and the technology, not necessarily the individuals who might touch the system. There's also a change to the definition of call center system where the located in Nevada requirement is similarly removed. Next, going on to the proposed language in 22.025, that particular section is titled Information Service License and Application Requirements. As you know, the licensed information services have been around for a number of years, but there has not been a regulation that addresses them. And so this is very generally what this particular section is going to do. I thought it might be helpful though, before I go through the language, to give you a little background on why information services are required to be licensed. And going back to the legislative history, back in, I believe it was 1997, when the statutory definition was adopted, you can see some testimony there as to the purpose behind it. And the purpose was to ensure that those assisting licensees by providing odds, lines, point spreads, et cetera, are reputable. That's because of how critical those activities are to the sports pool operation. There was a concern that if those persons who provide such services have questionable reputation or criminal backgrounds, it could be damaging to Nevada and the gaming industry. So with that background, we have the language in 22.025 that does some basic things by setting forth the licensing requirements for an information service. It's very similar to, for example, 22.020 for race books and sports pools. So it reinforces that a license is required to operate an information service. And it also makes clear that information service licenses are processed and determined just like unrestricted licenses. In addition, this section creates a framework for what is expected from an information service. And that is that there's an expectation that a licensed information service is not just a pass-through for some other person who might be avoiding licensure as an information service. And so I think currently there is a question, at least internally, as to whether that's acceptable. And so with this language, we're trying to create more of a defined framework that would not allow for that shell information service to be set up where it's just a pass-through from someone else. Going on to a new section 22.215, again, some new language. This addresses the relationship between a licensed book and its use of a licensed information service. The services provided by an information service, as you know, are becoming more extensive, they're becoming more sophisticated, and the line seems to be blurring between a book and an information service. So for example, a book may use an information service where the lines, point spreads, and odds are provided by the information service, and they're automatically used by the book and passed on to patrons without any affirmative action or oversight on the part of the book. So with this language, it's recognizing the significant role that information services are playing, but a book must be involved in making decisions and exercising some ultimate oversight and control of the services provided by the information service. And it does that by implementing implementing procedures where the book actually reviews and approves the information that is provided and has the authority to override any information that's provided. The language also recognizes the fast-paced nature of in-play wagering now, and that there may be insufficient time for a book to review and approve information provided by an information service before it's pushed out to the patrons. So for those circumstances, the language creates an expectation that the book reviews and approves the parameters for the information service to follow. So for example, the book would say, we're willing to accept wagers on all these different types of events. We're willing to accept wagers on those events with these defined betting limits. So it sets forth the parameters within which the book or within which the information service is expected to operate. And if the information service wants to go outside of those parameters, it would have to get approval from the book to do that. Finally, moving on to 26C.010, again, we have the definitions of account wagering system and call center system that are changed to match the changes to the terms in 22.010. And so that's the summary of all the changes. I suspect you'll have some questions, and I'll do my best to answer them. I may turn to my experts over here, Chief Colvin and Chief Barbie, and Deputy Chief Marusic is here as well. And so we'll see if you have any questions.
Would you, if you can, I didn't prepare you for this, but could you speak to the sort of predicate instances that have, the fall of PASPA and how that's led to our consideration of these potential reg changes?
I think as common knowledge now with the fall of PASPA, we have this proliferation of sports wagering popping up in various jurisdictions across the United States. So I think that given that there are operators now operating in multiple jurisdictions and they're trying to consolidate operations to the extent possible, while following obviously the different laws in the various jurisdictions.
Okay, thank you. All right. Chief Barbie, Chief Colvin, do you have any comments you'd like to add at the outset?
I don't have anything at this time, Mr. Chair.
All right.
Neither do I.
Okay. All right, well, let's open it up for comment. Please, please, I'm sorry, Senior Exec Soms or Watkins has a
In 5.240 service providers, to be person, is it limited to a person or does it also extend to?
I'd refer you to the statutory definition of person, which would include entities.
So incorporated by reference. All right. There was another area of concern that I had, but you said you have draft dated April something? So I don't know.
Yeah, so the changes to regs 22 and 26C are in draft dated April 18th. And I believe, well, I don't know what you have in front of you, but I think that's what should have been passed out to you.
Oh, okay. Find it real quick.
And Reg 5 is March 30th, right?
That's right.
Okay. Because there was somewhere where the word analysis was used in the singular term. Okay, it's 22.025 B.
Okay.
So it says that the person will generate its sports-related facts, opinions, and analysis internally or obtain from multiple unaffiliated sources. And this is acceptable to me, but the two previous items are in the plural, and I just thought we should put analysis in the plural too, unless your draft says something different.
I think that's fine. I can make that change in a future draft.
Okay, sorry, I didn't notice that before. I didn't entirely read it today. And those are all the comments.
Member Katsaros, would you like to?
Yeah, I do have lots of questions actually on each point by point, but probably best to hear public comment first, or, I mean, I'm not sure you want to. I did review the public comments already, and since they're here, I think maybe it'd be good to hear from them as well.
Okay, please. Let's go ahead and hear from the representatives of industry. Mr. Scheer, welcome.
Thank you, Mr. Chairman. Dr. Watkins, Board Member Katsaros, Madam Secretary, for the record, Scott Scheer of Brownstein Hyatt Farber Schreck, hearing today on behalf of BetMGM. These are important issues, and I appreciate bringing these forward for discussion, because I do think that with the fall of PASPA, with the spread of sports betting all over the country, it's important to make sure that we, to some extent, modernize our approach to sports betting here, because it has changed dramatically in the last several years. There was a decision made historically that the definition of information service would only apply to those who do business directly with the licensee, which is why you have this pass-through situation. And we understand that there is an issue, perhaps, or a concern to look at whose information is being passed through and are they reputable, and definitely understand and appreciate that. I do want to make the point, however, though, that because of that historical definition, and that primarily came through the investigations division, as those in the industry dealt with who needed to file applications to be licensed, we bear in mind that there are a number of operators now relying upon some of these pass-through feeds. And if there's going to be a new requirement for those companies that are passing through their feeds to be licensed, or as we've suggested in our comments, perhaps registered, that in fact there'd be a sufficient time for them to do that and not have to just automatically have operators cut off their access to those feeds they've been relying upon. Also wanted to, as we mentioned in our comments, discuss the IT service provider. And we understand now from Senior Dag Somp's comments that the objective or the intent is to prevent an IT service provider from being involved in management activities. And I guess the concern that I would raise, and I think it's important, like I said, these are important issues, and I think we need to carefully consider the language that is being used in them, because if you eliminate management, arguably by reading the statute and the regulations together, that means there is no regulation of those who are performing management, unless you were to consider them a key employee, which would put us right back in the same position, that they would have to be listed as a key employee. The board could call them forward, but they can call forward service provider now. So you have exactly the same regulatory authority over them. As examples, we previously in Reg 5.240 had a geo location service provider. We had a marketing affiliate. Both were service providers that had to be registered in one form or another. Those were deleted from the regulation, and the state of affairs today is that they do not have to be registered, and there is no specific regulation over them. So I think by striking management here, I don't know that you would actually accomplish what it is that was expressed as the intent. And I'll go one step further, nor do we think you should necessarily preclude management. Now, if you want to do it in a different way, or again, if they were to be key employees, that may be one way to do it. We have precedents where entities have been licensed as key employees, but we think that there has to be an opportunity for operators to take advantage of the expertise of those out there in the market, to provide them essentially management advice and consulting with regard to the operation of racebooks and sports pools, understanding that ultimately the licensed operator is responsible for the decisions that are made and have to be responsible for that. So we do think that's important, that they have that opportunity to have that sort of management advice and consulting available to them. And as this industry continues to get more automated, more fast-paced, as we continue to compete with those who are offering sports betting in other states in the U.S. right now, we do think it's important that our licensees have the tools they need to keep up. And that really was the point of the regulation that allowed for service provider, the statute that allowed for service providers in the first place, was to allow licensees to have more access to the expertise they need in a more fast-paced world, more automated technical world. And so I think we welcome the discussion, but think that, and welcome appropriate regulation, but think that there needs to be a way where the board is comfortable that those entities that are involved in those activities are properly regulated, but that licensees still have access to that expertise. So,
Mr. Chair, I appreciate your comments. We're not going to resolve all of this today. This is, I think, an overture that deals with a complex set of issues that we've encountered over the past year and a half. I just invite you and everyone here and everyone listening to think through, where do we draw the line with regard to licensing? It's really the issue for us. So, information technology service provider, as opposed to, licensee operator racing sports book or permission, pool. That's really sort of the question for us, is where do we demarcate that line? So if you can help us with that language or submit language for consideration, we'd appreciate that. I would.
And one of the things we've suggested, for example, on the information service on the pass-throughs, is that perhaps they be registered. That again, the statute does allow the commission great latitude to decide who is a service provider. And the regulation allows, and statute regulation both allow, anyone who's registered as a service provider, if you feel they should be called forward for a full finding of suitability, you have the ability to do that. So that brings them into the system without creating too significant a burden on them. Maybe to be licensed in other jurisdictions in the U.S., but to be honest, other than, there are a couple of other jurisdictions that have as in-depth a licensing process as Nevada has for data feeds or data providers, but most of them are a much less intrusive and expensive process and time-consuming process. So again, the registration would be a way to allow them to be in the system under your jurisdiction, to have you have some information about them. But, and then if you see a need to still call them forward for that full process, should it be necessary. So allow the industry to take advantage of those who are offering those services without a process that will chase them away and make Nevada or put Nevada out on an island.
Can I ask you a question on what you mentioned earlier in the historical treatment that we've had with information services?
Yes.
Is it your view that in fact that's how it was supposed to be treated? Because the way I read the language, it needs to provide and sell. The combination thereof creates a gap, right? Because you can provide it for free in this market and get paid elsewhere in another market. You're saying that was the line for us before, which is you have to have those two elements to actually be captured. And in fact, that was the intent. Because I look at it going, was that really the intent?
I don't know what the intent of
Okay,
the
I
original
just wanted to make
statute
sure
was.
I understood
Yeah,
what
I'm
you
not
were
sure.
thinking.
Sitting up here?
Yeah, right.
I was a few years later when some of the interpretation was done. I was actually sitting up there, but this was passed in '97 before I became a member of the board, and I don't know what the intent was in '97 when the legislature passed it, but I do know that there were discussions afterwards, and the provide and sell to the licensee, to the
Right.
licensed.
It's like very
school.
strictly or very tightly constructed. There's an and, oh, there's a comma there, and so I was assuming it was an interpretation made thereafter as opposed to at that moment in time. By the way, we didn't live in the world that we live in now, and I completely agree with a lot of that sentiment. I do have questions on each one of these points, and like Chair Gibson said, I don't know that we need to get through all of this today, frankly, because I think there's a lot here. As minimally as the changes are, the changes, the sort of result are big. So on the first point though, on the 5.240, I wasn't sure that I was necessarily tracking exactly, or at least I wasn't in alignment, because the mere scratching or deleting of management, I don't think the intent was to say that it was permissive. Therefore, I think in fact use of the word management all tends to lend itself to allow a third party to come in and actually operate without actually having a license.
That is a concern, actually.
So with that, okay, so if that's the concern where I'm going, yeah, because I think it's been stretched. These things continue to get stretched. As soon as PASPA fell, things really got stretched. We have regs and statutes in place now that have not really been touched. And they were written at a time when everything was written for a pre-PASPA world, Wire Act included, which means it needs to operate and function in this manner in Nevada with the cloud computing regulation that was just ratified. That really helps to change the world. And I think it needs to change. But I'm trying to understand some of the different moving parts with these different things. Okay, so with that understanding, then merely striking. Okay.
Yeah, may I say this about? Well, I'm sorry.
I was going to say, with that understanding, merely striking management, if the intent is merely to make sure we're not allowing too much involvement from a party who's not licensed, I wholly agree with that sentiment. If it needs to be tweaked, leave it to the lawyers to write up that language more tightly.
I guess what I'm suggesting is that there are a number of different contractors that licensees use now who are not licensed by the commission or registered by the board. CPA firms, yes, obviously they're licensed by the CPA board, but obviously perform important services, whether it's internal audit or whether it's their audited financial statements. You've got companies that do KYC or assist with KYC, security companies, companies that do due diligence, are involved in doing due diligence for companies. So there's a lot of contractors a licensee can use that are not regulated by the board commission, maybe regulated by other state agencies, but they're not regulated by the board commission. So, and then if you read regulation 5.240, the only prohibition in there is it says that a licensee cannot use a service provider who's not registered, essentially. So if they don't fall within the definition of service provider, then they fall back to the general rule that applies to the accounting firms and its security firms and everybody else, that they're then not required to be registered.
If a third party was coming in and managing this technology, though, they would therefore then be supporting it as well and be required to be registered. So I don't think they could do that without getting registered.
Yeah, I mean, again, if they were performing those services that are still going to be listed, yes, if they're supporting the technology, they would have to be registered as a service provider.
Supporting's here, managing's here. So if you're doing this, you're already doing that.
But yeah, if you're providing management services, I guess generally, you might be a key employee because the definition of gaming employee includes contract employees.
Okay.
So you might be a key employee and again have to be listed in a key employee report and then subject to being called forward, but there wouldn't be a specific registration process necessarily. Depending on the exact relationship, is there a percentage of revenue being paid or something like that? But so I guess the point I'm trying to make is we need to be careful with this language because the prohibition is on using a service provider who's not registered. And so if they're not a service provider, then the prohibition goes away. So in changing the definitions, we have to be careful. What is the definition? Who are we trying to regulate?
We do have the language, or the term does not include the performance of any service, action, transaction, or operation that would otherwise require a gaming license or other registration pursuant to these. Well, understood.
So I guess my point is simply we need to be careful with the language because the way the regulation is set up, the prohibition is on using a service provider who's not registered.
Agreed.
And if they're not a service provider, then there's no regulation of.
And they're not captured, is what you're saying.
Yes.
Yeah. That's not the intent.
Right.
Okay.
Which is what I took from Mr. Som's comments. And I assumed frankly that was the case.
Okay.
So, sure, do you have anything further you'd like to? Please go ahead.
I think everything else that I have to say is captured in my written comments. So, happy to leave it there because I understand from your comments that this is the beginning of the process, not the end of the process. Yeah. So happy to work with Mr. Somps and others and the chiefs going forward to try and make sure that, again, our hope is our belief is these issues do need to be addressed, and our hope is that we can strike the appropriate balance between making sure the board has the regulatory authority they need and at the same time allowing the industry to take advantage of the expertise that's out there for them to stay competitive in this rapidly changing environment.
Agreed, as well as the technology, right? To avail themselves of that. Yeah.
So if I can ask your opinion, sure, I've known you for a long time, so I'd like to get you on the record here and ask your thoughts. So the account wagering system, I certainly don't want to discourage people or entities placing their account wagering systems within Nevada. My concern though is I don't want to create a situation where everyone is retrenching. So we do it, we require it to be here, and every other state's doing the same thing. That's a concern for me. You have any thoughts on how that might play out, what the right way to approach it is?
I have some thoughts. The Wire Act, of course, prohibits interstate sports wagering.
Right.
So it is requiring at least the server that accepts the wagers to be within the jurisdiction where the wager is placed. So at the very least, you're going to have some kind of system, in Nevada that is where the wagers are being accepted. Now, if once the wager is accepted, information is transmitted to a system somewhere else for processing that data and providing analysis of that data, or risk management, so that you can assess your risk if you're a national company, in other jurisdictions as well, and maybe moving lines in other states based on the amount of play you've got from a total national perspective. Certainly those are probably going to end up being in the cloud with the new cloud computing service provider. But the primary servers themselves for accepting the wagers and processing the patron accounts or crediting and debiting the patron accounts are going to need to be within the state where those wagers are accepted because of the Wire Act.
All right. So, just of necessity, we'll have at least a substantial part of the account wagering system.
Yes.
You have any thoughts on? I'm also concerned. As regional or national entities, such as the one that you represent, as they attempt to construct their systems, and they're coast to coast almost, except in California, the call centers. So I do believe that if there was a Nevada specific issue, that someone who was located in Nevada that had training in Nevada law and so on might be able to resolve it better. That makes sense to me. But tell me, as entities such as yours attempt to consolidate, what are your thoughts on whether or not that's a move that we should make in the state? That is requiring the call centers to be here in Nevada, or if we should allow for something different?
By call centers, do you mean customer service to
Yes.
try and resolve issues,
Yeah.
not to
Right.
accept wagers?
Right.
Okay, yeah, so, yeah, in terms of the customer service, I think it really can be done better on a consolidated basis. And again, you're right that you need to have people that are knowledgeable in the particular jurisdictions. I think that staffing is typically done to a large extent by time zone, so that the time zones that are most likely to be busy that time of day are going to have people that are knowledgeable in those areas. But there certainly may be times if someone calls at an off time where the people who are knowledgeable in that particular jurisdiction may not be on, and it's going to be incumbent upon the licensees then to get the information and get back to the customer and get the issue resolved by the people who are knowledgeable in it and then get back to the customer. But I don't know that that's going to change if the call center is here locally, because you're still going to have employees who may be newer and not as well trained or not as knowledgeable, who may be on in the middle of the night and receive a call, and they're going to have to take the information and assure the customer that they'll get back to them and get it resolved by people who have the appropriate knowledge.
What I'd say is we really are trying to strike the right balance. I mean, at least people who are working with me. And so none of this is set in stone yet, as you can tell. Do you have any further comments? What about the changes to 22025? Do you have any comments on those?
Yeah, I mean, primarily our comment there is sort of what is unaffiliated. How do we make sure that it's not just a pass through? I think there's a lot that needs to be done in fleshing that out in terms of the definitions and understanding really what impact it's going to have. What's a unique product? I mean, every book, I think, and every information service, they start with, okay, Tom Brady retired from Tampa Bay. Suddenly that's going to change the odds of, futures odds for Tampa Bay to win the Super Bowl next year. Then he unretires. That's going to change the odds again. But that information, everybody has that same information, and working from that same information, then create their numbers. And then the other thing they do then is look at everybody else's numbers. And okay, are we way out on our own here? Is there something we're missing? And so they compare their numbers to everyone else's, and they may not be identical, but they're going to factor in other companies' numbers into their thinking as to whether there may be maybe they're out in left field on a particular wagering proposition. So and ends up making it hard to say what exactly is unique. And so the use of unique, the use of the word unaffiliated, I think we need to flesh that out. As we've suggested, many of the companies are, even among the book operators, they've got multiple layers in their corporate hierarchies. And sometimes somebody who's a key employee, making decisions for the book, might not actually be employed by the licensee. They might be employed by an affiliated company or an intermediary company. So our thought is that if you're an affiliated company, that ought to be considered internal. So when it says that the analysis has to be developed internally, that ought to be internal if it's an affiliated company. And we ought to be focusing more here on the information services that are not affiliated with existing licensees. Because again, you've got jurisdiction over the affiliates anyway.
I'd like to go back to Reg 22010. So the definition there, you mentioned in your comments that you agreed with the deletion of everything that's in there. At the end of it, I'd like to know why this would be good for Nevada, for us to remove and delete all these provisions that were put in here pre-PASPA. They were obviously thought through for a reason, why we'd put all the components, list out a few of them. And then I think it says at a minimum, shall include but not limited, I can't recall, but it was shall include but not limited, system operator, databases, system monitoring, writers, patron service representatives. That would not have been required necessarily under the wire, actually would not have been required under the Wire Act for patron service necessarily to be in Nevada to help with customers. Writers would have been system monitoring equipment, probably not. Tournament databases, probably not either. System operator. Why would it be good to remove all of these things when the commission went to some length to put that in there? Technology factor, human factor as well.
Yeah, I think the human factor has actually changed. Patron service representative, because the Wire Act not only prohibits placing a wager across state lines. It prohibits the transmission of information assisting in the placement of a better wager. So if you're right, if someone was calling to inquire about how come my wager was how come I lost, that wouldn't be the Wire Act because the wager's already been placed, or wouldn't be a violation of the Wire Act. But if they're calling to say, I'm trying to place a wager on this, and I'm having trouble with the app,
Different
that-
story.
Yeah, that would be prohibited by the Wire Act if it were transmitted to a jurisdiction where it's not legal, where sports betting's not legal.
But they went to some lengths to say it's not just that, it's everything. They need to be in Nevada. Why, to simply remove it all. Why is that good for Nevada?
Yeah, I think at the time Nevada was, well, why is it good for Nevada? I think at the time Nevada was the only state in the United States where at least full single event sports wagering was permitted in the United States. Now, I guess the question is it good for Nevada? Nevada is not the largest market in the U.S. anymore for sports betting. I mean, it is for many other things, but not for sports betting. And the fact is that if companies are forced to choose between, if New York and New Jersey, I think this is the point that Chair was making, and other states are saying, well, you got to be here in our state. And they're forced to choose between being in Nevada or being in New York. With the volume of business in New York right now, that's may not be a difficult decision. So I think if we want Nevada licensees to be able to take advantage of the best technology, the best minds, the best expertise, then I think it's important that we allow them that flexibility. And frankly, a lot of it is being driven out of Nevada anyway, because we have the history and the expertise here, but it's then being run through, in some cases, other states. In some cases, it's here. In many cases, it's here, but in some cases, it's certainly in other jurisdictions as well.
Well, I won't go into all the details. I agree under 22025, we need to work through that 22.215 as well. But on this point in particular, as you mentioned, we were the only state essentially that had sports wagers. Us, Delaware, Montana, I think Oregon too, but Oregon never ratified. So there's only 4 states, and yet they went to lengths to put this in there to say, because people would have naturally set up here anyway, right? As you're mentioning, we're the biggest market, and we're still one of the biggest as well. So let's not dismiss that point either.
Yeah, no,
so they would have naturally set up here nevertheless. So to go to the lengths of them put that in here and say, no, you need to do this activity here. I think there's value, the human factor in particular. The technology, I'll put that aside. The cloud-based computing regulations that we just were ratified by the commission that we recommended speaks to that sort of thing, a mindset. Great, avail yourself of that technology. The human factor on this side of it, when the commission put this in here to say, no, you're gonna need to be doing it in Nevada, my head goes, yeah, it makes sense, because it's a game. That game needs to be supervised here as well, much the same as a table game or a sports bet or a retail outlet of a sports book. Under Reg 5 requires game supervision. This is a game too. That needs to happen here as well. So I'm just trying to work through that, because when I see systems operator here, I know we had discussions before on this, I look at that, that's the trader. There's value in that trader being here and the people operating the system. We've had shortcomings simply because the individuals were not in Nevada, because they got the wrong time zone, right? I mean, that's a very simple thing. That's just one, example that scratches the surface, and there could be countless others. So just sort of my high level thoughts right now.
Appreciate it. Thank you.
So you sit on the you sit on the compliance committee for MGM RI. Is that accurate? Sure.
Yes.
So I mean, as you look at MGM RI, and they have resources around the world now. Where do you see sports wagering going? I mean, is it just going to be a U.S. specific? I mean, is a licensee that's national going to just operate within this country, or how do you see it spreading going forward?
It's already, I mean, it had spread significantly throughout Europe before it began to spread in this country. So it's already pretty widespread in Europe. Obviously, they bet on different things. Or bet the volume of betting obviously is much higher on soccer, or what they call football.
I guess one of the things I'm asking is, do you anticipate, or are there instances where, for example, from EU, we have wagering that is connected with the United States?
I don't at this point envision that there would be wagering, on among bettors or in a pool that's commingled with the EU and the US. So I guess I don't see anything happening with the Wire Act for quite some time, if ever. But I do think that ideas that are popular in the EU will be brought here and tried here. I think ideas that are popular here will be taken to and tried in the EU. I think South America is probably the next place we're going to see a lot of spread. And so I do think that it is becoming a global market. Yes, and that operators will try to take what works in one market and see if it works in another.
Thank you.
Sorry, Chief Barry, please.
Good afternoon. I'd like to go back to the 5240 definition of an IT service provider and the discussion that we've been having on that topic, and would like to clarify that an IT service provider and the discussion of sports pool and sports pool operations are two completely separate items. An IT service provider, the intent of that definition was for companies like Xerox or IBM to come in and assist an operator with the management of their IT infrastructure. That is their computing power, adding memory, configuring networks, but it wasn't intended for that IT service provider to have administrator privileges with gaming applications. And that's where we're starting to see this scope creep in the application of that current definition of an IT service provider. So we suggested some changes to clarify that the IT service provider is specifically intended to manage, or to provide support for the infrastructure itself. I would recommend that if there's an appetite to allow third parties to participate in the management of gaming applications, that a separate service provider be considered. And I apologize, Mike, I'm catching you probably flat-footed on this. We haven't necessarily had this discussion. But I wouldn't suggest we try to pigeonhole this all into an IT service provider, because that is a unique definition and it had a unique purpose.
I think that's certainly consistent with the comments we've made, which is, the commission has broad latitude to decide who's a service provider and could add other categories, just as it is deleted other categories.
Anything, do you have anything further?
I do not, Mr. Chairman.
Well, thank you very much for your submission and for your comments.
My pleasure. Thank you.
Thank you.
Are there any additional comments? Individuals who want to come up and have a conversation? Paul, come up? No? Downside to me knowing who you are. Are there any other comments from the chiefs or from staff? DC Marusich? No.
I just have one comment. We have a birthday in the audience, Mrs. Shannon Nadeau. Happy birthday, Ms. Nadeau.
Happy birthday. That's great. Watkins, do you have any comments? What are your thoughts?
Nope, I'm just sitting, listening, and taking it all in. I kind of wish Chief Barbie would have led with that. But no, I'm hearing what Chief Barbie said, and it makes a lot of sense. And I'd like to receive further comments. And I'm a very practical oriented person too, so it sounds like it would make sense to separate them out. And I would like to receive further comments from other participants or those here before us today to further examine this issue.
I agree. I mean, one of the problems with a lack of clarity, I mean, so it's not clear at this point in my mind. Well, I mean, I don't think it's clear based on what I'm seeing in the industry, how the different licensees or the different operators understand the definition of information technology service provider to apply. And so there are two approaches that a regulatory body can take. One is to file a complaint, just assume that I'm just draw its own line, even in the absence of clarity. The other is to try to clarify, right? And to, demarcate. So that's really what we're trying to do here, is to draw a line. So I'd invite comment, as Member Watkins said, from everyone listening, people in the audience, to help us to draw a line. Because I think it's far better for us to have, some demarcated, boundaries than it is for us just to strike out with complaints. So that's the goal.
For those of us who have to enforce these regulations, we appreciate that line as well.
No, I understand. I'm with you. Okay. Was there any further comment? All right, seeing none. Let's go to public comment then. I'm sorry, you had a comment? Okay, please come on up. Oh, all right. Yeah, no, please.
Hi, for the record, Jennifer Carlton, Chief Legal Officer for Sightline Payments. I did have a question about the various categories for information technology that Chief Barbie was referencing, and then also sort of next steps. So, obviously we could all make recommendations about what we think those categories might be or should be, but does it make more sense from a process standpoint? So that's where the question comes from, is where is the process? Are you going to be refining those definitions more and making another draft, and we then,
Yes.
okay, so that was what I was.
I mean, I don't think, I don't want colleagues to disagree. We can have minor disagreements, but there are some fundamental, differences. I don't want industry to misunderstand fundamentally. If we need to have new definitions or a new definition, we need to draft that. So we need to have internal discussions, and I think further discussions with industry. But I do think ultimately, if we can come to some resolution, this will help everyone.
Absolutely, couldn't agree more. So I think we'll probably hold off on our response or comments until we see that sort of refined categories. Thank you.
Thank you very much. All right, with that, I'll open a final public comment period.
This item is placed on the agenda to give the public an opportunity to comment on gaming related matters.
Okay, any public comment, please step forward and state your name and comment. See none in Carson. In Las Vegas, none. Is there any? Right. That will conclude our workshop then. Thank you very much.
Thank you.